Yes. What is the urgency? Please hand over. Yes.
My application for extension of intent.
Hand over.
On instant motion, mal.
No, he's there. He's there.
One minute, appearing in the unpaid is not. Urgency says I have applied for.
Please be a bit louder. On license.
Unlicensed. DM without assigning any.
Please hand over. Hand over. Hand over. Yes. Hand over the slip. Yes, I understand. Hand over. Yes.
On listed motion,
Listed motion at a regular heading is listed motion. Yes.
May I have your lordship's leave to mention item number 139 of the daily list for upgradation. Lord, I am an iron and steel manufacturer. Now, despite a deposit of 17 crore rupees, the respondent authority has refused to increase the contract demand of electricity. Lord, on such account, the business of the petitioner has come to a standstill. So, Lord, I is humbly praying for some precedence in this matter.
Hand over. Yes.
Let's say, may I please your lordship kindly make one matter regarding correction in the order sheet.
Yes, yes, please.
For upgradation, my lord, petitioner is a cancer patient who needs to go outside for his treatment. He applied for the passport, but authority did not issue it.
Hand over. Yes.
Sweet case study, lordship. The extreme margin, my lord, petitioner.
Yes, hand over.
My lord, may I permit?
The lordship.
No.
My lord, may I permit you to mention with regard to idea number 163. For upgradation, my lord, this is the perishable good. My lord, the fees for export, my lord, purpose.
Hand over.
Let it be appearing.
May I have your lordship's kind leave to mention item number 40.
এই অরিত্র এবার যেগুলো হচ্ছে
May I have your lordship, my lord, may I have your lordship's kind leave to mention item number 47. Mr. Sandal mentioned the matter, my lord, on Thursday. Your lordship fixed the matter today. My lord, the extreme urgent, my lord, tender regarding my lord fair price shop, my lord, the
no upgrade matters cannot be further upgraded. Sorry, no.
my lord,
No,
my lord, unless your lordship hear the matter.
Other
my lord,
matters are also equally urgent. Next.
unless I am protected, my lord, adding
No.
to the model, my lord.
No, no. Yes.
The petitioner had provided training under the directions of Poschimanchal Unnayan Porishad. My lord, after completion of the training, my lord, the Poschimanchal Unnayan Porishad is not giving the requisite certificate, completion certificate, so that the amount may be disbursed in my favor.
Wait for some time. Not
My lord,
right
the
now.
representation is
No,
also
not right now.
considered.
Yes.
My application for grant of foreign liquor country submarine is pending from.
Wait for some time, Mr. Mondol.
And my
No, not right now.
similar order, my lord, passed by
No.
your lordship, my lord.
I said no.
I am challenging the factory license issued by the incompetent authority.
এই অরিত্র মুকেশ সামনে সরো সাইড করে দাও।
I am challenging the factory.
না না
license.
ক্যালেন্ডার গাধা হয়ে যাচ্ছে এক পরে এখন ফিক্স করছি
Challenging the factory license issued by the incompetent authority. Only the factory is
issued by incompetent authority.
but he is not competent to issue the license.
Wait for some time, not right now.
But there are two disconnection matters. Disconnection matters.
Hand over. Yes.
Electricity disconnection.
Hand over, please. Yes.
My lord, I am saying leave to move on Monday, my lord. I am without electricity.
No, file it and give the number. এটা অরিত্র মান্ডে দিয়ে দিন।
That is my-
Yes, yes.
My lord, I made a to mention item number, my lord, 356 of your lordship. I mentioned this matter 3 weeks back. Your lordship, my lord,
What is the urgency?
that is, my lord, high tension wire has been erected over my land, my lord. So,
Hand over. Yes. Yes, Mr. Bose.
Kindly, my lord, to move this matter, my lord, on Monday. I am filing. Urgency is this, my lord. The government has, my lord, opened, my lord, the financial bid without any evaluation. And when I pointed out the defect, my lord, the government has called the H1 bidder. My lord, fair price shop is a promise of the government. Accordingly, my lord, notice inviting.
This is for opening of fair price shop.
Yes.
Please file it and give the number. Ask your learned
I
junior.
have 9 writ petitions to
Similar.
similar.
Yes. File all of those and give the numbers. Monday দিয়ে দিও এগুলো। সব করে। Yes.
New connection.
Old connection. No. Yeah, hand over.
Equal recruitment on 8 April, a tender process for Anima under the Anima Mukt Bharat, the hemoglobometers to be circulated. So the tender process is in violation of the tender terms as well as the financial.
Wait for some time. This is also a fair price shop.
Anima hemoglobometers.
Please wait for some time.
The difficulty is
Cannot.
that we have been writing to their representatives.
2 minutes. 50 already today. Let me dispose of this. No.
Tender matter, my lord, I am one of the L1 bidders, my lord. What is provided on this?
Tender matters, further tender matters, please wait for some time.
What is provided?
No.
that.
Hand.
This matter, petitioner intended a residential accommodation and he applied for a housing flat in an approved project of SBI. Thereafter, loan has been sanctioned and this was also. I'm also paid the refund.
Certificate.
No, my lord.
Title deeds. You want like the title?
The abandoned, I have not.
Wait for some time. Not right. No upgradation right now. Yes. Yes.
Not standing for
Yes.
upgradation, my lord, I am out of my livelihood as the liquor license has been withdrawn by making a retrospective application of an amendment.
Mr. Shwarka, I've refused one liquor license. So please come back on Monday or send somebody on Monday. Yes.
My lord, I'm mentioning for upgradation of monthly list item number 1228.
What is the urgency, please?
My lord, compassionate appointment, my lord, I'm praying for the representative.
Compassion, I don't have determination. No, I don't have determination. Yes.
My lord, I am mentioning for upgradation of 277. My lord, presentation of 5th March. My lord, the information was refused. That is the subject.
Handle. Yes. Yes.
Contract terminated 23rd February. But bank guarantee 13 crores taken out last Friday and that shall be disposed on.
Please hand over. Please hand.
May I permit you mentioning one upgradation or disconnection matter?
Yes.
Monday or Tuesday, they are going to issue a work order in a tender matter. To a bidder who did not qualify the technical
No, Mr. Manager, for the tender matters, I cannot. I have refused two.
And I follow may I
Only one fair price shop I have allowed, but others I have refused.
come back and travel your lordship on Monday then?
No question of trouble. Please come back on Monday. Today, no further. Yes.
Billing circumstance.
Yes, Dr. Shah.
Mentioning matter, which I had mentioned on the last Friday. Upon notice, I am mentioning.
What is the urgency? Just tell that.
That your lordship was pleased to pass an order for not encashing the bank guarantee amount till disposal of the matter pending before the ombudsman. Your lordship, March prior to the filing of the writ petition, bank guarantee has already been encashed. So I am praying, let this matter.
File an application, Mr. Dr. Shah. File an 2-page application and mention that. Yes.
Someone is praying for RTI report.
Hand over. Yes, give this.
Pardon?
Construction work is undertaken matter, but it is formed by there is a certificate.
Hand over. Yes. Be a bit louder, please. Can't hear you. No, absolutely can't hear you. Come to the microphone.
Without restoration, the electricity.
Hand over. Yes.
For release.
Grateful. My lord, the urgency in this matter is, my lord.
You also use the microphone. Yes.
My lord, the urgency in this matter is, my lord, there is a nursing home, my lord, and inside the nursing home, my lord, there is a liquor shop. My lord, for that reason, my lord, all the miscreants are getting inside, my lord, and misbehaving with all.
Hand over. Yes.
Okay.
The gentleman behind you, because I'll finish this mentioning business now. Yes. No, wait for some time. Yes. Hand over. Hand over. Yes.
Lordship, new connection matter, 2 matters for new electricity connection.
Yes.
Your lordship, this is a contempt matter.
Contempt hand over. Yes.
The refund of security deposit.
Wait for some time. Wait for some time. Yes.
Subject to your lordship pleasure, I'm mentioning item number 316 of monthly combined.
What is the urgency, please?
Sir, the urgency, the matter of inaction on the part of representative authority is concerned.
Pardon? Inaction?
The matter of inaction on the part of the respondent authority.
No, not right now, ma'am. Yes.
Number 36, I am applying for the private response.
No further upgradation.
I will pay for accommodation for
When it is called on, if it is called on, Mr. Lady.
My lord, I am praying for inclusion of a matter. It's a writ petition of 2022, my lord. The incentive under West Bengal incentive.
Inclusion in the list.
Yes, my lord.
Yes, please hand over.
Grateful, my lord. May I mention for one upgradation which I am.
What is the urgency?
My lord, the possession is not given to the petitioner despite for 2 years, my lord. Even the police.
I'm sorry, not this matter. Yes.
Item number 292 for upgradation, my lord.
What is the urgency?
This is the Surfacey Act matter, my lord. Respondent bank is going to take over my petition.
Hand over.
My lord, oblige, my lord.
I know number 101 of monthly list.
Yes.
For upgradation, my lord.
There are probably 100 upgrade matters. Today, 50 are there. I have added 50 more probably.
My lord, petitioner is the only legal heir of his uncle. And
I don't want
petitioner
to
applied
hear
for,
that.
applied for the allocation of his
Not right now. Not
uncle's
right now.
flat,
Next.
and they had started the demolition of the flat.
Not right now. Yes, Mr.
Regarding item number 270, my lord.
Urgency.
My lord, the urgency is this, my lord, the petition, one of the private respondent, my lord, he alleged that the land of the petitioner, it is a earmarked land.
What do you want? What is the relief sought?
DM, without going into any proceeding, my lord, the DM declared.
You are arguing the matter, Mr. Chakravarti. What has he done, the DM?
DM already passed order that this demolition must be done on that land where the petitioner, he constructed his house.
Yes, handover.
My lord.
Yes.
Okay.
This is the last line of mention. Please. No, you have already mentioned. No, no further. Yes, inclusion regular.
Inclusion, your lordship, I am the.
Inclusion, yes.
My lord, upgradation, my lord, item number 68 of today's list.
Urgency.
Yes, my lord, actually my bank account.
All right, no further mention this side, please. Come back.
My lord, my bank account has been frozen. I'm a retired person.
Hand
I'm
over.
against disconnection of
Grateful.
electricity supply.
The matter pertains to inaction on the part of the concerned sub-divisional officer, my lord, in taking steps in respect of my complaint pertaining to a purported schedule caste certificate issued to the.
Schedule caste certificate, you're trying to cancel somebody else's certificate. Wait for some time. Next.
I'm asking for an upgradation agency that not despite clearance of all dues, bank is not releasing title deed. I can take any further than from another.
I appreciate title deeds. Please come back after some time.
Running. Ruby General Hospital.
Very well, hand over. Yes.
My lord, my vehicle is being seized by the DFO authorities, my lord, despite the order.
Something else was seized on the last turn of mentioning. You are mentioning this is the second time you are mentioning.
My lord, the first mentioning was for release.
No,
my
no,
lord.
no, no.
Innocuous release, my lord.
No,
This is
no.
an urgent, madam.
No further. Yes.
For upgradation,
Urgency.
the minor daughter of the petitioner is not getting the ST certificate.
ST certificate. Hand over. Call code list.
Your lordship, may I permit to mention one matter?
Item 1, top item.
Yes. Yes, Mr. Vardhan, what is that?
The certificate letter.
Affidavit of service.
Sir, they're appearing.
Certificate data.
Challenges the proclamation of sale under the Bengal Public Demands Recovery Act.
Yes.
No, I'm challenging Locus.
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 Why? On what ground?
Because he is claiming that I am the secretary of the society.
Right.
When fact remains that the board of the society has been dissolved much earlier in the year 2022, and thereafter special officer was appointed, and there is no board as of now. So the society is the debtor.
He's representing the society in the cost title.
The society claiming himself to be the secretary.
Acha, very well, let me hear Mr. Vardhan on that. Mr. Vardhan, deal with that first.
Kindly seize my cost title. IHBAG Shomabhay Krishi Unnayan Samiti Limited, a corporate society. Then,
how can you represent that?
Kindly seize number 2 is Ratneshwar Bhatto,
Yes.
Sadansa secretary.
Yes, as secretary.
As secretary.
So, how is it maintainable?
May I say this? This writ petition, has a checkered history. This earlier orders have been passed by this court, Now,
No, Mr. Vardhan, we are on Locus now. If the entire body has been dissolved, you cannot.
Someone has to represent,
Body has not been resolved.
The body has, my instructions are body has not been resolved.
There is no board. There is no
board.
May I say this? An observer was appointed.
Yes.
He passed away, So someone has to apply,
You are applying for appointment of observer.
No,
Do you have to apply for that first?
May I say this, My property is being sold. My property is being sold, in terms.
By means the society.
Yes. Society.
You cannot represent the society. Cannot say. Reframe your. If there is any personal injury, come up with that.
May I say this? My learned friends, they had appointed the observer. The observer has been expired. So someone has to represent.
I have not appointed observer. I am for the Murshidabad District Central Cooperative Bank.
Oh, you are
at the, no. At whose instance this auction sale is going to?
You don't appear for sale officer.
No, I am not for the sale officer. I am for the respondent number 2.
3 versus service on 3.
They are the certificate holder. They are the worst affected.
Yes, the certificate holder. And the society is the certificate debtor.
I have got nothing against the award. There's an award which is under challenge in this High Court. I am only on the mode of sale.
I even do not challenge the sale as a mode of sale.
That he
I
can-
reject the proclamation.
That
Don't
you
have
can-
locus.
That you can.
Don't have.
Someone has to represent, my lord. Someone.
You should have taken steps. When did the observer pass?
Sorry, this year on January.
January. I'm told it's January.
You should have taken steps for appointment of a new observer. Do that. But you cannot represent. You are a dissolved board. How do you don't have locus standi to represent the society, Mr. Bodhan? This is entirely on the society and as secretary. Of,
Yes, true.
how is it maintained?
Wrong description, my lord. And suppression fact.
Mr. Bodhan, like I mean, in some matters, shareholders may represent their own cause also. No, that the same principle may apply. If you have any personal cause of action, you can come up. I'll give you that liberty. If you have any personal cause of action, you can come up. At the outset, an objection as to locus standi is taken, full stop. It transpires from the cause title of the writ petition that the petitioner number 1 is a society who is
My lord, may I reframe my requisition? Come back, my lord.
I'll let a
And
prayer.
this and come back.
who is purportedly represented by petitioner number 2, which is purportedly represented by petitioner number 2, claiming to be the secretary of the said society. Full stop, next para. However, learned counsel for the respondent number 2 points out that the board of the society has already been dissolved, and as such, the petitioners do not have locus standi. Petitioner number 2 does not have locus standi to represent the society. Full stop, next para. Learned counsel for the petitioners argues that an observer was appointed after the dissolution of the board, who has since passed away in January. Full stop. However, the remedy of the petitioners, petitioner number 2 lies, if aggrieved due to the vacuum created on the passing away of the observer, is to approach the appropriate forum for appointment of a further observer or taking due steps in that regard. Full stop. However, as of date, the petitioner number 2 cannot represent the society, and hence the writ petition is bad for lack of locus standi of the petitioner number 2. Full stop, next para. Accordingly, WPA 7148 of 2024 is dismissed on the ground of locus standi without any orders to cost. Full stop, liberty, however, is given to the petitioner number 2, if otherwise entitled in law, to canvass a personal cause of action with regard to the affairs of the society, if any, in an appropriate proceeding / writ petition. Full
My
stop.
lord, I am relying on this memo, my lord. I have handed over, my lord. I have handed over.
Yes. No. This is for regarding the dissolution.
Yes, regarding completion of tenure.
The copy of a memo dated March 12, 2024, handed over by learned counsel for the respondent number 2 in respect of the dissolution of the
Completion of tenure.
in respect of the completion of tenure of the previous 12 board be kept on record. Next.
Great.
Upgraded matter item 2.
Yes. Do not have locus standi. আমার কবে থেকে আছে 2021 has determination to hear writ petitions from the year 2021 onwards, I do not have determination, and as such the matter be released from my list due to lack of determination, with liberty to the parties to mention for inclusion before the appropriate bench having determination. I'm sorry. Yes. Please give your name, sir. Yes, next.
Item 3. Item 3, I'm for the respondent number 3. Upgradation notice has not been served to us.
It's appearing in the list, that's sufficient. Yes.
Kindly make it on Monday. Just one day we are.
It was taken up yesterday also. You are for which respondent?
Respondent number 3, Bank, Indian Bank. Kindly, we are praying for one day adjournment.
Very well. Come back on. The bank submits that no notice of upgradation was given to it, pushed up on the prayer of learned counsel for the bank, that is respondent number 3.
Respondent number 3.
The matter is adjourned for the day.
Fine.
And shall be listed under the same heading
My lord, I am filing the affidavit service, my lord.
on April 1, 2024. Affidavit of service filed today be kept on record. Please come back on next month.
Great. Led by Mr. Om and
Yes. This is that matter you sought instruction with.
item 4.
I wish to appear on the state respondent. My lord, your lordship's pleasure was that, my lord, we should file a report. Kindly grants me 3 or 4 days time to file a report, my lord. Lord, I have received the report from instruction on 20th March.
This report is regarding what?
Regarding, my lord,
May I tell you, lordships? Lord, I purchased a plot of land, my lord, which do not have any access in the road.
What?
Now, I applied for before the authority because in the northern side, there's a non-Julie and then highway.
PWD was to identify the land and all.
Land.
Yes.
Now, your lordships,
I'll give them 3 days time, Mr.
Lordship.
Come back on Tuesday.
Waitlist, my lord, is waitlist.
Yes.
Lordship.
Only one thing, my
Yes, please.
events of the petitioner is to that extent that he did not make any construction for cultivate due to encroachment. Now, my lord, you also can't direct to identify the land because the petitioner himself.
So, save your breath for Wednesday.
Report is there, my lord.
Learned counsel for the state seeks an adjournment and an extension of time to file the report as per previous direction. Hence, on the prayer of the state, the matter is adjourned till April 3, 2024, when it will be listed under the same heading.
Extremely grateful.
Thank you. Yes, Mr. Bhalet.
Lord, may I have a copy of the report before I
Acha, at a line at Kurdin, at the copies of the report shall be circulated by the state on the learned advocates appearing for the other contesting parties. Please circulate among all. Particularly to Mr. Dotto.
Yes.
Yes. 5.
Lordship, this matter is regarding release of advocate professional fees. Your petitioner is a 72 years old.
Can you file the referee?
Yes. Service.
Have you given any notice of upgradation?
No, your lordship.
Why don't you give notice of upgradation in these matters? Otherwise, they won't be there. Your fees are being withheld. You are an advocate.
Yes.
Please give a notice to the respondents. Come back. Affidavit of service filed today be kept on record. However, none appears for the respondents, nor has any notice of upgradation been served on the respondents by the petitioner. The learned advocate on record for the petitioner shall serve a notice indicating that the matter is appearing under the upgraded heading and file a receipt on the next date of hearing. The matter shall be listed on April 2, 2024 for hearing under the same heading. I am keeping it on Tuesday so that you get another extra day for. Yes.
Item 6.
Yes.
Yes. I'm appearing for the petitioner.
Right.
My lord, I am appearing on behalf of the Union of India.
Union.
The affidavit of service is here.
Yes, yes.
My lord, your lordship finds, my lord, the district.
Can you please take the microphone a bit closer to you? Yes.
The district commission.
Yes.
My lord, rejected my prayer.
Commission means consular forum.
Consular forum. My lord, your lordship finds the order, my lord.
There is an alternative forum. Why should you interfere?
My lord, the appeal was preferred before the state commission. State commission, my lord, turned down my appeal ex parte.
National Commission revision is available.
Thereafter, my lord, 226 jurisdiction of your lordship has.
No, revision is available with the national.
The alternative remedy, my lord, cannot.
Not absolute bar, but we rarely interfere.
First order, my lord, I shall.
Very well.
If
I put you on alert.
Yes.
You have to show me that.
Yes.
Yes.
My lord, your lordship kindly comes to. My lord, impugn order is at page 14. First, the commission's district commission's order, your lordship finds.
Yes. 14.
At page 15, that the complaint case is hereby allowed ex parte against Tropi Cold Storage. Has your lordship got it? Then, my lord, your lordship comes to page 17. The appeal was preferred. None appears on behalf of either side. In view of earlier observation, the case is dismissed for non-prosecution. Appeal was dismissed for non-prosecution.
Your appeal.
Yes. Then, my lord, the execution case was started. Already started. Then, my lord, your lordship finds at page 18. Kindly come to the bottom. 3 paragraph. The judgment debtor has taken dilatory practice to defeat the claim of the decree holder. The decree can be executed by exhausting civil remedy in terms of 71 and also by invoking criminal remedy under section 72. The judgment debtor opts for proceeding with criminal remedy by exhausting coercive process like warrant of arrest. With great respect, I join issue here. The judgment debtor, my lord, cannot make a prayer or opt for. It is the decree holder who will do it.
This is the clerical error.
Perverse
Obvious.
finding, my lord.
What purpose? This is obviously clerical error.
Then, my lord, your lordship gets it. The commission also of the view that ends of justice to compel the attendance of the judgment debtor. My lord, how can it be? Obviously, be. He repeats it.
You are right. Because he reiterates on that finding.
Yes. Continuation of that.
And Navakumar Dattu is your client.
Yes. Perversity is writ large on the face of it.
Is this proceeding with criminal remedy? Have you initiated anything?
No. 72. Section 71. Execution proceeding 71.
Consumer Protection Act দাও।
And my lord,
যখন মামলাটা হবে তখনই তো অ্যালার্ট থাকবে।
This court also. Justice Vivek Chaudhary's judgment.
এটা দেবেন তো যশোর। হ্যাঁ হ্যাঁ লাগবে না। 71 relates to execution proceeding and 72 milord penal provision.
72 overlap করে 71 overlap করে 72.
হ্যাঁ execution proceeding milord
No, imprisonment is also there.
Yes.
71 started long back when once milord 71 has been adhered to milord or taken recourse to
No, exhausting coercive process, warrant of arrest was issued against you previously.
Yes.
So then what happened? You did not appear.
No, I have challenged this order before
Then
you.
under 72, it can, the forum can pass this order.
No, the execution proceeding milord which was pending there long back, from long back,
Yes.
that was initiated under section 71.
Right.
Once 71 has been taken recourse to, 72 cannot be taken resort to. That is the finding of Justice Vivek Chaudhary.
Let me see this section first.
Yes, kindly.
71.
71 is the execution proceeding, and 72 is the penal provision.
Civil remedy.
And moreover, my lord, the judgment debtor is praying for proceeding against himself under warrant of arrest. That cannot be done.
That you have not done. That was done by the decree holder. It's a mistake.
No.
Finding.
Can,
authorities were also
cannot take advantage of that mistake. Obviously, you did not take out a warrant of arrest against yourself. But the question of law you have raised, just let me see the section, then I'll look into the judgment. Please give me half a minute, I'll just look.
Proceedings pending.
71 execution proceeding is pending. In the midst of that proceeding, 72 cannot be adhered to. That is my contention.
Yes, Justice Chaudhary's judgment, which portion is relevant?
Only the relevant portion. Pages 11 and 12, your lordship may be pleased to turn to. Pages 11 and 12. Kindly
You have given a copy?
Oh, our copy to
Yes. That is section 71, this is section 72. Copies. You are taking recourse to both remedies.
Justice Chaudhary has dealt with.
I am not saying that. I am saying both copies you have handed over. One is 71, one is 70. You are taking recourse to both. Yes, page 11, yes.
Page 11, Milord, kindly.
Are not mutually inclusive.
Provisions of section 71, 72 of the Act are not mutually inclusive. It is open for the decree holder after disposal of a case or appeal as the case may be either to put the order of the commission in execution or to play for initiation of a proceeding for penalty for non-compliance of order under section 72 of the Act. Kindly, I am skipping over. Thus, while comparing the provisions contained in 71 and 72 of the Act, it is ascertained that if the decree holder wants execution of its order, they must take recourse of section 71, and the execution will proceed in accordance with order 21. In an execution proceeding, the commission having power of the executing court cannot take recourse to section 72 and take a shortcut and coercive method for execution of its order. For the reasons stated above, this court comes to an irresistible conclusion that in an execution application, the commission cannot issue warrant of arrest for enforcement of its order. The commission has, of course, the authority to issue warrant for detention of the judgment debtor in civil prison in accordance with the provision under the Code of Civil Procedure. It cannot issue warrant of arrest against the judgment debtor following the part B of Chapter 6 of the Code of Civil Procedure. In view of what has been stated above, this court finds that the order dated such and such is palpably.
Yes, what do you say, Mr. Bhattacharya?
Difficulties, I'm totally unequipped. No notice for upgradation was given to us. I'm appealing for the private respondents.
There's an immediate urgency. I mean,
kindly takes it on Monday also, my lord. I am not without the brief.
No. In the meantime, he'll be. I mean,
it's not upgradation.
Yes, this is
warrant of arrest has been issued.
Yes.
Kindly takes it on Monday, my lord. Kindly.
In time, Lord, I get arrested.
Yes, but till Monday, I'll give it. Put in a stay order for you.
Yes.
Learned counsel for the petitioner argues that while during pendency of a proceeding under section 71 of the Consumer Protection Act 2019 for execution of an award passed by the Consumer Forum, the award holder has also taken out a proceeding under section 72, apparently for the implementation of the same award. Push up next para. Two defects are sought to be pointed out in the order of the executing forum. Push up first, it is recorded that the judgment debtor opts for proceeding with criminal remedy by exhausting coercive process like warrant of arrest, which is absurd, since the judgment debtor cannot ask for issuance of warrant of arrest against himself. Full stop. Secondly, comma, by placing reliance on a coordinate bench judgment of this court dated August 12, 2022 in the case of Samast Infotainment, এটা দেখে করে দিও, such and such, comma, it is argued that once recourse is taken to section 71 of the 2019 Act, comma, order cannot be passed under section 72 as a coercive measure to force execution. Full stop. Next para. Learned counsel argues that in view of the said position, comma, the issuance of warrant of arrest against the petitioner by virtue of the impugned order dated February 6, 2023 is bad in law. Full stop. Next para. Learned counsel for the, you are for respondent number? 5. Respondent number 5 submits that no prior notice of upgradation of the matter has been given to the respondents. Full stop. As such, comma, learned counsel seeks a day's accommodation. Full stop. Next para. In view of the extreme urgency involved, comma, since the matter pertains to issuance of warrant of arrest, which may be implemented at any point of time against the petitioner, and since an arguable case has been prima facie made out, comma, the operation of the impugned order dated February 6, 2023 is stayed till April 5, 2024 or until further order, whichever is earlier. Full stop. The matter shall be placed under the same heading on April 1, 2024. Affidavit of service filed to be kept under. একটু উপর দিকে দিয়ে দিই এটা, একটু উপর দিকে দিয়ে দিই, শোনো। Thank you.
7, 8 actually.
Yeah.
7. 7 and 8 minutes, will cover the same point.
7, 8 are against what?
Same.
Other judgment debtors?
No, the same judgment. Same part.
Why so many writ petitions?
3 complaints were filed.
What is the difference between the three?
3 cases.
3 cases warrant of arrest?
3 cases.
You are an evader.
No.
No. On first, let us see what Mr. Bhattacharya submits. Same order. পরের দুটোতে সেম অর্ডার। আর একটা লাইন অ্যাড করে দিও দুটোতেই, সবকটাতেই, লেট দ্য ম্যাটার বি হার্ড অ্যালং উইথ ওই আদার 2 ম্যাটার্স এর নাম্বার দিয়ে প্রত্যেকটা। Three will appear together on first.
Item 9.
Yes.
Affidavit
পিটিশনার তো
হ্যাঁ,
এদিকটা চলে আসুন,
petitioner.
এই মাইকটা চলে। কি ম্যাটারটা?
Affidavit সার্ভিস, সাপ্লিমেন্টারি এফিডেভিট,
Yes.
এগুলো দেওয়া আছে।
সাপ্লিমেন্টারি এফিডেভিটের কপি দিয়েছেন?
হ্যাঁ, সাপ্লিমেন্টারি এফিডেভিট।
আর আপনি নোটিশ দিয়েছেন যেটা আপগ্রেড হয়েছে?
হ্যাঁ।
আপগ্রেড হয়েছে, আপনি তো মেনশন করে এটা আপগ্রেডেশন নিয়েছি আমি, তার কোনো নোটিশ দিয়েছেন? একটা নোটিশ দিয়ে আসুন তাহলে।
হ্যাঁ, নোটিশ আজকে আমি দিয়ে দিচ্ছি। আমি
আজকেই দিয়ে দিন, আমি সোমবারই রাখবো।
আজকে নোটিশ দিতে হবে?
হ্যাঁ, নোটিশ দিতে হবে, মেনশন করে আপলোড
অবশ্যই,
করছেন না? হ্যাঁ,
তাহলে নেক্সট কবে থাকছে?
সোমবারই থাকবে, সোমবারই নেক্সট ওয়ার্কিং ডে।
ঠিক আছে।
Affidavit of service and additional supplementary affidavit along with supplementary affidavit filed to be kept on record, full stop. None appears for the respondent at the time of call, full stop. However, comma, it transpires that no notice of upgradation of the matter was given to the respondents, full stop. Accordingly, the petitioner, comma, appearing in person with leave of court shall serve a notice indicating that the matter shall be listed under the heading upgraded matters on April 1, 2024. Notice of upgradation. None appears for the respondents. No notice of upgradation has been given. Let the matter stand adjourned till April 1, 2024. Full stop. A notice of upgradation of the matter shall be given in the meantime to the respondents. Yes, Ms. Sadok. No notice. Same.
Well, I am for the petitioner.
Yes.
My Lord, Lordship, prior to coming to the petition, my Lord, may I submit, Lordship, my Lord, Lordship was pleased to pass an order, March 12, my Lord, file a report, an advance copy of the report to be served upon the learned advocate of the petitioners, my Lord, but they have not served.
Respondent of 7 is the bank.
Respondent 7, you don't know.
Who was to the 7 was to file the report.
Respondent 7, my Lord, assistant engineer.
You are for the union. State is not there. No report is filed pursuant to the previous direction of this court. Full stop. The learned advocate for the petitioner shall give a notice to his counterpart appearing for the respondent of 7 and or the respondent of 7 directly, indicating that the matter shall be listed under the same heading on April 2, 2024. Full stop. It is made clear that in the event no report is filed on the said date, appropriate orders shall be passed in the matter.
My Lord, may I only submit, my Lord, only one thing, my Lord?
Yes.
But they have not circulating the water through the pipelines still today.
No, I asked for a report. Let us see. Let that come.
Grateful. Duly obliged. Thank you. And also, my Lord, may I submit?
Give a notice today itself.
Yes, yes. My Lord, also, my Lord, when my Lord passed an order on 12th of March, my Lord, immediately thereafter, next date, my Lord, they have issued the notice that they are going to construct the road over my land.
Let us see.
My Lord, we have
they cannot construct it overnight.
Matter is appearing third before worship.
Eta kobe dilam raklam?
2, second.
Should I keep this also on third?
Yes.
Third, April 3.
I'm giving the number.
13.
Lordship, this is what 41 application.
Yes.
Against state, Your Lordship.
14 application, not
14.
41.
Sorry, Lordship.
Yeah, you have served on the borrower.
Yes, Your Lordship. This is
All have been served, you have checked up.
Yes, Your Lordship.
You are for the state.
State, Your Lordship. I'm led by Mr. HON'BLE Kumar Sen.
Right. Learned counsel for the petitioner points out that the application under section 14 taken out by the petitioner bank is pending for an inordinate period, beyond the statutory outer limit, full stop. Affidavit of service filed today be kept on record, full stop. Despite service, none appears for the borrower, full stop. Accordingly, WPA 1024 of 2024 is disposed of by directing the respondent number 2, that is the district magistrate Nodia, to dispose of the application 2002 as expeditiously as possible, positively within 3 weeks from the date of communication of this order to the respondent number 2 by acting on a server copy of this order. No rest to cause urgency.
Grateful, Your Lordship.
14.
14, I beg to appear on behalf of the CSC, man.
Yes.
My Lord, kindly page 15. I am for the petitioner.
Right.
Page 15, P4.
Yes.
The service charge security has already been deposited.
But not given?
Not given. We have faced objection, my Lord, from one Mr. Ashok Das, that we have intimated to the petitioner on 30th of October 2023.
30th of October is after the filing of the writ petition. Also, that intimation copy is there with you, Mr. Mukherjee? Have you got the particulars there?
No, my Lord, only the inmates we have stated, but in my instruction, it is written at Ashok Das. My Lord, Ashok Das is not made a party.
Ashok Das, if he does, you have to disclose. I mean,
my Lord,
Ashok Das is not even mentioned here.
Well, only inmates it's written, my Lord.
Inmates of what? They're the same house then.
No,
inmates has to be in the house.
It is a saloon. It is a saloon. Business center.
Saloon?
Saloon.
Who are the inmates? The customers?
I don't know what they like to say. My submission is only
of a saloon, Mr.
only the page 15 bill for service charge and security charge deposit has already
a saloon or a salon? If it's a saloon, there can be inmates. If it's a salon, there cannot be any inmates.
The difficulty is that, my Lord, so this is an application for a commercial loop meter connection.
So what?
My Lord, it is a paid case, my Lord. We have attempted many times, my Lord, we have been obstructed. My Lord, direct the police.
This is very vague. You are a owner of that?
Tenant. Tenancy receipt is there. Annex P1.
Very well. The
P1.
petitioner alleges that the petitioner has deposited the security deposit and complied with formalities in terms of the bill raised by the CSC for getting a new electricity connection for operating his salon, SALON, full stop. However, comma, such connection has not yet been given, full stop. Next para, learned counsel for the CSC Limited hands over a copy of a communication purportedly made to the petitioner on October 30, 2023, comma, that is after the filing of the writ petition, comma, indicating that the team deployed to execute the job was unable to do so due to objections raised by the within double inverted inmates, double inverted close, as well as the access to the supply position was denied. Full stop. The said communication be kept on record, full stop. However, comma, it is unclear from the same as to who are the exact objectors, full stop. Moreover, comma, moreover, na.
If I am not wrong, may I interrupt? May I kindly see the affidavit part that is on 15th of October 2023, this writ petition is filed.
This is 30th of October. Your letter.
Later, I'm sorry to interrupt.
2 rupee costs.
I'm sorry.
কি বললাম? Said objectors. So moreover, comma, there is nothing on record to indicate that any written objection was filed by a legitimate objector. Next para. The petitioner has annexed the of the property as a tenant. Next para. Hence, comma, there cannot be any impediment in the CSC Limited giving the electricity connection to the petitioner. Next para. Accordingly, WPA 1048 of 2024 is allowed, comma, thereby directing the CSC Limited to give electricity connection to the petitioner within a fortnight from date and or from compliance of all formalities, comma, whichever is later, comma, positively. Full stop. In the event any obstruction is raised from any quarter, it will be open to the CSC personnel to approach respondent number 3, the inspector in charge of the Chitpur police station, who will provide adequate police assistance to assist the CSC personnel in doing so at the cost of the petitioner. Full stop. Next para. In the event any padlock or other hindrance is put up to prevent the CSC personnel, comma, it will be open to the police to remove such hindrance or padlock for the limited purpose of giving access to the CSC Limited to the existing meter board position. Full stop. The parties and all concerned shall act on a server copy of this order for the purpose of compliance. No orders to cause urgent certificate.
My lord, I was correct, my lord. My lord, this petition was affirmed on 15th of January 2024. That's why it is coming as the 1048 of 2024. I kindly see the stamp of the Commissioner of Affidavit, High Court, Calcutta.
Correct. 22nd January 2024.
But it was affirmed on 1st of October.
15th of October is this one.
Okay. বিশ্বাস করছেন দেখো it was affirmed on 1st of October.
24
File later. যেখানটা বলেছি after ওখানটা দিও না. After the filing of the writ petition, ওই কথাটা কেটে দাও. I have scored that through. করে দাও. Next.
I'm grateful. I'm grateful.
I am also grateful to both of you.
But the difference in
Otherwise, you are not stopping. Both of you are saying
kindly everybody service
granted. Prayer granted. Yes. 15. Yes. Who is for the? What is the matter? Affidavit of service, ma'am.
Yes, my lordship.
Number 7, lordship.
7.
Lordship, known.
Yes. Move your matter, ma'am.
Yes, my lordship. This writ petition, I have preferred this writ petition against the respondent number, private respondent number 7 and 8, and the fact was that the private respondent number 7 and 8 has misused the entire fund raised from the 15th pay commission. They have raised huge bill against the act, which have not they done. They have not made any roads, not digged any tube well, but they have raised the bills against that act. And
is your locus standi? What is
my lordship, I am the member of the Panchayat Shamit.
So those allegations are here.
Yes, my lordship.
What sort of relief are you wanting?
My lordship, I have made a representation.
Page 45 is represented, sir.
Yes, Annexure P3. Kindly
We'll
consider.
consider the representation, the chief minister.
No, my lordship, it's a block development
Will
officer.
do. Block development officer will help you against the Panchayat. Anyway, I'll direct this to be decided.
Yes, yes. My lord.
Yes, my lordship. I want I pray for an inquiry against these respondent number 7 and 8.
Inquiry I cannot direct from here. Let him ascertain. He will give you a hearing. Both of you a hearing, and then decide on it.
My lordship, there is.
Then hearing.
Let her finish. Yes.
My lordship, the private respondent number 7 and 8 was lodged FIR against each other, and then the
Those will be considered by the block development officer.
no, my lordship, he has not considered any my complaint
That
or
will be considered after I direct this representation to be heard.
Okay, okay, my lordship.
Okay.
Okay.
You sanction this, so then I'll allow it. Yes. I'll direct that the representation to be considered. I'll indicate certain allegations are made by the writ petitioner, who is the member of the Chakdaho Panchayat Somiti, against the private respondents, who are the Pradhan and the secretary of the said Gram Panchayat respectively. Push up next para. It is contended that the private respondents have filed complaints against each other. Push up. However, when a representation was made to the block development officer, Chakdaho development block, Nodia, it is argued that the said block development officer did not take any steps on the issue. Full stop. The contentions raised by the petitioner are denied by learned counsel for the private respondents. Full stop. Next para. In view of the innocuous nature of the prayer, however, affidavits are not being directed, and it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Full stop. The purpose of justice would be subserved if the concerned block development officer, that is respondent number 4, looks into the issue, upon an inquiry if necessary, and upon giving opportunity of hearing to all the concerned parties, including the petitioner and the private respondents. Full stop. Next para. Accordingly, WPA 1467 of 2024 is disposed of by directing the respondent number 4, that is the block development officer, Chakdaho block, Nodia, to consider the representation annexed at page 45 of the writ petition given by the petitioner upon conducting an inquiry into the issue and upon giving opportunity of hearing to all the concerned parties, including the petitioner and the private respondents, and thereafter take a decision in accordance with law upon completion of such inquiry and hearing. Pushed up. The entire process shall be concluded by the respondent number 4 within 2 months from date, and appropriate action shall be taken thereafter consequent to the outcome of the said inquiry and hearing. No address to cause, urgent certificate copies.
Grateful, my lord.
This is a Hengram Gram Panchayat.
Oh, what Gram Panchayat?
Hingnara Gram Panchayat.
Hengara.
Hingnara.
Hingnara. Acha, ota Chakda ki bolam Hingnara. Thank you.
Block.
Chakda
Block.
Chakda block.
Block Chakda.
Yes, yes. Block is Chakda, that has gone correctly, but ota cost title dekhe naam. Sorry. Thank you.
My lord, like by Mr. HON'BLE, he is engaged court room.
Please give them.
16. But I am for the petitioner.
Yes, what is
I am
that?
for respondent number 9.
My lord, I am for,
Private respondent.
but I am for the petitioner, my lord. My lord, initially,
You're for the state.
Mrs. Shubhashree Ghosh is appearing for the state due to her viral fever. She could not come to court.
Let us see what relief he is
Yes,
asking for. What is the relief?
but what happened, my lord? My lord, I am the
You're
owner
for the state or the WBSCDCL?
DCL.
my lord, state I also serve, my lord.
No, WBSCDCL is what is the grievance?
My lord, very short grievance. But initially, my lord, I am the owner occupier, my lord, of the land. But initially, I came before your lordships in previous occasion. Your lordship directed the district magistrate to hear out my application. What happened, my lord? Despite of the direction of your lordships, my lord, I prefer representation before the district magistrate, my lord. District magistrate, my lord, my representation has not been disposed of, and not only that, my lord, by this, my lord, passage of time, my lord, the other side, my lord, filed suit, different suit against me. My lord, that suit also, my lord, they prefer appeal before the additional district judge. District judge also, my lord, set aside the order of the my lord, Munsef. My lord, one after another litigation crops up. My lord, that's why, my lord, I pray before your lordship, my lord, kindly keep it pending the matter. In the meantime, direct the district magistrate to dispose of the matter. Otherwise, my lord.
That is my direction. Show me that.
Yes, yes, page 62, my lord.
Fourth matter.
Acha. And when did you make the representation?
Yes, my lord. That is on 6/3, my lord.
Page 11. And my lord.
You come this side, you appear for the petitioner, and you appear for the other side.
My lord.
You're more prepared than him. Yes. No, this is not caustic. I mean, this is good.
My lord, actually.
When did you give the representation? What is the date you
Yes,
said?
my lord. That is date, my lord. I'm telling you, lord, my lord. That is 6/3/2023. 6th March.
2022.
23, my lord.
23.
23.
You waited for 3 months for communication.
Yes, my
So,
lord.
why do you claim any equity for that?
My lord.
I passed my order on 16th of December. You communicated on 6th of March, 3 months after. Why?
But what happened, my
You
lord?
cannot claim any equity.
My lord, kindly, my lord. Otherwise, my lord, I am without electricity, my lord.
No, you cannot claim any equity. You waited
My
for
lord,
3 months.
My lord,
Why?
Thereafter, my lord, I have made representation. My lord, thereafter, another
No,
representation.
I'll not keep the writ petition pending. This is not a
direct them, my lord, within a.
definitely I'll direct.
Otherwise, my lord.
Kindly see the order of the DM.
They must pass an order.
We have not passed an order.
Only
There was
one
a
hearing.
direction- There was a direction, second page, my lord. There was a direction to file a field inspection. BLRO was directed.
BLRO wasn't done, my
Field
lord.
inspection has been done. So, my lord, the DM can be directed to dispose of.
I'll do that. The petitioner alleges that although this court vide order dated December 16, 2022, passed in WPA 22831 of 2022, had directed the district magistrate, Howrah, to decide the issue involved in the writ petition in accordance with law and upon giving opportunity of hearing as expeditiously as possible, positively within 6 weeks from the date of approach being made by the petitioner, the matter has still been kept pending by the said district magistrate. Push up, next para. Learned counsel appearing for the respondent number 9 hands over a copy of an order dated May 3, 2023, indicating that the district magistrate had directed the district registrar Howrah to submit a report regarding authenticity of the deeds submitted by the petitioner and private respondents. Push up, it is submitted by both parties that the report has since been filed. No, not filed.
No, but
not BLRO has to be submitted as a report also. They had to do a field inspection. Next
No, district registrar did not file.
My lord, that is not within my knowledge.
No, my lord, that is filed, my lord. I have checked it up, my lord.
Achha, it is submitted by both sides, it is submitted by the petitioner that the said report has been filed.
Yes, my lord.
Pushed up. Next para, it also appears from the same order that the divisional engineer Howrah Division 2 WBACTCL was directed to cause a joint field inspection with BLLRO AMTA 1 with prior intimation to the petitioner. Push up, next para, be that as it may, upon query of court, the petitioner submits that the petitioner approached the district magistrate after about 3 months from the passing of this order dated December 16, 2022. Full stop. Although under normal circumstances, the petitioner should not have been favored with an order on the ground of equity, since the petitioner herself caused a delay in approaching the district magistrate, still, in view of the inordinately long pendency of the matter before the district magistrate, the district magistrate is required to be directed to dispose of the matter at the earliest. Full stop. Hence, WPA 1481 of 2024 is disposed of by directing the respondent number 2, that is the district magistrate Howrah, to comply with the order dated December 16, 2022, passed in WPA 22831 of 2022, and dispose of the matter pending before the respondent number 2 as expeditiously as possible, positively within April 30, 2024, by ensuring that all the reports directed by the district magistrate are submitted at the earliest. Full stop. It is expected that the timeline indicated above shall be adhered to strictly by the district magistrate Howrah. No less to cause urgent certificate.
Affidavit of service kept with that.
Affidavit of service and the copy of the order handed over in court today by respondent number 9 be kept on record. Please don't give her name, give your name for the WBACTCL. She is not in court. You are in the panel.
No, Lordship.
What is your name?
Pile Khara.
Pile
Khara.
Khara. একটা লাইন প্রথমে অ্যাড করে দেবেন তো। An adjournment is sought on behalf of the WBACDCL in view of absence of counsel for the said respondent. Full stop. However, comma, in view of the innocuous nature of the order proposed, comma, the matter is taken up for hearing. Full stop. Ms. Pile Khara shall be the appearance of Ms. Pile Khara shall be regularized by the WBACDCL to enable her to represent the WBACDCL for this particular matter. Please communicate an order to the WBACDCL authority. Ask your senior to do it. Your appointment for this matter will be regularized. Yes, next. 17. Yes.
May it please your lordship.
Yes, please.
17, I'm for the respondent bank, my lord. May I entitled to get a upgradation notice, my lord? Suddenly I've come to the court and
Affidavit of service filed today be kept on record. It is submitted by learned counsel for the bank that no upgradation notice has been given. Full stop. Let the matter stand over till April 1, 2024 under the when it will be listed under the same heading. Come back on that. Yes.
Huh.
18.
I'm appearing on behalf
Yes,
of the
Mr. Sheth, what is the matter?
This is the affidavit of service. My lord, the
It's
petitioner.
all 13 affair.
All that did.
Yes. Yes, Mr. Sheth.
My lord, the petitioners applied for passport, my lord. They,
She's from.
You're for the state, right? See?
Not all 13 affair.
Not?
Not all, but
Acha.
well,
Ms. Shaw should be given an honorary membership of the Bar Association rule number 13.
100.
All the rest of us are from that bar.
Yes.
Yes, Mr. Sheth, please continue.
the petitioner applied
You
for,
want to travel to Arab country? Why is this relevant?
for the purpose of Hajj.
You should have said that only. Oh, acha, Hajj is a pillar of Islam. Yeah? Yes.
My lord, the petitioner
So you want to visit Arab country for Hajj?
for Hajj.
Passport refused. Why?
Because of that, one criminal case is pending against the petitioner.
You have obtained an order from the magistrate.
No, my lord.
Give him a copy of the circular, Mr. Tiwari.
My lord, I am relying on judgment, my lord, passed by our coordinate bench of our High Court, my lord.
Cite that. Passport একটা দাও ওগুলো দাও পাসপোর্ট একটা দাও
Yes.
Yes, there also same thing was stated by her ladyship. See the first, the second paragraph. Petitioner may apply to the court for permission as per the provisions of notification. Oh, acha, that was not. Let us see what happened. Here also it was directed, considering the relevant provisions of the 1967 Act as well as the notification, dispose of with the direction on the Deputy Passport Officer to issue passport. I'll read something into this. That passport, the provision is section 6(2)(f) that is qualified by the notification.
No, 570.
Pardon?
GSR 570.
Yes, দাও ওটাই দাও না যা বলছি সেটা দাও Mr. Seth, I'll give you liberty to approach the jurisdictional court to obtain an order from that court and immediately approach them.
Yes,
When is the Hajj scheduled to begin? I mean, you're scheduled to leave when?
Within 1 month, my lord.
Oh, you'll get it much before that. Learned counsel for the petitioner argues that the petitioner was denied passport. Push up. The ground for such refusal was that a criminal case is pending against the petitioner. Push up. Learned counsel submits that the petitioner seeks to perform Hajj and as Petitioners seek to perform Hajj, comma, which is a religious rite, and as such, the same ought not to have been denied. Full stop. Next para. Learned counsel for the respondent authorities. Article line kore do. Learned counsel for the petitioner cites two coordinate bench unreported judgments of this court in support of his proposition. Full stop. Next para. Learned counsel appearing for the respondent number 4 places reliance on a notification issued by the Ministry of External Affairs bearing notification number G full stop S full stop R 570 within bracket cap E bracket close dated August 25, 1993, in which a relaxation was made in the operation of the provisions of clause small f within bracket of subsection 2 within bracket of section 6 of the Passports Act 1967 to the effect that if an order stroke permission is obtained by the concerned person against whom a criminal case is pending, comma, from the jurisdictional criminal court, comma, the passport authorities shall accordingly grant permission to travel in terms of the said permission granted by the jurisdictional court. Full stop. Next para. A perusal of the first judgment of the coordinate benches in the matter of HON'BLE Islam indicates that the learned single judge had taken into consideration the concerned concerned notification and had directed the passport authorities to issue passport to the petitioners therein, considering the relevant provisions of the 1967 Act and the notification. Full stop. Next para. Thus, comma, nothing is indicated or held in the said judgment to negate the effect of the concerned notification, comma, which the Ministry of External Affairs has the authority to issue. Full stop. In the second judgment, in the case of Nirmal Mondal versus State of West Bengal and others, comma, the learned single judge merely followed the proposition laid down in HON'BLE Islam Supra and reiterated the same. Full stop. Next para. A careful scrutiny of the notification dated August 25, 1993 indicates that the same is not by way of a stringent provision, but rather a relaxation to the provisions of section 6 within bracket 2 within bracket F of the Passports Act 1967, comma, full stop. The said section provides that the passport authority shall refuse to make an endorsement for visiting any foreign country on any of the grounds following thereafter, comma, including that proceedings in respect of an offense alleged to have been committed by the applicant are pending before a criminal court in India. Full stop. Next para. The notification in question provides that citizens of India against whom proceedings in respect of an offense so alleged are pending are exempted in case they can produce orders from the court concerned permitting them to depart from India, and stipulates the periods in consonance with the said permission. Full stop. Next para. Thus, comma, the remedy before the petitioner lies in obtaining a permission from the jurisdictional criminal court where the criminal trial against the petitioner is now pending. Full stop. Next para. Accordingly, WPA 4772 of 2024 is disposed of by granting liberty to the petitioners to approach the jurisdictional criminal court where the criminal trial is pending against the petitioners for the purpose of obtaining a permission in terms of the contemplation of notification number GSR 570 within bracket cap E bracket close dated August 25, 1993, issued by the Ministry of External Affairs. Full stop. If such an application is made before the jurisdictional court by the petitioners, comma, the said court, comma, it is expected, comma, shall decide on the said applications within a week thereafter. Full stop. In the event a favorable order is passed in favor of the petitioners by granting the petitioners permission to leave the country, comma, the petitioners will be at liberty to approach the respondent number 4 for the purpose of renewal of their request for issuance of passport. Full stop. If so approached, comma, the respondent number 4 shall expeditiously decide on the same, comma, preferably within a week thereafter, comma, keeping in view the urgency involved due to the oncoming Hajj. Full stop. No orders to cause urgency.
Gratefully.
Parties shall act on the server copy of this order. একটা করে দেবেন। Thank
Gratefully.
you, thank you. এটা ফের বইটা ফেরত দিন দিয়ে জেরক্স করে দিন আমাকে। কি কি বই ওটা ওদের লালটা বিল্টু দিদি ও কোন বইটাই আমাদের না
19.
I appeal for the petition.
Yes, please.
Actually, I'm appealing for the respondent bank.
Right.
In this case, the petitioner obtained loan from Bank of Baroda.
Yes.
Thereafter, due to some difficulties and COVID situation, defaulted. And bank issued Surfacey application, bank issued under the Surfacey Act for auction sale. Petitioner challenged the auction sale before the DRT and they were stayed. And thereafter, conversation was going on. Ultimately, the petitioner approached a one-time settlement OTS proposal, 24 lakhs, something else, and which has been accepted by the bank and page 12, my lord. Thereafter, my lord, after payment of that amount, the bank is withheld the original, not returning the.
What is the receipt of payment? What is the receipt of payment?
Acknowledgement at page 12, my lord.
Page 12. Yes.
Minal Kanti Das Gwin has repaid.
This is a fresh OTS proposal.
Provisional of notice certificate. Mr. Minal Kanti Gwin has repaid the loans by paying total outstanding.
Oh, I'm sorry. I was looking to page 11.
Yes.
Right. Oh, very well. Yes. Yes, what is your...
Not, but ultimately, my lord, I continue submit your lordship.
They have issued?
No. After filing, they have issued. The no subject dues will be issued and subject to withdrawal of the retribution. By this time, retribution is filed. But till that is issued.
No, that cannot be a condition. I'll impose cost on your bank for imposing this condition.
Sir,
You cannot coax them.
8th March issued.
You have not issued the no dues certificate and you insist that they have to withdraw the writ petition for issuing that no dues certificate.
Lordship, kindly.
Impose exemplary cost on your client.
Lordship, kindly come to this point 2 of this terms and condition, Lordship.
Page 11.
No, Lordship. I'm
This.
just handed over to this later, Lordship.
Page, yes, 2.
Lordship, border. This is this terms and condition of the sanction of the no due certificate, Lordship. 8
To a no due certificate immediately.
Lordship.
Then it counts.
And return the original deed. Is very difficult. Original deeds are lying with the bank.
Original deeds also you have to return.
Lordship, I will. Lordship.
The grievance of the petitioner, comma, who was a debtor of the respondent bank, comma, is that despite a one-time settlement having been arrived at between the bank and the petitioner having paid all dues, comma, the no dues certificate and or title deeds of the petitioner which are kept as security with the bank are not being issued / returned in favor of the petitioner. Sub next para, during pendency of the writ petition, a communication was made to the petitioner by the bank insisting upon withdrawal of the writ petition as a precondition of issuing such no dues certificate. Sub next para, learned counsel for the bank submits that among the terms and sanctions of the one-time settlement was that the borrower was to give unconditional undertaking while accepting sanction that they will withdraw all the legal / other cases at various forms against the bank and they will not file any claim against the bank. Next para, however, comma, the present writ petition cannot be governed by such terms and sanction for the simple reason that the writ petition has been filed on the very premise that the bank is not honoring its commitments despite the petitioner having fulfilled the petitioner's part of the one-time settlement. Next para, the present writ petition is not a legal claim and or case pertaining to the amount due, but rather to enforce the one-time settlement between the parties. Thus, comma, the insistence of the bank for the petitioner to withdraw the writ petition is arbitrary, comma, illogical, and contrary to settled principles of natural justice. Be that as it may, comma, WPA 5256 of 2024 is disposed of by directing the respondent bank to immediately issue a no due certificate in favor of the petitioner and return all the title deeds which were deposited with the bank by the petitioner as security deposit for the loan which has already been settled by the petitioner. Push up, the such return stroke issuance shall be completed within an outer limit of a fortnight from date. No less to court certificate.
Lordship.
Thank you.
Oblige, Lordship.
I am for the petitioner, my lord.
Yes, Mr.
My lord, matter relates to, my lord, the gun license, revocation of gun license, my lord. Now, it is my only survival because I am a ex-army. I have got gun license after my judgment, and now I am running, I am employing as a security guard, my lord. Due to revocation of gun license, my lord, my life.
Why was it refused?
Because of, my lord, one criminal case under section 354.
What is
Well,
section 352?
What is outside of what is
354. Lord, your lordship kindly,
And my lord, one
your
thing, my lord.
lordship knows, but it
lord.
has been seized.
My lord, one thing.
And Lord,
No, let him.
Well, I am very candidly one submitting your lordship, my lord, because
No,
yesterday,
hold on.
like this matter, my lord, I have already preferred appeal before since the statutory appeal is there. But my lord, I come up with your lordship, my lord, only one ground that there was natural justice was violated, but without giving any opportunity of hearing, the order was
You were
passed.
convicted by the first court.
No, my lord, no conviction is there, my lord. Only criminal case pending.
What is the appeal against?
Appeal for revocation of license, my lord.
Oh, before the appellate authority?
Yes, my lord. I have approached, my lord. Because I should be candid before.
Oh, you
lord,
have to
because I
approach
should
before
not
that.
suppress anything.
He cannot approach both forums. So, I'll give him liberty to pursue that appeal.
But,
Writ petition does. No, I'll not go into the merits, Mr.
report because it has been seized in Alamat and he has no, he has a forum
I'll
because
just
he-
reject this writ petition, give him liberty to pursue the appeal because two remedies, this is forum shopping on part of the meeting.
But that's and first prayer, your lordship, kindly the return of the blood gun, arms. Blood,
The
that cannot be
petitioner
because-
alleges.
because blood, the criminal court.
Mr. Banerjee, you don't understand. You will understand once I pass the order.
Well,
The petitioner alleges that the petitioner's gun license was cancelled due to apparently due to a criminal case pending against the petitioner. Push up. Learned counsel for the petitioner candidly admits that the petitioner has also taken recourse to the appellate provision under such cancellation. Push up next para. Learned counsel appearing for the respondent authorities seeks to produce documents and submits that the cancellation was valid in law. Full stop. However, the petitioner cannot be permitted to forum shop by pursuing the same remedy before the appellate authority as well as the writ court. Full stop. Upon query of court, the learned counsel for the petitioner on instruction submits that the petitioner shall pursue the appeal.
I have already preferred for appeal.
Pursue the appeal. Pursue the appeal, which has already been filed. Push up. In fact, the said option is the prudent one since the petitioner otherwise would be the parties, otherwise, would be deprived of a forum. Push up. Accordingly, WPA 5592 of 2024 is dismissed as not entertained with liberty to the petitioner to pursue the self-same remedy in the pending appeal at the behest of the petitioner. Push up. It is made clear that since affidavits have not been invited, none of the allegations made in the writ petition are deemed to be admitted by the respondents. Push up this court, it is made clear, has not gone into the merits of the contentions of the parties at all, and it will be open to the appellate forum to decide all issues independently in accordance with law.
One in just one time frame.
It is expected that the appellate authority shall decide the appeal as expeditiously as possible, preferably within 1 month.
1 month.
Blood, 1 month.
Yes,
blood,
not
I have
only
no
also pass the
instructions.
same
Blood,
order.
1 month. What is the stage? I do not know. But instead of 1 month, your lordship kindly give some time.
Well, my livelihood is at
All right,
stake, my lord.
within some time.
Well, my livelihood is at stake, my lord.
Sometime.
It is my only.
Decide within some time.
Well, yesterday already 1
But
month.
within some time, not later than 1 month.
Not later than 1 month. 2 months, your lordship kindly will. And
If you
blood,
want-
written instructions be kept on it.
No, keep it with. Yes. Next. Who is appearing?
I am for the petition, Lordship.
What is the matter, Mr. Haldar?
For the electricity matter, Lordship, this is my affidavit of service. There are 3 private respondents. Lordship, one has accepted, one has refused, and other is addressee cannot be located.
They are related? No.
No, they are neighbors. The service connection, Lordship, complied with all the formalities. CSC authority went for installation.
Yes,
but
what
due
is
to
the
their
difficulty?
objection? Our neighbors, they are three types. Right, the effect supply because of the obstruction made by the private.
Inspection has been held.
Quotation has been deposited, Lordship. Complied with all the formalities.
Affidavit of service filed today be kept on record. For so it transpires that all the two of the private respondents have been served, comma, one could not be served conclusively. Full stop. Next para. However, comma, the gamut of the dispute involved is that the petitioner has already complied with formalities, but no electricity connection could be given to the petitioner by the CSC Limited due to obstruction by the private respondents. Full stop. No written objection has been given by the private respondents, comma, nor are any of the served private respondents represented today. Full stop. Next para. Since there is nothing on record or before the CSC Limited to indicate the exact ground of such objection being raised by the private respondents, comma, the petitioner, comma, being in settled occupation of the property prima facie, comma, is entitled to the electricity connection as sought. Full stop. Accordingly, WPA 5663 of 2024 is allowed, comma, thereby directing the CSC Limited to give a new electricity connection to the petitioner from the existing meter board position at the premise. Oh,
Main service
to give a new service connection to the petitioner at the premises in question within a fortnight from date positively. Full stop. If any obstruction is raised by the private respondents and or their men and agents in doing so, comma, the CSC Limited will be at liberty to approach the respondent number 3, that is the officer in charge of the Ekbalpur police station, who will provide adequate police assistance to the CSC personnel to ensure access to the CSC personnel at the cost of the petitioner. Full stop. If need be, comma, the police personnel will be at liberty to remove any padlock or other hindrance if put up to obstruct the CSC from reaching the location in question. No orders to cause urgent certified copies. Parties shall act on a server copy of this order.
Grateful. Ahmed Ali.
22.
I am for the petition, Lordship. Lordship, the submersible pump connection, Lordship, petitioner deposited the quotation amount. Primarily, the connection was given by temporary means.
Bamboo pole.
Bamboo and everything. Thereafter, petitioner approached the grievance redressal officer due to the non-availability of the permanent connection.
Yeah, from the bamboo pole or gave a permanent?
Yes, GRO has passed order
What did you do? What is it?
to within 2 months to give the connection with
Permanent connection.
permanent means. Lordship, page number 14.
Yes, bamboo, exactly.
Page number 14, Lordship. The ordering portion of the GRO.
Yes, Mr. Mukherjee.
Now,
Give a proper structure. I mean, why this peculiar preference for bamboo for the WBCDCL?
No, when
Every time you give a bamboo structure through a bamboo structure first, then a wooden pole. Why? Wood is in crisis, or there is an abundance of bamboos.
That chapter I can. What happened, but I will first say, this writ petition, but petitioner himself made an application before the authority saying that these are the person who are making obstruction. Because when we put kindly see Bibadi Pokko, this is the application filed by Mohammad Ali.
Before GRO?
Before the station manager. And kindly see the date. Ahmed Ali. This is filed by the Ahmed Ali.
Who is Ahmed Ali?
Ahmed Ali is the petitioner.
Yes.
Kindly see Bibadi Pokko. The names are there. They are raising obstruction for installing the pole. Now, there are two options. Either let them meet party or kindly send the matter to the district magistrate, because they are saying this is their land. Petitioner is saying that the pole will be installed. That is not the land of these objectors. But this is
already given a connection through
Connection
bamboo.
is already there.
Initially there was a bamboo. Now, if we install the permanent pole, these persons are saying that this land belongs to them, and he knows that, and that's why he filed this objection.
Rule 3. Learned counsel.
My instruction is that already connection is existing there.
My instruction is also that.
Lordship, WBA.
Learned counsel for the petitioner submits that the petitioner sought for an electricity connection to operate his submersible pump, which was given by the WBSCDCL, but via a bamboo pole, which is temporary in nature. The petitioner subsequently approached the grievance redressal officer, who directed to convert the temporary bamboo structure to a permanent infrastructure with PCC poles and matching materials within a maximum period of 2 months from the date of issue of the order. However, such connection is not being given by the CSC limit, WBACDCL. Learned counsel for the WBACDCL hands over a copy of a communication made by the petitioner himself indicating that there was obstruction on the part of several third parties regarding regarding installation of electricity pole. It is submitted that the said obstructors claim that the pole is to be installed over their property, to which they have objection. Next para. A perusal of the order of the grievance redressal officer indicates that the chapter is closed regarding giving electricity connection to the petitioner. Moreover, the petitioner is already enjoying a temporary connection through a bamboo structure, and the grievance redressal officer has merely directed the same to be given the color of permanence. Next para. In any event, if the WBACDCL personnel are obstructed by any third party while giving the connection, it is always open to the WBACDCL, as a distribution licensee, to take recourse to Rule 3 of the Works of Licenses Rules 2006. Next para. In such view of the matter, WPA 5671 of 2024 is disposed of by directing the WBACDCL to immediately comply with the order of the Regional Grievance Redressal Officer, Murshidabad Region, WBACDCL, annexed at page 14 of the writ petition, by converting the temporary bamboo structure to a permanent infrastructure with PCC poles for giving electricity connection to the petitioner, with matching materials. Such connection shall be given within a month from within a fortnight from date. In the event any obstruction is faced by the WBACDCL in doing so, it will be open to the WBACDCL to approach the concerned district magistrate under Rule 3 of the Works of Licenses Rules 2006 for an appropriate permission. In case such an approach is made, the said district magistrate, it is expected, shall resolve the issue within 3 weeks thereafter.
Thank you. Could I seek one enlargements?
Yes, Mr.
Item number 20. Lord, if Lordship kindly add one line, if statutory, because he has himself stated that without exhausting the statutory appeal, because his urgency, I have come up before this honorable court.
I have given him liberty. If he fails
statutory appeal, he fails. Because there is no averment, appeal filed.
He says, I have recorded. Yes.
No, Lordship kindly consider.
No, Mr. Banerjee, please. Yes.
Paragraph 14, Lord, he himself
23.
Without exhausting.
The matter is over, Mr.
Yes. But Lordship, kindly remember, Lord, your Lordship.
I have already forgotten. Yes.
Sir, for the petition, Lordship, submersible pump connection, Lordship petitioner complied with the formalities, quotation amount paid, connection
not given?
Lordship, as per my instruction, pole erection has already been completed, Lordship, and electricity will be supplied by 8th of April, Lordship.
Why 8th? Pole erection is over.
Lordship, there.
Very well.
There are some.
Learned counsel for the petitioner argues that the petitioner complied with all formalities for getting a new electricity connection, but the same has not been given. Learned counsel for the WBACDCL submits that already an electricity pole has been erected for such purpose, and the connection shall positively be given by April 8, 2024. Next para. In such view of the matter, WPA 5901 of 2024 is disposed of by directing the WBACDCL to positively give the electricity connection to the petitioner on or before April 8, 2024 by acting on a server copy of this order. No rest to cause suggestion. Thank you. 24. Yes, what is that?
AIPTV service state only. My lord, this is a question the notice issued by the my lord district register. My lord, page 54. My lord, we are the my lord MMR in district of Hooghly in different police stations.
Yes.
And we have been working, my lord, since 2017, 18, 19. But all on a sudden, this notice has been issued that we are treating as temporary. Now, applications invited for permanent appointment of Muslim registered MMR for the area under jurisdiction.
You were appointed in the first place as temporary.
That is there. That is there.
They have a right.
In the letter there is, but my
You
lord,
cannot stop that.
our case is that, my lord, long ago we have been appointed. We have also applied for consideration for granting permanent status.
No, giving preference to you, in the previous matters. Giving preference to you will open a Pandora's box. No preference to you also apply along with
Then,
the
my
others.
lord, out of 4, 2 are within age, 2 are, my lord, 2 years over age. That should be, my lord, relaxed.
Why?
Because, my lord,
How can I give a direction for
because
that?
they are already we are working in that.
No relaxation for that.
My lord, in similar situation, another order was passed.
No, if you cannot get appointment as a permanent MMR, how can you continue even as a temporary MMR? That should also be stopped.
No, we are already working.
Age relaxation, I can at best say that they will consider the provisions of age relaxation if you apply for that. Only this. I'll leave it to the discretion of the
My lord,
state.
kindly, another coordinate judge.
Yes.
Clause D to them. My lord, a similar situation occurred. 2 within age, no problem.
There the government suggested. It was the suggestion of the italics is the government suggestion.
Oh, yes,
Your
advocacy.
government is not suggesting.
But
Not suggesting.
we are already working 2 years, my lord. 40 is the last stage.
Here also they say to participate in fresh recruitment process, upper age limit, whose name is appearing in the present plan, shall be deemed to have been relaxed by the state government. That was the state itself gave an
They agree.
affidavit.
Yes, state agree.
Here the state is not agreeing. I'll direct them to consider. That I can do. But not more than that.
Yes, yes.
I'll do that.
I told the petitioners that this is a
I know you have said.
weak case.
Learned counts the petitioners, who are acting as temporary MMRs, Mohammedan marriage registrars, challenge a notice dated February 12, 2024, issued by the district registrar HON'BLE. By virtue of the said notice, applications are invited for permanent appointment of MMR in the for the area under the jurisdiction of Chinsura, within the zone where the present petitioners are already functioning. It is argued that the petitioners have long been performing their duties as temporary MMRs and should be given a preference. That apart, out of the petitioners, some have exceeded the upper age limit.
2 and 4. Petitioner number 2 and 4.
Out of the petitioners, some within bracket petitioner numbers 2 and 4 bracket closed have crossed the upper age limit for participation in the permanent appointment process. It is argued that they should be given a relaxation which is permissible under the regulations, under the law. Learned counsel for the state, heard learned counsel for the state. The petitioner has cited an unreported judgment of a coordinate bench in Mahirul Sheikh versus State of West Bengal and others, where it was recorded by the learned single judge that the state government itself had filed an affidavit where it was suggested that the persons already acting as Mohammedan marriage registrars would be given an opportunity to participate in the fresh recruitment process, and the upper age limit of candidates whose name are appearing in the present panel shall be deemed to have been relaxed by the state government, and their candidature shall be considered if they are otherwise suitable for appointment as MMR. Next para. However, similar affidavit has not been filed in the present case. Be that as it may, since the petitioners have already been acting for long as temporary MMRs in the area in question and have gathered considerable experience in the field, it would only be exigent for the state to consider the issue of relaxation of age, which is permissible under the law, for petitioner numbers 2 and 4, in respect of all the petitioners, the petitioners are definitely entitled to participate in the fresh invitation for permanent appointment of MMR by virtue of the notice dated February 12, 2024. Accordingly, WPA 6043 of 2024 is disposed of by granting liberty to all the petitioners to participate in the invitation issued by the impugn notice dated February 12, 2024 for appointment of permanent MMRs for the area in question, full stop, with regard to petitioner numbers 2 and 4, comma, if the said petitioners approach the respondent authorities for relaxation of the upper age limit, comma, the said request shall be considered sympathetically by the respondent authorities, keeping in view the fact that the said petitioners have been acting in the capacity of temporary MMRs for a considerable period of time. Full stop, no others to cause urgency.
I'm extremely grateful.
May I point out?
ঠিক আছে।
It is my duty.
As per division bench order is.
Division bench order, this issue has already been decided.
No, notice.
What has been held?
No, that is.
No, what has been held?
May I hand over a judgment of the division bench, Your Lordship? Kindly see a few paragraphs. That is page number 2. আমি দিয়ে দিচ্ছি। Submission of learned counsel for the appellant is that the appellant is now overaged. Therefore, he cannot participate in the process of appointment on permanent basis. Therefore, he should be allowed to continue up to the age of 68 years. Similar is the submission of learned counsel for the applicant in Can 1 of 2022, which has been filed by similarly situated temporary appointees in other areas. Now, kindly come to the bottom paragraph, Your Lordship, which starts with undisputedly.
Let us not look into this. I've passed my order.
I am grateful, extremely grateful.
That's why I've left the discussion on. I've left the discussion on you. You can consider this.
আচ্ছা ঠিক আছে নিয়ে নিন।
Oh, ভালো। I'm grateful.
Thanks.
For Your Lordship.
I'll take up the next matter after 5-6 minutes.
চলো।
25. Yes.
Ma'am for WS.
Yes.
Your Lordship, I'm appearing for the petitioner.
What is the matter?
Your Lordship, first of all, I would like to hand over the affidavit of service served upon the respondent.
All have been served?
All have been
Right. What is the matter?
Your Lordship, this matter pertains to the electricity connection being disconnected of the petitioner by the responding authority in a very arbitrary and unjustified manner. Your Lordship, before I place my submission, I would like to draw your kind attention to Annexure 9,
Page?
page 69, Your Lordship.
Yes.
Your Lordship, I would like to indicate point 3.5, payment of disputed bill. Under that, 3.5.1 and 3.5.2. It states that if I'm reading 3.5.2, Your Lordship,
Very good.
if any aggrieved consumer makes a provisional payment as aforesaid, no penal measures, including disconnection, for the non-payment shall be taken against him till the dispute is settled either at the level of grievance redressal officer or at the central grievance redressal officer or ombudsman, as the case may be, Your Lordship. Your Lordship, it is pertinent to mention over here is that the petitioner already paid a provisional payment of 10,000 rupees. Thereupon, his connection was disconnected. Also, when the matter is pending before the adjudicating officer and the competent authority, redressal officer, it is pending for disposal and adjudication.
It is still pending.
It is still pending, Your Lordship.
That is your challenge. They could not have disconnected.
They could not have disconnected, and now they are without any electricity connection.
Yes. So you place reliance on 3.5.2.
Lordship.
Anything else?
Your Lordship,
Yes.
the crux of the matter over here is that the petitioner belongs to a weaker section of the society.
How?
He works as a security guard, and now he obtained the connection in the year 2016. Thereupon, no electricity bill was generated in his name. And after a span of 6 years, suddenly, like from 2020 to 2018 March to 2024 February, suddenly the responding authority is coming and issuing the bill for a payment of some 33,217. And for a span of 6 years. In between 6 years, the petitioner did go to the responding authority asking for the issuance of the bill in his name. But every time he was maltreated, dismissed from the office at one go.
You obtained the connection exactly on what date?
2016.
When was the bill started, the first bill issued to you?
No bill was generated.
No, this amount was claimed from you when?
Yes. I'm showing you. I'm showing your Lordship. No. Electricity. Your Lordship, it was generated March. It was generated on 5th of December 2023.
This is the first time any
bill was generated in his name.
Do you
Span of
disputed
6 years.
that before the grievance redressal officer?
It was disputed.
Very good.
Also, it was also mentioned before this adjudicating officer that after this, the matter was pending. They could not have disconnected the electricity connection.
Understand? Yes, that point you have taken already. So 56.2 also probably there's a bar. These are your arguments.
Yes. Also, Your Lordship, I would like to point, as we all know, Your Lordship, that under 56, of electricity.
That is not an also. That's
Yeah,
that
Your
I
Lordship.
yes.
The petitioner was not even afforded 15 clear days notice before the disconnection. Disconnection notice. Lordship, I would like to draw your kind attention to Annexure 7, page 53, Lordship. Annexure 7, page 53.
Yes.
Your Lordship, kindly note that according to the responding authority, this is a deemed disconnection notice. But Your Lordship will kindly appreciate the matter that the subject of the letter says reply letter. Whereas it should have been, if it had been, for the sake of argument, even if I consider this is a deemed notice, it should have had the deemed notice as the subject letter. Also, it does not even bear the proper consumer number, nor does it bear how much arrear is due or which is to be paid by the petitioner, Lordship.
No, where is the claim? The show me that claim. 33,000 something. What is that bill?
Impugning. Lordship, it is in Annexure P2, page 30.
This is the disputed bill.
This is the disputed. When he went to the office, he was handed over this impugned installment bill. And he was asked to pay the bill in just 3 installments. When he paid the first installment of 10,000 rupees, subsequently, it was disconnected. Electricity connection was disconnected.
Because you failed to pay the second installment.
Because he failed to pay the.
You agreed to this?
Yes.
No, it was not agreed because he already made representation to the competent authority. As per the Gazette, because he made
Why did you
provision
pay the
for-
first installment?
because he was forced, like he was under threat
When did you prefer the challenge? Before the GRO?
after payment of the first installment.
Immediately after.
Nothing has been specified.
So let me hear them then. Yes, Ms. Dr. Shara.
So far, man, there is a history on that. So far, this letter itself, that your lordship kindly come to page 30.
Take your seat. Yes.
Page 30, it is very much crystal clear. He agreed to pay that amount. Since 2013, they agreed, they enjoyed the electricity. What happened, man, there is certain aspect which is my duty to bring to your lordship.
13 or 16?
2013, lordship. They have said 2016. But from 2013 to 2023, they have enjoyed consumption of electricity without paying a single penny.
How do you get over 56.2?
I am coming to that. I am coming to that, lordship. It was not registered. And subsequently, when he came 56.2, lordship will find that he was ready and eager to pay that amount. If you can, lordship, kindly come to page 30. But this is a very important letter. This is the letter where they have agreed to pay in 3 equal installments. And kindly come to the next part, in the bottom part, which is well within their knowledge. Late payment surcharge has not been included.
What is their agreement?
But agreement means?
You said they have agreed to pay.
Yes, they have paid the 10,000 amount. They have made.
This is their agreement, yes.
Yes, and not only that, now should kindly see note 2. This is very important. Failure of installment payment within due date, as stated above, will lead cancellation of installment order and disconnection of supply without any further notice. Now, lordship will find that they have, once they have agreed to pay it, and they have acknowledged the due. Now, this 56.2 will not come into play on that basis, since they have agreed to pay that amount. And subsequently, your lordship will find that several notice thereafter has been given to them for making payment. They sat tight over this matter. And all on a sudden, they said that we are not ready and eager to pay that amount. And subsequently, they have failed to make that payment. And we have to disconnect that amount. Because your lordship, it is very much crystal clear from this notice itself that failure of installment payment in due date, they have agreed. Not a single letter.
Dr. Shah, anything else?
But this part, and lordship, kindly see that I have to say something on that aspect, that they have enjoyed electricity initially from 2013. And it was under the jurisdiction of Rajarhat CCC. Now, subsequently, it has been demarcated, that is bifurcated in 2 parts. One Rajarhat CC, and thereafter that is on the Lauhati CC. Now, they have been giving electricity under the National Rural Electrification Scheme. And on that, it was not registered. Their name has not been registered, not for a single time. As a responsible citizen, they come before us and say that my bill has not been registered. You take my bill. Nothing else. On inspection, we have found in the 2023, on 22/5/2023, we have gone there. We have inspected and we have found that it has not been registered. We have requested him several times to make payment. Thereafter, he agrees to make payment. And on that basis, that is on page 30, he has agreed to make them on the 3 installments. He paid the 10,000 amount, and subsequently, he agreed to pay the subsequent installment. And in the notice, it is very much crystal clear, your lordship. Thereafter, 15 days, more than 15 days has been given to them to make payment.
but they failed to make payment and we have disconnected it on 6th of February 2024. So much
How do you
after.
get over this provision which they have cited 3.5.2?
But 3.54 here, he has to specify that without prejudice to my right and contention, I am making payment. And I am going before the GRO for raising this dispute. No dispute has been raised at that point of time when this notice has been issued and when he has made that payment. Not a single letter has been issued there specifying that without prejudice to my right and contention, I am paying this bill. Nothing has been made. He has paid that bill and he is ready to pay that bill. He has subsequently agreed to pay the bill. Now he is coming up with the new story. Now, Lordship, in that we have given several notice on that and we have already issued the notice that already notice, it is a deemed notice. And that 8.3, it has been specified if I go to GRO, then I am ready to pay that provisional bill without prejudice to my right and contention and I will ventilate my grievance. But Lordship, kindly see, he has paid that amount and never raised that said that without prejudice to my right and contention, I am making payment. Not a single letter has been given, Lordship.
Let me pass my order now. Ash. The petitioner, learned counsel for the petitioner submits that the petitioner comes from the marginal sections of society, comma, employed as a security guard. Whose next para? The petitioner has been enjoying electricity connection since the year 2016.
2013, Lordship.
Mr. Dr. Sharai, please don't disturb. I'm recording the submission. Please take your seat, Dr. Sharai. Don't do this ever. Since the year 2016, full stop. However, comma, the petitioners were not charged with electricity bills all along. Before a composite bill was raised, apparently for the period between March 2018 to February 2024, comma, on December 5, 2023. Full stop. Next para. Only 3 installments were given to the petitioner. Full stop. Subsequently, after payment of the first installment, comma, the petitioner approached the concerned grievance redressal officer. Full stop. During pendency of the said challenge, comma, however, comma, the electricity connection of the petitioner was disconnected without 15 clear days notice being given by the WBSCDCL. Full stop. Next para. Learned counsel for the petitioner argues that apart from the fact that the claim of the WBSCDCL was palpably time-barred under section 56 within bracket 2 of the Electricity Act 2003, comma, no clear 15 days notice was given, comma, thereby vitiating the disconnection. Full stop. More importantly, comma, it is pointed out that in terms of clause 3.5.2 of regulation 55 of the WBERC dated August 7, 2013, comma, if any aggrieved consumer makes a provisional payment, comma, no penal measure including disconnection for non-payment shall be taken against him till the dispute is settled either at the level of the grievance redressal officer or the central grievance redressal officer or the ombudsman, comma, as the case may be. Full stop. Next para. Learned counsel appearing for the WBSCDCL argues that the petitioner himself agreed to comply with the claim of the petitioner. Full stop. Such admission is evident from the very fact that the petitioner paid the first installment of rupees 10,000 in terms of the installment bill dated December 5, 2023. Full stop. It is contended that in the said bill itself, comma, it is clearly indicated that failure of installment payment within due date, as stated therein above, would lead to cancellation of installment order and disconnection of supply without any further notice, comma, thereby obviating the necessity of any further notice in any event. Full stop. Next para. Having taken advantage of the said installment bill, comma, the petitioner cannot now resile from such position by pleading the bar of section 56 within bracket 2 of the 2003 Act. Full stop. Next para. Learned counsel for the WBSCDCL further points out that the petitioner had enjoyed electricity not from the year 2016 but from the year 2013 under a particular prevalent scheme. Full stop. However, comma, the petitioner did not ever come up before the first installment bill was raised, comma, seeking to pay the electricity charges due from the petitioner. Push up next para. It is submitted that such malafide intention of the petitioner ought to be deprecated. Push up next para. Learned counsel for the petitioner, however, controverts the fact that the petitioner never approached the WBACDCL and argues that the petitioner made several communications to the WBACDCL asking for bills which was not complied with by the WBACDCL. Push up next para. There are three issues which are involved primarily in the present case. First up, the first issue is the alleged violation of clause 3.5.2 of regulation 55 of the WBERC. Push up next para. The WBACDCL has, comma, in defense, comma, pleaded that the payment of the first installment by the petitioner was not a qualified payment, comma, whereby the petitioner indicated that the same was a provisional one. Pushed up next para. As such, comma, the provisions of clause 3.5.2 cannot apply in the present case. Pushed up, however, comma, such argument is not tenable in the eye of law due to the chronology of events in the present case. Pushed up, although the petitioner, comma, obviously under compulsion of threatened disconnection, comma, paid the first installment of rupees 10,000, comma, before making payment of the other remaining two installments, comma, the petitioner duly approached the appropriate grievance redressal officer, comma, thereby clearly indicating the petitioner's intention that the first installment, comma, which was already deposited, comma, was by way of a provisional payment. Pushed up next para. Nothing in clause 3.5.2 necessitates that the aggrieved consumer has to indicate in the payment, with the payment, that the payment is provisional in nature. Pushed up, the circumstances of a case are sufficient indicators of the conduct of the parties and their intentions. Pushed up, in the present case, comma, the very fact that the petitioner had approached the grievance redressal officer immediately after paying the first installment is sufficient to clinch the issue in favor of the petitioner to the effect that the payment made was provisional in nature. Push up next para. Thus, comma, there cannot be any doubt that the disconnection is bad on such score alone. Push up next para. However, comma, there is a dispute regarding whether 15 clear days notice was given to the petitioner. Pushed up, the installment bill, double inverted with the installment bill dated December 5, 2023, annexed at page 30 of the writ petition, comma, in any event, comma, cannot qualify as a valid disconnection notice. Pushed up, the clause of disconnection mentioned therein was merely a rider which was a component of the installment terms between the parties. Pushed up next para. Hence, comma, the same cannot be construed to be a disconnection notice within the contemplation of the 2003 Act and or the extant regulations. Pushed up, be that as it may, comma, since a cloud has been sought to be cast on whether independently also other disconnection notices have been issued, comma, even without going into the said issue, comma, there is one other major factor which interdicts the claim of the WBACDCL. Pushed up next para. Section 56 within bracket 2 of the 2003 Act, comma, in no uncertain terms, comma, stipulates that notwithstanding anything contained in any other law for the time being in force, comma, তারপর double inverted, no sum due from any consumer, comma, under this section shall be recoverable after the period of 2 years from the date when such sum became first due, double inverted close. Full stop. The rider thereto that the sum had been shown continuously as recoverable is not applicable here, comma, since it is the case of neither party that the amount due was shown prior to the raising of the installment bill dated December 5, 2023. Full stop. Next para. The language and manner in which subsection 2 of section 56 is couched makes it mandatory, makes the time bar mandatory in nature. Full stop. Next para. There is no scope of waiving a right which is conferred by the statute in an unqualified manner. Full stop. Rather, comma, section 56 within bracket 2 is not a right conferred on the consumer which might have been waived by the consumer, but a fetter cast on the distribution licensee which, comma, if waived, comma, could only have been by the distribution licensee. Full stop. Next para. Hence, comma, there is no scope of the consumer to waive a right which is not conferred by the statute at all. Full stop. Section 56 within bracket 2 is not a right, comma, it is repeated, comma, but a fetter on the claims being made by the distribution licensee, which is absolute, since the provision provides that no sum as spoken of therein, comma, shall be recoverable. Full stop. The use of the expression double inverted shall is completely mandatory and cannot be resiled from. Full stop. Next para. It is too well settled to reiterate that a legal fetter cannot be waived by agreement of parties. Full stop. Next para. The bar under section 56 within bracket 2 is an absolute bar, and in the event other conditions of the said provision applies, comma, the claim of the distribution licensee is clearly barred under such count. Full stop. Next para. Even if there was a subsequent addition to bills already raised, comma, which is not the present case, comma, it has been well settled that the distribution licensee could not disconnect the supply as a penal measure. Full stop. More so in the present case, comma, where the claim itself is substantially barred, comma, except for the last two preceding years immediately before the bill was raised for the first time. Full stop. Next para. Hence, comma, the petitioner has a strong prima facie case to move the grievance redressal officer. Full stop. Since such challenge is already pending before the grievance redressal officer, comma, there could not have been any occasion for the WBACDCL to disconnect the electricity supply of the petitioner, both in terms of clause 3.5.2 of regulation 55 and in view of a substantial portion of the claim being palpably time barred. Full stop. In such view of the matter, comma, the disconnection effected by the WBACDCL is required to be reversed. Full stop. Accordingly, WPA 6139 of 2024 is allowed on contest, comma, thereby directing the WBACDCL to immediately restore the electricity connection of the petitioner, comma, latest within 48 hours from now, comma, without asking for any reconnection charges or further charges whatsoever. Full stop. Next para. However, comma, such reconnection shall be subject to the outcome of the adjudication by the grievance redressal officer, or, comma, if either of the parties are aggrieved against the same, comma, before the ombudsman. Full stop. Next para. It is further made clear that this court has not dealt with the merits of the challenge pending before the ombudsman apart from the issues which have been directly touched in the above order. Full stop. It will be open to the ombudsman, to the grievance redressal officer to decide all issues in accordance with law as expeditiously as possible. Full stop. The connection being given to the petitioner, comma, however, comma, shall be subject to regular payment of the current bills now raised by the WBACDCL. Full stop. The WBACDCL shall not club the outstanding dues which were raised by the impugned installment bill dated December 5, 2023 in the garb of current bills till an adjudication is arrived at by the grievance redressal officer and subject to such adjudication. Full stop. The WBACDCL shall give due adjustment to the amount of rupees 10,000 already paid to the WBACDCL by the petitioner, comma, in terms of the provisions regarding thereto, comma, if made by the order of the grievance redressal officer. Full stop. No address to cause urgency.
So far, Your Lordship, the second installment, after failure of second installment, they have gone to the grievance redressal officer.
You said first?
No, Lordship, kindly see that notice that they on the 5th of January, they have to make that payment. They failed. And subsequently, after 15 days, they have raised this before the GRO. But this is the conduct, Lordship. Not a single payment has been made, and they have nothing is on record.
Second installment payment.
After 15 days of, sir.
1 minute. You paid 10,000. You made the second installment. Paid the second installment also.
No.
No.
First and 5th of January 2024, the second installment due was there.
No, they made only one installment.
One installment.
And that is what I've said.
No, so for the grievance, they have gone before the GRO
Yes.
after default of the second installment, Lordship.
I'm not on default. They have paid only one installment. I
That's-
said that in
that's-
my order.
That's
They have
ridiculous.
paid that on 5th.
Well, Dr. Sahara, I have passed my order.
Lordship.
Next.
Much obliged.
Thank you. Yes.
Your Lordship, I am the
26.
petitioner.
Yes.
State doesn't.
Yes. What is the matter,
This
please?
is the affidavit of service. Your Lordship, this is an application for
Section 14.
Section 14, Your Lordship. No section 17 is filed or served.
All right.
for-
Borrower has been served.
Your Lordship,
Borrower
borrower
served.
has been served. One has been served. Two has come as left.
Although one of the borrower's respondents have not been served properly, comma, the other has been pushed up in any event, comma, the nature of the prayer involved does not demand an adjudication of the respective rights between the petitioners and the private respondents. Full stop. The petitioner number 1 bank seeks implementation of the law inasmuch as the application of the petitioner number 1 bank under section 14 of the Surfacey Act 2002 has been kept pending by the concerned district magistrate for over the outer statutory limit. Full stop. Upon hearing learned counsel for the petitioner and the state, comma, it transpires that there is substance in such contention of the petitioners. Accordingly, WPA 6027 of 2024 is allowed, comma, thereby directing the respondent number 2, that is the district magistrate, North 24 Parganas, to dispose of the application filed by the petitioner number 1 under section 14 of the Surfacey Act 2002 as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the respondent number 2. No address to cause urgency.
Yes.
Thank you.
27.
Yes.
Uh,
You're for the respondent?
Yes, number 2.
Number 2, yes.
For Mednipur, Milo, that's
Right.
the Lordship.
What is the matter? Section
Lordship,
14?
Section 14.
No section 17 pending.
No, Your Lordship. The
Service?
yes.
All served?
Yes, Your Lordship, the state has been served.
What state? The others?
Yes, Your Lordship, it has been served, but it's showing that it's dispatched. Item has been dispatched.
Affidavit of service filed today be kept on record. Although although service has not yet been completed on the private respondents, comma, the matter is not adversarial inasmuch as the petitioners seek implementation of the concerned statute insofar as the application under section 14 of the Surfacey Act filed by petitioner number 1 has not yet been disposed of, comma, despite having exceeded the outer statutory limit. Pushed up. Upon hearing learned counsel for the petitioners and the respondent number 2, comma, WPA 6500 of 2024 is disposed of by directing the respondent 2, that is the district magistrate Purbo Medinipur, to dispose of the pending application at the behest of the petitioner number 1 under section 14 of the Surfacey Act 2002 as expeditiously as possible, comma, positively within 4 weeks from date. No address to cause urgency.
Grateful, Your Lordship.
Yes.
28.
28 will I for the state, Lordship.
None appears for the petitioner, although the state is represented through counsel. The matter shall now be listed under the regular heading
Lordship.
in the monthly combined list of April 2024.
Grateful.
Board function ko chitori.
29.
I'm for the petition.
Yes, please.
This is a curious case, Madam. First, I'm
This is a?
This is a curious case, my lord. I placed my affidavit of service.
Of
but-
Benjamin Button.
No, my lord. Yes. But service upon the electricity distribution licensee is complete, my lord. The
Right.
private respondents have not been served.
Private respondent is not served.
Service is incomplete against them, my lord. I will tell you what has happened, my lord. The petitioner had entered into an agreement for purchasing a flat with the private respondents. In terms of the agreement for sale, the petitioner advanced certain monies and has taken possession. Thereafter, the petitioner approached the bank for financial institution for a loan. Loan was sanctioned, and the private respondent was invited to execute the deed of conveyance. Private respondent has refused to execute the deed of conveyance.
The agreement was registered.
The agreement for sale was not registered, my lord, unregistered. The private respondent has refused to execute the deed of conveyance and is now not, and then thereafter the petitioner is in possession of the premises, has filed a suit for specific performance before the court of Alipur, also filed a complaint with the respective police station. The private respondent has communicated to the electricity distribution company and disconnected the petitioner's electricity supply, which was on the basis of the meter, which was in the name of the private respondent.
Acha.
My lord, the petitioner is.
Can I give them liberty? Is there any bar to give them liberty to apply afresh?
My lord,
You have already disconnected.
we have disconnected in respect of the letter of 9th of November 2023 given by the
9th November 2023.
Yes. Given by the private respondent number 3. Subsequently, my lord, we received another letter that is on 17th of November 2023 not to reconnect.
To make it stronger. I mean. But I'll give them liberty to apply for a new connection. Give them a new connection.
But we can my instruction is subject to your lordship kind of approval. We since the meter is already disconnected, we can reconnect the said meter in the name of the.
You can do that.
Yes,
That's the best option.
Number 3, subject to compliance of all
But that will be treated to be a new connection, isn't it?
Yes, yes.
But it
because
has to be. Otherwise,
the meter is already there.
Yes,
As my instruction that is a
physically yes, but that has to be a notionally new connection in it.
new connection.
Learned counsel,
The name will-
learned counsel
Yes,
for
ma'am.
the petitioner submits that the petitioners had entered into an agreement for purchase of the property where the petitioners are residing with the private respondents, full stop. However, subsequently, the private respondents having refused to execute a deed of sale, the petitioners have approached the civil court, full stop. In the interregnum, at the behest of the private respondents, the electricity meter at the premises from which the petitioners were enjoying electricity supply, has been disconnected on the instructions of the private respondents, thereby creating extreme hardship to the petitioners, who are already in possession of the property. First up, it transpires from the affidavit of service that service has not yet been completed on the private respondents. First up, next para, however, it appears from the submissions of parties that the CSC Limited is agreeable to give electricity connection to the petitioners from the existing meter, which was disconnected at the behest of the erstwhile consumer, that is the private respondents. Pushed up, in view of the extreme urgency involved, since electricity is a basic necessity of life and a part of the right to life as enshrined in Article 21 of the Constitution of India, the court ought not to wait for service to be completed against the private respondents, particularly since no rights of the private respondents or title in the property is being decided. Full stop. Next para, the utmost prejudice which the private respondents could claim could have been that their civil rights would be prejudiced, regarding which this court intends to put in a specific rider in the proposed order. Full stop. Accordingly, the matter is being decided finally in the absence of the private respondents. Next para. WPA 6707 of 2024 is disposed of by directing the CSC Limited to give a new electricity connection to the petitioner from the existing meter at the premises in question, subject to the petitioners applying for a new connection and complying with all formalities, preferably within a fortnight from completion of such formalities by the petitioner, by treating the previous connection and the jural relationship with the between the private respondents and the CSC to be terminated in view of the successive notices by the private respondents to the CSC Limited dated November 9, 2023 and November 17, 2023, whereby the CSC Limited was first asked to disconnect the supply standing in the name of the private respondents and then to sustain such disconnection. First up, next para, it is, however, made clear that such electricity connection, as and when given to the petitioners, shall not create any special right or equity in favor of the petitioners, which the petitioners do not otherwise have in law, and shall not prejudice the rights and contentions of either the petitioners or the private respondents in the pending civil litigation between the parties. Full stop. No less to cause urgency. Thank you.
I'm grateful.
I'm obliged.
Thank you.
And for the petition, Lordship.
Yes.
Submersible pump connection, quotation deposited.
Why not given?
Connection not.
Lordship, boro cultivation is going on in this point of time, Lordship, and pole needs to be erected, and for that I am being instructed to appear for the Lordship and consider that since the pole needs to be erected, there will be some damage to the boro cultivation in the petitioner's land as well as in the adjoining areas also.
How long should you wait?
No, Lordship, we are ready to compensate the damage for the connection.
No, but they have 180 days under the law.
Lordship, if they are willing to compensate, Lordship.
I'll record that and give you direct.
Lordship.
Wait. The petitioner has come up against the alleged inaction by the WBSEDCL in giving electricity connection to the petitioner to operate his submersible pump. You have complied with formalities.
Quotation deposited.
Despite the quotation amount having been deposited by the petitioner. So, next para. Learned counsel for the WBSEDCL submits that since boro cultivation is going on in the neighborhood where the electricity connection has been sought, both the petitioner's land and others' properties as well as boro cultivation shall be severely affected if electricity poles are installed for the purpose of giving such connection to the petitioner. Next para, at this, learned counsel for the petitioner, on instruction, submits that the petitioner is agreeable to compensate whatever damage is caused to the neighbors of the petitioner for installation of such poles. In view of such stand of the petitioners, there cannot be any further impediment in giving the electricity connection immediately to the petitioner. Accordingly, WPA 6718 of 2024 is disposed of by directing the WBSEDCL to give electricity connection to the petitioner by installing the necessary electricity poles at the earliest, preferably within 1 month from date. Next para. In the event any objection is raised from any of the neighboring landowners, the WBSEDCL shall approach the concerned district magistrate under Rule 3 of the Works of Licenses Rules 2006 for getting permission to make such installations. It is expected that if such approach is made, the district magistrate shall resolve the issue within 3 weeks of such approach. The compensation, if any, awarded to the persons whose lands / crops are damaged due to the work done for giving electricity connection to the petitioner shall be quantified and intimated by the WBSEDCL to the petitioner. Upon such intimation, the petitioner shall ensure that such compensation is duly paid to the persons who are entitled to the same through the WBSEDCL, positively within 1 month of such intimation by the WBSEDCL. No orders to cause urgency.
Grateful.
Thank you. Yes, next. 31.
No, I beg to appear on behalf of the petitioner.
What is the matter?
In this
My lord,
petition,
I appear on behalf
By that
of the
face.
respondent number 1 and 2. My lord, learned counsel Mr. Jishnu Chaudhary is leading me.
Sir,
My lord,
entire matter, my lord, financial bid has not
my lord will
conducted by-
kindly take up the matter on Monday, my lord.
But they don't open the bid in the meantime. That's I can take it up on Monday. I have no difficulty. You say that the bid has not been opened.
My lord, we are technical.
You have challenged the tender process itself or your rejection.
Rejected financial bid has not opened.
You are challenging the technical bid rejection.
Technical bid rejection, my lord.
The petitioner challenges the rejection of the technical bid in a tender process given by the petitioner. First up, it is submitted by learned counsel for the petitioner that the financial bids have not yet been opened. Push up, an adjournment is sought on the ground of absence of learned counsel appearing for the respondent authorities. Full stop. Accordingly, the matter is adjourned till April 1, 2024. Full stop. However, comma, in the event the financial bids have not already been opened by the respondent authorities, comma, the respondents shall remain restrained from opening the same till April 5, 2024 or until further order, comma, whichever is earlier, full stop. It is made clear that the prima facie merits of the writ petition have not been gone into, but the above ad hoc restraint order is being passed only since an adjournment has been sought by the respondent and the matter is adjourned due to no fault of the petitioner. Could not be clearer than that. So, not an automatic extension when they come back.
Deeply.
Thank you. Yes. But don't give his name by mistake.
My lord.
Yes. Next.
32.
My lord,
What is
for
that?
the petitioner.
Yes. Affidavit of service and you know?
Affidavit of service.
Yes.
For the respondent, my lord.
Respondent number?
3.
You're not sure?
3.
See. Yes. Yes, Canada Bank, what do you have to say?
The question is that we have submitted a petition under section 14 to
Oh,
the
section.
district magistrate. It is pending for more than a year.
Here.
Yes. And last reminder is given in 19/1/20.
Have you served on the private respondents?
Yes, I've given all.
Good service.
Good service.
And no section 17 or any restraint order is.
Nothing.
The 17 is pending.
You are for the private respondent? Yes. What is yours?
The 17 is pending. Initially, 86 order was restrained by the learned DRT, and subsequently it was vacated. Again, they
Please take the microphone a bit closer to you.
again in pursuant to the new 13.4 application, they issued a 86 notification. It was mentioned that the auction will be held on 27th. But as per my information, no bidder was there. So that notice was also gone. And that particular notice was also challenged before the Honorable learned DRT. And next date in DRT fixed on 5th, 3rd May or 5th May.
Tell me something. Is there any restraint order on the section 14 procedure? There
No,
cannot
my
be
lord,
any,
no. In
because there
section
cannot
14
be any
procedure-
adjudication in section 14. Possession has to be given. How can I interdict that?
My lord,
Whatever will happen there,
first,
it will happen.
My lord, first of all, this particular writ petition is a premature because the date was fixed.
Premature?
Yes, my lord.
1 year pending for 1 year.
What I am saying, trying to say, why they have come before this learned court, honorable court?
Why?
Because a particular date was fixed for hearing. On that particular date, they were not attend the hearing before the district magistrate.
Do you have a copy of your initial order, which the stay order initially you obtained, which was vacated later?
No, my lord.
What was the nature of the order?
The 86 order was restrained until the defendant bank come and file their opposition.
Oh, after being vacated, it has not been reimposed.
No, because what happened, one after another 13.2 and 13.4 notice.
Yes, but we cannot resist section 14.
No, my lord, I am not asking section 14 to resist, but my lord, before this honorable court, the petitioner should have mentioned all the facts. They have not mentioned all the facts. Even in their particular affidavit before the district magistrate also, they made affirmed that there is no application pending before any court or tribunal.
We don't have
But even then,
51.
even at that point of time, section 17 was pending.
Section 17 is of 22.
No, you cannot get an order as a matter of right. There is serious allegation of suppression.
It's a 19 crore outstanding, and that is not that. The IA was disposed of
Maybe.
before I filed this.
You are not entitled to equity.
No. Question
You have
is what
suppressed
is the
material
date
facts.
submit? There is no stay order, and there is no IA application is pending at the time of my filing. Even today, 19.
Whatever recourse in law you
kindly-
can take. But because of this suppression of material facts, I'll not entertain the writ petition.
No, suppression of material is not that. 45, please kindly.
You said no section 17 is there.
45. Kindly see page
I
number
asked you specifically, sir, you said there is no section 17 pending. He's saying
section pending. No section pending.
no section 17 pending.
No, no, stay order is there on the section pending.
No, you said there is no section 17 challenge
At
pending.
the time of my filing the petition.
At
Even
that time also it was there.
Let it
Yes.
go.
And in the section 14, there will direct affidavits, file affidavits. Learned counsel for the petitioner submits that the petitioner bank, petitioner number 1 bank initiated a proceeding under section 14 of the Surfacey Act 2002, but the same has been kept pending for more than a year. An early disposal of the same is sought. On query of court, it is submitted that no section 17 Surfacey Act application is pending. However, subsequently learned counsel for the bank qualifies such submission and contends that at the juncture when the writ petition was filed, there was no such pending application. Such contention is squarely opposed by learned counsel for the private respondents to borrowers, who contends that even at the juncture when the writ petition was filed, there was a pending application under section 17 of the Surfacey Act. The said challenge was also pending when the section 14 application was filed, but was suppressed according to the private respondents in the affidavit filed by the bank in connection with the section 14 application. Learned counsel for the private respondents further submits that initially a restraint order had been passed with regard to steps taken under Rule 8 (6) of the extant rules under the Surfacey Act. However, he candidly submits that the same was subsequently vacated and has not yet been reimposed. Next para. A vital issue arising here is whether the petitioners are entitled to get an equitable relief under Article 226 due to apparent suppression of material facts which are germane to the issue. To substantiate the allegations of the private respondents, the respondents are directed to file their affidavit within (S) in opposition, but do it within a fortnight, please. Within a fortnight from date, reply, if any, shall be filed within a week thereafter. The matter shall be listed under the same heading on April 22, 2024. Same heading, please file, disclose in your reply, whatever happened. Thank you.
And next item.
Next item similar.
No, it is another district. Similar, this is section 40.
33.
33, I'm for the respondent number 4, the board.
Private respondent, borrower. Yes, what is your stand in the matter? Any section 17 restraint order?
My lord, no, there is no restraint order, my lord. In fact, my lord, what has happened, my lord, challenging the order under section 17, my lord, one review application is still pending, my lord. Since, my lord, one point we have taken.
No, you said there is no section 17. Section 17 was there.
Yes, my lord.
Rejected.
Yes. My lord, subsequently we filed a review application, my lord, taking into consideration the fact that no equitable mortgage has been created. Since one CBI case is pending over the self-same issue, my lord, the Canara Bank itself, my lord, filed an application before the CBI, my lord, against the deed.
You have filed a review, but not an appeal.
No, review.
Then section 14.
And another point.
Appeal has been disposed of.
Yeah.
The IA he is admitting that was rejected, not only disposed of.
Another point, if your lordship kindly comes to
page
44. What is the prayer here, my lord? Before this, in this writ petition, my lord, kindly comes to the prayer first, my lord.
6966.
The first prayer, my lord, editing the nature of mandamus directing the respondent number 2, that is the DM, my lord, district magistrate, to so cause as to dispose of the application file under section Surfacey. Well, that order has been passed by the DM, my lord, long back, my lord. So therefore, prayer A, my lord, does not stand in the way, my lord. So far, the prayer B is concerned, my lord, kindly see, my lord, prayer B, editing the nature of mandamus directing the respondent number 2 to take necessary steps so that his order is complied with for the purpose of taking physical possession, my lord. My lord, kindly comes to page 44, my lord.
Yes.
My lord, I have preliminary objection whether this jurisdiction, my lord, lies or not, my lord. My lord, police has acted upon, my lord. My lord, if any grievance, that too before the, my lord, police in action bench, my lord.
No,
this is why
learned counsel for the petitioner submits that despite the petitioner number 1 bank having initiated a proceeding under section 14 of the Surfacey Act 2002, the same has long been pending. Next para. It is contended that under the statutory stipulations, the matter ought to have been decided much earlier. Learned counsel for the private respondent number 4 submits that a challenge had been preferred by the private respondent under section 17 of the Surfacey Act, which met with rejection, comma, giving rise to a review application by the private respondent, which is now pending. It is further argued that already the police authorities have taken steps with regard to the handing over of possession in favor of the petitioners, and as such, the matter pertains to police inaction, regarding which this court does not have determination. It is further argued that the prayer made in the writ petition is vague insofar as relief A refers to an application under the Surfacey Act, which apparently is an indication to the application filed under section 17, which is already disposed of. Next para, all the technical objections of the private respondent are untenable in the eye of law. Insofar as jurisdiction of this court is concerned, comma, the matter does not pertain to police inaction at all. The fact that the police have raised a claim regarding police help costs is only a collateral ancillary of the prayer in the present writ petition, which seeks an early disposal of the application filed by the petitioner bank under section 14 of the Surfacey Act 2002. Although there is a misprint in relief A of the prayer portion of the writ petition, comma, a composite reading of the entire grounds of the writ petition as well as the statements made therein, comma, particularly ground Roman 7 of the same, comma, clearly indicates that the grounds Roman 7 and Roman 8 clearly indicate that the grievance of the petitioners is the long pendency of their application under section 14, and there cannot be any second thought about that. Next para, insofar as the claim of the petitioners is concerned, comma, the application under section 17 of the borrower stroke private respondent number 4 has already been dismissed. Mere pendency of a review application does not stand in the way of the section 14 application to take its own legal course. Next para, accordingly, WPA 6966 of 2024 is allowed on contest, directing the respondent number 2, that is the district magistrate North 24 Parganas, to dispose of the application under section 14 of the Surfacey Act 2002 filed by the petitioner number 1, which is pending before respondent number 2, as expeditiously as possible, comma, positively within 4 weeks from date. No others to cause certified copies.
May I submit, Lordship?
Yes.
Page 42, Lordship, the district magistrate has passed the order, Lordship. Yes. In 2020, Lordship.
No, my lord.
Section 14.
No, he is still in season for the purpose of implementation of that.
Yes, Lordship.
আচ্ছা, to dispose of, যেখানে বলছি to dispose, যেখানে disposal করলাম, to dispose of the application under section 14 such and such, and or to pass consequential orders to ensure implementation of any order which might have been passed by the district magistrate under section 14 within bracket 1 of the said act. He'll ensure
The
implementation.
instruction is that they have filed the application after the statutory period. The executive magistrate
Dispose
was
it of,
appointed.
decide that.
Lordship.
But you have already passed 14-1 order, so you cannot raise that bogey again.
Actually, the executive magistrate who was appointed, he has posted out. That way, there is a delay, Lordship. I'm grateful.
Next. You have tried your level best. I must appreciate your, I could not have argued better. Very little scope. Yes, next.
34.
Well, this is my application.
Yes, please.
I'm paying for not to develop.
Why, Mr. Bhattacharya?
Because
No notice of upgradation?
Without no notice of upgradation.
Sufficient ground. Since no notice of upgradation has been given, comma, on the prayer of learned counsel for the Union of India, the matter is adjourned for the day and shall next be listed under the same heading on April 1, 2024.
Well, item 35 also same matter, identical matter.
This is item 34. 35 also, 35 to call karo.
35.
Identical, Mr. Bhattacharya?
No,
No,
35
Mr. Tiwari.
That is also, this is also identical.
But there Mr. Tiwari is ready and Mr. Lahiri is also there.
36.
You're appealing for the union in 36?
No. Private.
How dare you prevent Mr. Tiwari from coming before
He's
this?
also
No, you have given notice regarding 35?
No, my lord.
Give a notice of. Since no notice of upgradation has been, sorry, since no notice of upgradation has been given, 35(8). Let the matter stand adjourned till April 2, 2024. The learned advocate for the petitioner shall give a notice of the matter, notice of the next returnable date to the learned advocate appearing for the respondent or directly to the respondents and file a notice to that effect on the next date of hearing. I have kept it on second because you will get time to give the notice.
Lordship.
Yes.
36.
36.
Lord, I appear for the petitioner, Lord.
And for the private.
No notice of upgradation?
No, no. Not
Then Mr. Lahiri.
Similar matter is there, Lord. Item number 83. 83 is my petition.
His petition?
Let that be heard along with this.
Same order.
So I am for the Union of India.
Did I say none appears or something like that? The Union of India, please give ask question.
Only one Monday 2 at matter is there.
Monday?
2 matter 34 and 35. 35 appearing in Monday to 1 4 5.
35 you are appearing?
Yes, no, I have not. 34 and 35.
No, I have passed my order in open court, whatever. Yes.
Lord, item 36, I appear for the petitioner.
Praying for not today only, man. It's my personal accommodation. Well, can you take it up Monday?
36 comes along with 83.
Yes, yes.
Lord, I have not received any copy of 84, Lord. 83, Lord, may it come on second instead of first.
Yes, yes. No.
You are for respondent number?
A private respondent, koto number.
Lord, husband, he is the husband, I am the wife. On his complaint, the daughter's passport has been impounded. I don't know what he has prayed for, but I have challenged the order of impounding on the ground that that is in violation.
Counsel appearing for the private respondent stroke husband seeks a day's accommodation. Learned counsel for the Union of India submits that WPA number such and such. Please give the number. Ask your learned junior to give the number on a slip of paper. Such and such is also appearing in the list today and being connected be heard together with the present matter. Accordingly, let both the writ petitions be listed on April 2, 2024 under the same heading for him.
Lord, should I file the affidavit of service note with regard to 36 or I'm keeping it with myself?
No, file it.
36 is affidavit of service.
Such a good boy, Mr. Chok.
Oh,
Such a good boy.
But I'm
Naive, good. I mean,
But I'm always
exemplary by your conduct. We'll see when the matter is taken up, Mr. Chok. This is not a veiled threat. This is an open threat. Ageta affidavit of service filed to be kept on record. Yes, next.
37.
Yes. What is the matter, please?
You
are appearing with Mr. Chakraborty? Definitely come back on Monday.
Lordship, I'm appearing for the writ petition, Your Lordship. Only one, my learned friend is praying for not today, Your Lordship.
Some difficulty?
Only thing, yes, Your Lordship. The subject matter of this writ petition
yes,
pertains to the invocation, that actually not the invocation, the threat to invoke the bank guarantees pertaining to a tender.
Did you give a notice of upgradation?
Your Lordship, notice of upgradation, I have not given, Your Lordship.
Why don't you give notice of upgradation? Should I put it on my list? That will be demeaning my advocates. I mean, this is basic. You have to give a notice. Even Mr. Chakraborty, if he comes for the petition, he will not give a notice.
All the respondents have been served. Affidavit of service may.
No, that. Yes, invocation of bank guarantee. Who will invoke, you or the state?
The state only.
Don't invoke the bank guarantee, Mr. Galib, impress upon your client if it has not already been invoked.
Long before the story was there, my lord, that was
service.
Thereafter, he preferred.
No, which story? First story or second story or third story? Don't let it. Don't let another story be constructed.
That was on 29th February 2024.
An adjournment affidavit of service filed to be kept on record. First up, an adjournment is sought by learned counsel for the respondents. First up, it transpires that no notice of upgradation has been given. First up, accordingly, let the matter stand adjourned for the day and be listed under the same heading on April 1, 2024. First up, it is expected that since the writ petition has been filed challenging the probable, the apprehended invocation of a bank guarantee, no steps will be taken till April 1, 2024 in that regard, comma, if not already taken by the respondents. Full stop. However, comma, it is made clear that the above observation is only on an ad hoc basis without going into the merits of the case, even prima facie. And that will help your hands, strengthen your hand. Yes.
38.
Lord, I beg to appear on behalf of the petitioner.
My lord, I appear on behalf of the bank. My lord, no application notice has been served upon us.
Don't take advantage of my.
I am not, my lord. I'm
It's
not.
appearing in the list, published in the list.
Very
That is
well, very
sufficient
well. I will
notice.
not.
You are ready in the matter also. I can
Yes.
see it from your face.
My lord, may
Yes.
I file my
Sufficient pep talk. Now let us do the matter.
Very well, my lord.
My lord, may I file the affidavit
Thank
of
you.
service?
কোনো দুটোর সময় fix আছে?
My lord, I am led by Mr. Rahul Karmakar. My lord, he is
So I
not.
don't know. I cannot take up within 1 minute probably because 2 p.m. another
Then,
matter
my
is
lord, may I kindly fix it at 2 o'clock. 2 o'clock.
2 o'clock another matter is fixed. If I can reach after that, I'll continue. I'm not passing any order now.
Very well, my
If
lord.
after 2 o'clock, after taking up the 2 o'clock matter, I can reach before original site, then I'll take up in due course. I've not called this officially.
Very well.
Oh, you have filed your affidavit, sorry, take it back. Because I've not called it officially. Because if I call it, I have to pass it over for the day.
Great.
Fixed matter at 2 p.m. Item 51.
I'm the state lordship.
My lord, may it please your lordship, I am for the petition.
Yes, Ms. Shyam,
Now, my
please.
lord, the petitioner before your lordship
Yes.
is a contestant of an election held for the association of the Siddha town Rajarhat. My lord, the fact remains that from
Association of, I'm sorry, I couldn't.
association of Siddha town Rajarhat apartments, that is the township.
Right.
My lord, there are 39 blocks, more than 13,000 owners. Now, my lord, there was an ad hoc committee from 2022 till 2024. So, my lord, this year ad hoc committee is to hand over the charge to the newly elected committee. Petitioner is the secretary of the ad hoc committee. Now, my lord, in this year, my lord, they took all the steps. First, they have submitted the declaration from all the flat owners. The flat owners' name was approved by the competent authority. Thereafter, my lord, the association was formed according to the rules.
What are you doing? Please, sir, give us some space. This is not the way to practice.
Yes.
Yes.
Now, my lord, according to the bylaws of the Apartment Ownership Act, a presiding officer was elected. A election commission of 13 members were formed to complete the election. On 10th of March, the election date was fixed. The total election was complete. Only one thing is that the petitioner, there was a home collection provision for the persons, my lord, who are really not willing to come or not able to come.
Home collection of the ballot.
Home collection of the ballot papers by the election commission team. Now, my lord, the petitioner gave a letter for home collection of a voter. And when the election commission members went for home collection, that person, that lady, he was alone in her home, she declined to give his vote. Now, when they came back, thereafter the problem started. There is only one.
What was the locus standi of the petitioner? I mean,
petitioner,
why
one
did
of the contestant of that Magnolia block, only where one block representative will be elected.
Right.
Now, the respondent number 7 is the other person who is the contestant. Now, she raised an objection that petitioner has obtained a fraudulent manner by asking for home collection, and so the candidature of the petitioner has to be cancelled. No ballot paper for that Magnolia block will be counted, and the respondent number 7 will have to be declared elected by the presiding officer. Now, my lord, there is no such provision in the bylaws that after election, if one candidate does not want to cast her vote, and if one of the contestants asked for her collecting vote, and thereafter it cannot be said that as fraudulent or to cancel the contestant's election, the candidature.
And in any event, she did not cast her vote.
Did not cast her vote. So nobody will be benefited by that. Now, there was a huge chaos. The other persons, the respondent number 7's leadership, they stopped counting of ballot papers for 8 hours. After 8 hours, the presiding officer was just succumbed to such pressure, such hooliganism rather. Just collar was pushed out, slang language. So he declared the result are permitted for counting ballots of other 47, excepting one. And on the next date, the presiding officer resigned to the competent authority and stated that election is complete except one block, Magnolia. But the election commission members, 13 in number, most of them also resigned. So the election was not complete. But those elected, some members, they submitted a Form 3 informing the competent authority that these are the elected members, and they have shown that respondent number 7, who was only one, after verbal declaration of petitioner's candidature as cancelled, that was verbal, no written. Everything was on loudspeaker. So counting her as an elected candidate, they submitted Form 3 regarding constitution of the board of managers.
They means who? Because most of the election commission also had resigned. So the remaining election commission members?
Only one election commission members.
Out of 13, 12
out
resigned?
Of 13, only one. All resigned. Presiding officer, everyone. Just have a look to the letter of their resignation. Then
what are you challenging that declaration?
I am challenging the declaration that first of all, the candidature of the petitioner cannot be declared. There is no such provision.
Your challenge is confined to Magnolia only.
Only Magnolia. But so far, Magnolia election is not complete. The total election is not complete. Then the board of managers cannot be declared.
All right.
So, my lord, what I am praying before my lord,
yes,
that the ballot box is intact in the strong room, either to ask for counting for Magnolia block, only one will be represented, and or to collect for a fresh election. My lord, lordship, kindly have a look to 2-3 papers.
Fresh election is a tall order.
Only for Magnolia.
Oh, for Magnolia.
For Magnolia, if they want it.
All right.
Losses, kindly have a look to this, the letter of the presiding officer.
Yes.
Below that is page 40. The presiding officer was approved by the competent authority. So when he resigned with this complete declaration that we accept one block, page 40 to the competent authority. That kindly note that most of my fellow election commission members have resigned by today evening. As per schedule yesterday on 10th March, I, along with my election commission team, conducted the elections for block representatives successfully, 47 blocks, apart from one block Magnolia, due to which there was a lot of harassment which I and my team had to face from various sections of the society. In light of this tremendous mental physical pressure on me and my team captured in camera and available with the facility team, I would like to resign from the honorary post of the presiding officer and get discharged from all my duties with immediate effect. Below the next pages are designation letter of all the EC members, EC committee members. And below one clarificatory note from one member, it is clear that which was the situation there at page 48. At page 48, the presiding officer sought for a clarification that why did you resign? Resignation for my personal ground, why? Then he sent this letter at page 48, that as asked below is the clarification of my resignation as desired. All this started at 2 p.m. The mob was pressurizing the EC team and presiding officer using bad slang. Few of the residents in the mob were in drunk state. The EC member team had a long discussion with the mob. The mob was harassing the EC team, including the presiding officer, mentally and physically, to cancel one of the candidates' nomination of Magnolia block, named Mohammad Samim Alom, the petitioner before my lord. After an 8 hours hard discussion and struggle with the mob, the presiding officer lost control of himself and announced the rejection of nomination of Magnolia block, knowing the candidate's nomination legally cannot be cancelled. The presiding officer was worried about the time given by all Siddha residents to vote, and he did not want another block to suffer. Mob had only one condition, that the counting can only start once the candidate nomination Samim Alom of Magnolia block is cancelled. Now, my lord, according to me, this action of the presiding officer, though under pressure, is highly illegal, where there is no provision in the bylaws to cancel candidature of nomination of any person after the election is over. Losses, kindly have a look to the bylaws. What are the provisions? Bylaws, but put it bylaws 3. Miller Losses, I am just giving a, this is the bylaws for
yes.
33 of the West Bengal Apartment Ownership
Yes.
Act.
Which bylaw?
Miller, this is the West Bengal Apartment
No, that I've got
Ownership
2022. 2022.
2022. And the act is also
No,
here.
no, you are particularly on bylaw 3.
Bylaw 3. Bylaw 3.2. 3.1a and 3.2. There is no provision anywhere in the bylaws that after the election is over, the candidature of any candidate can be cancelled. And far less there is any question of obtaining any fraudulent manner. If someone said that yes, I shall cast vote, if home collection is necessary.
Is there a process for a forum for challenging the election?
No, no.
There is none.
And here the petitioner is not challenging the election of other block.
No.
He is praying for only counting of votes in Magnolia block. Then the election will be completed, and then thereafter only the board of managers can be constituted. That is the provision. Lordship, the owner.
Very well. Yes. So this is
my, and my lord, only one thing is that,
yes,
that the ad hoc committee, which was functioning, my lord, till now. So, my lord, till such election is over in Magnolia block, now there is, my lord, a vacuum. There is nobody.
Ad hoc committee was appointed by whom?
By the town builders. Lordship, the letter is also here. Lordship, kindly have a look.
Why was the ad hoc committee appointed in the first place?
In 2022.
Why was it done? Why ad hoc committee? Because the tenure of the previous committee was over.
There was no committee because first of all,
this is the first election.
This is the first election. This
morning
is
shows the day.
Election. Morning shows the day.
Yes.
My lord, and the ad hoc committee was taken total effort in submitting the declaration from every residence that I am the owner. This is my declaration in Form A of the Apartment Ownership Association Act. Thereafter, there are stages. Everything has been completed by the ad hoc committee. Even the election, when the competent authority asks them to elect a presiding officer and to form an association, the registration of association was also done by the ad hoc committee under the secretaryship of the petitioner. Everything was done.
Let me hear. Yes, who is appearing for whom?
For a presiding officer of the election commission.
What is your stand in the matter? First, I'll hear you. Then, who is for this respondent 7?
Respondent number 7.
Yeah, I'll hear you next. Yes. You are one of those who resigned.
Hello, I am the presiding officer.
A presiding officer. What is your viewpoint?
Whatever my senior had the same.
You agree with that?
Under tremendous pressure by the hooligans, which has been captured in the CCTV bylaw. The CCTV footage will speak the entire process.
Who is in custody of the CCTV footage?
Facility manager of Siddha Builders. He is in custody of the entire ballot box, CCTV footage, and the home collection, which was done. Everything is.
You are which respondent? Respondent number?
Oh my God! Oh, Mr. Chiranjeev.
Very well. So you agree with that? Yes, respondent 7.
My Lord, I beg to submit before your lordship.
Yes, please take the microphone. Ms. Sengupta and the rest, please, you can take your seats if there is any seat. I mean, if there is no seat, try the lapse of your juniors. Yes.
My Lord, in fact, the petitioner has challenged the election. But if your lordship kindly have a look.
Ms. Sengupta, you have to make space for him now, because otherwise, I have rebuked him sufficiently.
He has candidly admitted the result of the election. I will place reliance on that. Kindly come to prayer A of the read. Kindly come to that. He has challenged. Nobody can stop him.
Yes.
A writ in the nature of mandamus do issue commanding the respondent number 2 to cancel, rescind and or withdraw the form 3 sent by the respondent number 8 on 14th March 24.
What is this form 3?
After the election is over, the elected candidates, the list, the names of the elected candidates, those have been sent to the competent authority. That has been accepted. And that is here, my lord. As per the RTI reply, my lord, I can place.
It is annexed also here.
Yes.
Yes.
And at the same time, my lord,
May I just tell one thing?
Yes.
That is under challenge because the Form 3 is regarding election of the board of managers after the election of block representatives who is over. As
if Magnolia goes, then that cannot be done.
That cannot be done.
And this writ petitioner, he has signed Form 3 as it appears from the copy which you have received from the builders. Lordship, kindly see his name is there, column number 13. So he's accepting that. How he can challenge? This is again.
Give a copy to them also.
Yes, yes. Form 3.
What is this? Give a copy to them also.
Yes, yes.
Yes means?
I will hand over, my lord.
No, will not do. Then net of
We are giving, my lord. We are giving.
Are giving, I don't believe in present continuous.
Dear Lord, dear Lord. Give me 1 minute time.
Yes. Take your 1 minute. Give and then hand over.
I have handed over.
Yes. So they have signed. That is your.
Yes. So he has accepted the election result. Now he has challenged the total election process, rightly, wrongly. So he cannot go beyond his own declaration signed in form number.
How do you explain this conduct of, can this be done? Just first of all, there are two aspects of the matter. One, for this reason that he has instigated, rather on his request, home ballot was sent.
Yes.
Can this be a ground first of challenging that election or his candidature? Secondly, was the cancellation of his candidature after the election valid? Support this from law.
No, my lord, so far the second part is concerned,
yes.
That after the election is over, this cannot be. But my lord, we were actually apprehending danger at the instance of this present writ petitioner.
How?
And kindly see the.
They will be breaking the bottles of the liquor which you are taking because you are drunk.
Another writ petition before the election, apprehending this for irregularities at the instance of this writ petitioner, my lord, we have filed before your lordship, and that is pending.
This writ petitioner irregularity means What was he?
That we apprehended at that point of time that
That was
he-
like an anticipatory bail application.
no, he will do some
A previous diary. Because you do something and then go file a lodge a diary.
The moment he lost the election, he came before your lordship.
That is the precise reason for your other writ petition.
No. That was
What was the irregularity he was committing?
My lord,
As per your that writ petition? What was the irregularity he was committing?
irregularities, my lord, kindly take up that.
What type of irregularity? Tell me.
Item number 28. lordship
Item number
kindly
20 will
see.
come later. I'm not taking.
We-
What type?
He was going beyond the rules and regulation of the election of the election process.
Don't be so secretive. Use the microphone.
My lord, he was going beyond the rules and regulation of the election process.
How? How exactly?
My lord, no notification of the election, etc. And this thing has been done at the instance of the present writ petitioner.
No, if you cannot cancel after election, then your entire process goes. Then I'll declare that he is also an elected candidate. His papers will also be ballot. The entire ballot papers will be counted, and his candidature cannot be cancelled.
My lord, this is a question of fact. My lord,
Where are the ballot papers of Magnolia now? They are in safe custody.
it is in the strong room.
I'll direct those to be counted and set aside this cancellation of this person.
No. My lord,
He cannot be
that
cancelled just
no,
like
no. That can be counted. We are not standing on the way. But thereafter, your lordship will pass the necessary order.
No, I'm telling you this. I'll not tell you what will happen after that. The counting will itself tell you. Whatever will be the result. If he wins, he wins. If you win, you win.
So far, the cancellation of the
He cannot be
petitioner-
cancelled like this because you cannot support that by law.
That is a technical aspect. Lordship has rightly pointed
What is
out.
the technique?
No. That after the
It
election
is absolutely technical. I appreciate.
after the election is over,
Yes.
what is the use of cancelling his candidature? That is a
No,
pertinent
there is
point.
every use of cancelling his candidature, but there is no law supporting you. You are fair enough on that. There is no law supporting you. So
Lordship-
therefore, you cannot withhold that counting of the ballot papers. Let those be counted. Whoever wins wins.
Kindly come to the rule 3. Rule 3.
By
voting
law.
process.
By law
voting,
3.
Yes, voting process for manager. Page 38 of the writ petition.
Oh, this. Yes.
Yes.
Right. What is the voting process?
Yes, I'm coming to that, my lord.
Yes. Manager means regarding a particular tower. Magnolia, one manager, like that. Very well. Oh, acha. Either the petitioner or respondent of 7 will be a block representative, among whom that and who will vote for that? The block representatives. Very well, very well. Thank you.
Kindly come to rule 3.
Yes,
Sub-rule 3, sub-rule 3. Voting will be done in person only at the set time. No online or other modes are allowed, except those more than 80 years old and completely unable to walk to the election areas. If he or she wants to, his caste may contact the facility officer by 8th of March 24, 4 p.m. and give his name for casting the vote. Accordingly, EC members will visit their flat personally and will take his vote in a closed envelope. EC has also the right to deny his vote cast on the spot if he is found healthy and able to walk. Casting of this vote will be done at any time. Yes. Now, Lordship, kindly come to
election commissioner নিজের হাতে থেকে
and this election commissioner, he resigned.
Obviously, what else could you do? You go drunk and beat him up, and what will you do? That is the allegation here.
It's an allegation. We have to deal with.
Drinking is not an offense; it's a constitutional right. But after that, what you do, that is what is important.
That is
is CCTV. That's a sufficient warning the presiding officer is.
I was not present. Perhaps she was also not present. CCTV will tell.
Why should she be present?
Yes. Oh, I see.
Oh. No case at all.
Let us
what?
My lord, let us come back on using.
Come back. Why should we come back? Don't come back to me. come back with a different matter. I'll dispose this of right now. I'll
Malad-
cancel this cancellation, and I'll direct the votes subject to hearing them. And I'll direct the votes to be counted and whatever be the results. But the difficulty, other difficulties all have resigned. Now what happens now?
No, 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 no.
No means
He's saying the interim order.
12 persons have resigned out of 13 of the electoral.
It is they are saying. What is the proof?
Oh, these emails.
They have done this, my lord. According to my instruction, my lord, this is not correct. This is not correct. And Lordship kindly see they are asking for interim order in terms of F, G, and H.
What interim order? If I decide it, there is no question of interim.
Then
I'll refuse the interim order. I'll direct the petition to be disposed.
Let it be decided.
Let the
on
counting be done
affidavit.
and whatever be the result.
On affidavit.
Now, what is to be decided? Oh, you want an affidavit?
Yes, very
Then
short
the ad
time.
hoc committee continues in the meeting.
No, no, no.
Then you will continue.
As per law, the competent authority.
What is the law? As per
competent-
law, who is to continue?
If there is no election, and
You
no
are the law.
committee,
You are the law.
The
As per
competent-
law, what will who will continue?
competent authority will take charge of this situation.
Competent authority? How can the competent? He does not have any other business.
Competent authority has accepted.
Competent authority.
The board of managers.
The competent
Authority will take charge.
No, the competent authority has accepted the proposal of the board of managers. The form 3 has been accepted
What
by
do you
him.
want to disclose by way of affidavit? Tell me that.
That the total, it is a case of total fraud. The petitioner has no cause of action. Within very short time, 7 days, nothing more.
Within 7 days, you will file your opposition.
Yes. Let it be decided. Let them.
But till then, the ad hoc committee will continue.
As well, Lord.
Ad hoc committee was there.
Yes.
Not that I'm putting in somebody there.
Yes.
Ad hoc committee, whoever was there,
Only for 7 days. Thereafter, Lordship will dispose of after.
you will file the opposition within 7 days. Ad hoc committee will continue till 7 days.
Yes.
And then they will not file any reply.
It is up to them, my lord. Obviously, they will file. 7 days, 7 days.
I'll direct that affidavit. Since you are asking, I'll definitely direct them to file affidavits.
Yes.
Till disposal of the writ petition, ad hoc committee will continue. I'll fix a specific date.
Yes.
How long do you want to take to file reply?
Below 7 days.
7 days. So others also, if they want, they can file opposition, either opposition or reply to the opposition filed by them.
Yes.
Either of the two.
So far.
You have nothing to say.
Yeah.
You are the architect of all this. The state is the architect.
No.
You are trying to grasp this siddha.
In item number 28, none appears for that reason. For Lordship makes this matter in the month of April. In that petition, my lord,
Yes.
the allegation has been made that the petitioner, this present petitioner, and the election presiding officer are in hands in gloves.
Since there was no.
They are.
The rules reveal.
They are
But for,
hands-
but for
they-
better
they-
administration of justice.
That was our
No.
apprehension at that
That
point of
is-
time before election.
No one appears. That's
Now,
the reason, my lord.
we are the
But
elected
here, my lord,
candidates.
I find, my lord, in that petition that respondent number 5 and 6, in that petition, my lord.
মাধববাবু এর মধ্যে ঢুকবেন না আপনি অর্ডারটা নিন আসুন আপনি এখানটা চলে আসুন আমি ওদের থেকে প্রোটেক্ট Learned counsel for the petitioner has raised a strong prima facie case for the writ petition to be heard on merits. Push up, it is argued that out of the several towers of the apartment concerned, that is the Siddha Town Rajarhat apartment, the present dispute pertains to one of the towers, namely Magnolia. Pushed up. When the election process was going on, the respondent number 7, who is a contestant in the said election, as is the writ petitioner, made an allegation that the petitioner had requested a home ballot to be sent to one of the voters, pushed up on such flimsy ground, it is alleged, the entire candidature of the petitioner was sought to be cancelled. Pushed up next para. In any event, learned counsel submits that the said voter had not even cast her vote. Pushed up next para. Subsequently, as a fallout, mayhem, AGM, ensued. Pushed up. Out of the 13 members of the election, what is that called?
Election Commission.
Oh, that's also called a out of the 13 members of the election commission in charge of the said election for the association, as many as 12 resigned. Pushed up, even the presiding officer made serious allegation, all indicating towards the supporters and henchmen of the respondent number 7 having created a ruckus. This is her allegation. Don't get excited. Created a ruckus to disrupt the election process. Full stop. Learned Counsel argues that the cancellation of the candidature of one of the candidates after the election process is over is not sanctioned by the West Bengal Apartment Ownership Bylaws 2022, which governs the field of such elections. Full stop. Next para. Secondly, the en masse resignation of the election commission members itself is sufficient indicator that there was extreme undue pressure exerted on them, full stop. Next para. Thirdly, it is submitted that the formation of the board of members for the entire association will be hampered, since unless the elected representative of the Magnolia Tower is declared, the board itself cannot be formed, as it constitutes of representatives from all the towers. Full stop. Next para. Learned Counsel, appearing for the respondent number 4 stroke presiding officer, agrees to the contentions of the petitioner to the hilt and adds that extreme pressure was created on the presiding officer, leading to a disruption of the counting process regarding Magnolia in particular. Full stop. Next para. Learned Counsel for the respondent number 7, who is the other contesting candidate against whom the plinth of the petitioner's allegations have been made, submits that the first relief sought in the writ petition itself indicates that Form 3 was duly sent by the respondent number 8 and was accepted by the competent authority, thereby completing the process of election. It is argued that the petitioner himself participated in the said process by being one of the signatories of the Form 3. Full stop. Next para. It is thus argued that there was no irregularity in the election process insofar as respondent number 7 is concerned. Full stop. Next para. Learned Counsel for the respondent number 7 insists that the said respondent shall use an affidavit in opposition to bring on record relevant documents and pleadings. Full stop. It is also hinted by respondent number 7 that fraud has been practiced before this court. Full stop. Next para. Since certain serious factual allegations have been made by the petitioner and the respondent number 7 as well as the other parties to the writ petition, the respondents are directed to file their affidavits in opposition, if any, within a week from date. Full stop. Reply, if any, thereto shall be filed by the petitioner and or the other contesting respondents, if any বোধহয় বলেছি দুবার হয়ে যাচ্ছে, within a further week thereafter. Full stop. Next para. The matter shall be listed under the same heading on April 16, 2024 for hearing. It is made clear that till disposal of the writ petition, the ad hoc committee which has
the ad hoc committee is not functioning. The SIDDA group is managing the.
No, the ad hoc committee was constituted.
No.
It was the approval of the
but
SIDDA
they have
group.
not taken charge.
the ad hoc committee which has been previously functioning shall continue to function and regulate the affairs of the apartment stroke association.
Milord, only one irregularity, if Losses kindly add that the ballots collected by home collection that has not been counted. That is also in the strong room. In total blocks.
It is made clear that the facility, what is that facility committee?
Facility manager.
The facility manager shall preserve the CCTV footage regarding the relevant period of the election and shall produce the same if so directed by this court, till disposal of the writ petition. Full stop. Next para. Insofar as the ballot papers stroke boxes with regard to Magnolia Tower is concerned, the same shall also be preserved by the presiding officer. by the facility manager also till disposal of the writ petition, comma, subject to any order of production which may be passed by this court.
Milord, Magnolia block and Milord, the ballot papers collected through home collection. That box is also not open. That is sealed also. That is not counted.
So
So
whatever ballot boxes are there regarding Magnolia, those will be preserved.
Magnolia and the ballot papers which are collected from home, that has not been opened also. That has not been counted. That
No,
has made the specific pleading.
That
petition.
is rather beyond the scope of the present writ petition. I'll not direct those to be preserved. Those will have to be preserved. আচ্ছা, ম্যাগনোলিয়া টাওয়ার বিভিন্ন জায়গায় বলেছি, টাওয়ারটা কন্ট্রোল ফাইন্ড করে ব্লক করে দেবেন। It's a block.
Because some of the blocks by one vote, some has been owned. So if the ballots collected through home collection is counted, result may be changed. So only below that box be preserved. That is also the.
It will be wider than the relief claim. For the time being, no.
I'm grateful, Milord. I'm grateful. I'm grateful.
16 তারিখ সেম হেডিং এ 2 PM আছে এটা। আচ্ছা, ওটা লিখে দিন একটু, টু বি টেকেন আপ এট 2 PM 16th এ সেম হেডিং, টু বি টেকেন আপ এট 2 PM।
I'm grateful, Milord. Grateful.
But my lord, I have been instructed to submit before your lordship that particular ad hoc committee has been dissolved by the Siddha group itself. Though they are in management as of now, my lord.
Siddha group
For the time being, let them continue. Let us.
But that has kindly record my submission. Kindly record my submission. Kindly record my submission, because it may create.
I passed my order after that. I can.
Lordship, I was
You in your opposition you point out.
My lord, I was searching for the document. My lord, kindly record my submission.
After the hearing is over, no. You put it in your opposition.
As well.
Dako.
Upgraded matter item 38.
Respondents will act upon the communication made by the learned advocate.
All of you are present here.
38.
My lord, I hope to appear on behalf of the
Yes, what is the matter?
My lord, for the bank.
My lord, the petitioner is, my lord.
Take the mic. Take the mic.
The petitioner is a senior citizen, my lord.
Yes.
My lord, he's a retired defense civilian, my lord. My lord, he maintains his pension account with the respondent number 1 bank. My lord, the respondent number 1 bank, my lord, has deducted from his pension account, and my lord has appropriated some amount of money into the petitioner's son's loan account, my lord, in which the petitioner was a guarantor. So, my lord, we have challenged only that particular portion where, my lord, the pension of the petitioner has been deducted, and my lord is been appropriated into some other loan account belonging to the
entire pension is being appropriated.
Entire pension, my lord. I shall show, my
the
lord.
Entire pension account is being appropriated.
Yes, my lord.
It's solely a pension account or some other some.
No, my lord. It is solely a pension account. I shall, my lord, show. My lord, on this pretext, my lord, may I be permitted to show some documents, my lord?
Yes.
My lord, may I first come to page number 15, my lord.
Yes. 15.
My lord, this is a sanction letter through which the petitioner's son was, my lord, granted a sanction facility. My lord.
You are a guarantor. Your liabilities are coextensive. There cannot be any doubt on that. You know that. He knows that. I know that.
My lord.
Only question is whether pension, how far it can be attached.
Yes, my lord. My lord, then come to the next. My lord, may come to the next page number 19, my lord. My lord, this is the statement of account of the petitioner, which is the pension account. Why I am telling this is a pension account, my lord, may kindly see.
All the incomings are pension.
Yes, my lord, the deposits, my lord. 18,892 on the 2nd, 29th of June, 29/9. My lord, this is a my lord, transferred from principal controller.
Yes, you're absolutely right.
My lord, may come, and my lord, may kindly come to the last entry at page 20.
Yes.
My lord, last entry, recovery in account number such and such. My lord, may kindly see the balance was 35,215. My lord, 34,938 has been deducted, and my lord, appropriated into the son's loan account. My lord.
The grand amount of rupees 277.57 has been left.
My lord. My lord, on this, my lord, I will just show one judgment, my lord, which is pat on the point, my lord.
Those are not.
My lord, those are also.
No,
my lord,
don't multiply judgments on the same point. You're absolutely intelligent in doing this. What you are doing. Yes.
My lord, this is a Madras High Court judgment, my lord. My lord, the facts are similar. My lord, if I go through the petition is aggrieved against the order of the file first responded dated auto, whereby her savings bank account number dealing only in respect of her pension amount was put on hold for the purpose of recovery of an outstanding of loan amount. My lord, then my lord, paragraph 3, it is the contention of the learned counsel appearing for the petitioner that the present impugned order is in effect attaching the pension amount of the petitioner lying in savings bank account. My lord, this follows, my lord, one Supreme Court judgment, my lord, Radheshyam Gupta. My lord,
Yes.
my lord, may kindly come to the concluding portion.
Section 60 is to be looked into 1/3 probably forgotten. I'll just look into section 8.
My lord, that, my lord, my respectful submission is, my lord, the pension account cannot be done, my lord.
Yes, you are right probably. I'll just check up.
My lord, I am led by Mr. Rahul Kaur.
Then I'll hear you seriously now. Yes, Mr. Kormukar. Don't have a case. 61.
Surfacey Act.
My lord is looking into my lord 61G.
Yes, you're right. Enter.
This was subsequently, my lord, interpreted and said, my lord, that any pension cannot be attached.
Right. Yes, yes. That is obvious.
My entire case is on that. The second aspect is, my lord, from the sanction letter your lordship has seen, there are, my lord, 2 securities already available with the bank.
No, that is their discussion. Your liability is coextensive. I made that very clear to you.
Yes. Lord, my liability is there.
Their choice, bank's choice.
Lord, my security is also there with the bank.
No, if I hold that the pension account cannot be attached or taken, then you need not get into the
Very.
There is their option. The others among them they may choose. Let me hear your learned friend. Yes.
My lord, without sounding insensitive to the
No,
petitioner,
not that.
I have a very fundamental point of maintainability, my lord.
Why do you say that?
Because my lord has rightly held that the guarantor's liability is coextensive. I need not press section 128 of the Contracts Act at all to justify that.
Section 120?
128, my lord, the Indian Contract Act.
Right.
The
Yes.
surety's liability is coextensive.
That's settled, yes.
The aspect is that my lord, if kindly looks into...
Pension.
My lord?
Pension.
Yes, my lord. If my lord kindly looks into section 13, subsection 11 of the Surfacey Act, I am at liberty to take any measure that I can before even proceeding against the secured...
I'm sorry, please give the section name. Section 13?
Subsection 11, my lord. It is on that plinth itself, my lord, that I wish to argue on the very simple point that, my lord, there is an alternative remedy. They can file an application, my lord, before the DRT claiming that this attachment, without admitting to the fact that, my lord, there is at all an attachment. What has perhaps been shown to, my lord, is that there's a deduction of a certain amount that is not the entire pension amount, my lord. My learned friends has not justified the fact that that amount is the pension amount. My lord would see there's a long list of transactions that has happened in that specific account, and a certain amount has been deducted. My lord kindly records what has been mentioned there, recovered in an account that is admittedly.
Section 1311, you said?
Yes, my lord.
Please place it. This is general in terms.
Yes,
general in the sense that
that I may proceed against the guarantor before proceeding against.
Oh, yes, you can.
On that print itself, my lord, my respectful submission is that there's an alternative remedy. I will not place, my lord, for Bharti. I will not place Federal Bank. I will not place Arc Phoenix. I am certain my learned senior friend will be applicable in distinguishing them. But my only respectful submission is that there is a simpliciter case of alternative remedy. They can file an application for the DRT and they can contest it there. Whether at all, without admitting to the fact that there is at all a sort of quote-unquote attachment of the pension. What has happened here, my lord, is a deduction. Kindly records the comment that has been made, recorded there, recovered in and the number of the account, and the account number is admittedly one of the loan accounts for which the petitioner is a guarantor. Whether that can take the character, my lord, of attachment of pension is one submission, my lord. As regards the judgment that has been shown, my respectful submission, my lord.
No, this is one of the loan accounts. Show that to me from the documents.
Yes, my lord.
Yes.
In fact, my lord, that my lord will find from the sanction letter, I believe, my learned senior.
Yes, he was repeatedly going to place. It is I who stopped. So I should be fair to them. Page 15.
Page 15.
No, that account is mentioned here. Existing account number.
Recovered in that amount. My submission is that, my lord, if I may ask for one simple indulgence in the absolute interest of fairness, I can take one instruction from the bank, one opportunity from the bank to take necessary instruction, whether at all, in effect, as my learned senior friend claims, there's been an attachment of the pension account. And
no, deduction is more than attachment. I'll apply the principle. I will not say that this is attachment, but the principle will be applicable. That is what
in that case, my lord, one indulgence is that why that amount has been attached. I only need to seek instruction to that effect. Why that specific account?
We are not on the why, whether it can be done. whether it can be done for whatever reason.
Very
You
well,
may
my
have your reasons.
very well, my I do.
Even if it is a loan account, it is the loan account. Let us see whether it is a loan account.
And one last submission, my lord, and I press this with utmost humility. The
Yes.
judgment that has been shown, my lord, is in respect of section 60, subsection 1G of the Code of Civil Procedure.
Yes.
My utmost respectful submission is that, my lord, that is only applicable in respect of enforcement of a civil decree of a court.
Yes, no doubt on that.
My only, if I may beseech, only one indulgence, my lord, kindly allows me to take necessary instruction from the bank, whether at all we have put it to proceed as my learned senior friend alleges. If it does so, my lord,
We have deducted.
my lord, that deduction, whether the deduction is in the effect of an attachment or not, that is my only submission. I will not press it.
No, deduction, I'll apply the principle.
Very well.
I'll say it's a deduction.
Recovery.
Mr. Kormakar, one serious point has been, apart from maintainability, you will deal with that also.
Yes.
Apart from that, I mean, if this is the existing account number given in the sanction, why did you give this account? You cannot now take shelter under the fact that this is a pension account. Now, why did you choose this account? Page 15, come to page 15.
Correction, Lord. Kindly comes, Lord, to page 15 once.
Yes, I'm there.
The existing account number is 83. Last, Lord, 2 digits, 83.
Yes.
Kindly comes to page 20. The last note, my lord, at 2nd of March, recovery on that account from my pension account.
The account is, you gave this number, this account number.
Number was never given to them.
At the same bank.
In the sanction letter, existing account number, it's mentioned and existing. They sanctioned the loan on the premise that this is the covering account. Page 15.
Yes.
Page 15 verses 21. See the account number.
Your lordship is seeing existing account number.
Yes.
Existing account number is, my lord, 0083.
Right.
Kindly comes to my account number at page 19. Page 19, top. This is my account number.
No, what about page 21?
Page 20.
21.
21, my son's account number. That is my son. 19 is mine. 21 is my son.
Which is a loan account.
The name is given. Your lordship would find that.
All right.
That is one. The other aspect is kindly comes to, my lord,
Yes.
section 31 of Surfacey. I'm sorry, my lord, the Securitization Act. My lord, kindly.
Yes. Section 31.
Section 31.
Yes. What about that?
G. Any property is not liable to attachment or sale under such and such under 60 subsection 1 of section 60. The act is not applicable.
May I make one submission, my lord? I am certain it will not fall on my lord's. Yes, but we had made one communication to them, my lord, on 19th of January to the guarantor itself, where we had specifically indicated that in light of the repeated defaults to provide for that entire loan account, that your pension account may be, I say this with utmost restraint, it may be considered at a point where I would take shelter of that account for recovery.
You will have to reverse the withdrawals from this. The gamut of the present dispute is limited. Full stop. The petition, you are the sole petitioner, the father is the petitioner.
Sole petitioner.
The petitioner acted as guarantor in respect of a loan taken by his son. Full stop. The account number which finds place in the sanction letter of the loan belongs to the son of the petitioner, who was the borrower. Full stop. However, on the pretext of taking measures under section 13 of the Surfacey Act 2002 for alleged default of repayment of the loan by the son, the petitioner's pension account has been debited, almost to the full by the respondent bank. Full stop. Learned counsel for the petitioner argues that applying the principle of section 60 within bracket 1 within bracket small g of the Code of Civil Procedure, read in conjunction with section 31 of the Surfacey Act 2002, the pension of a person cannot be the subject matter of attachment / deduction. Full stop. In support of his contention, Learned counsel for the petitioner cites a judgment of a learned single judge of the Madras High Court reported at 2015 SCC Online MAD 13308, which supports the proposition of the petitioner. Full stop. Next para. Learned counsel for the bank contends that due to availability of an equally efficacious alternative remedy in the form of a challenge under Section 17 of the Surfacey Act itself, since the action taken by the bank is a measure under Section 13 of the said Act, this court ought to hold its hands in interfering under Article 226 of the Constitution of India. Learned counsel for the bank contends that in a plethora of judgments, the Supreme Court has highlighted such restraint, self-imposed restraint by the courts. It is contended that under normal circumstances, unless the alternative remedy provided under a specific statute, which is virtually a code by itself, is exhausted, the writ court does not interfere. Next para. Learned counsel for the bank also seeks to argue that the impugned action of deduction of the amounts in question do not tantamount to attachment as contemplated in Section 60, read with Section 60 of the Civil Procedure Code, read with Section 31 of the Surfacey Act. Next para. In any event, it is contended that the provisions of Section 60 of the Code of Civil Procedure are not applicable to measures taken under the Surfacey Act, which is a code in itself. Next para. A perusal of the statement of account of the petitioner with regard to account number 02700 100 11682, from which the impugned deductions have been made, it is seen that the same is different from the account number of the borrower as given in the sanction letter dated February 26, 2018, annexed at page 15 of the writ petition. The series of amounts deposited in the said pension account goes on to show that virtually all of those pertain to payments of pension made by the ex-employer of the petitioner. As such, there cannot be any manner of doubt that the account in question from which the deductions were made is almost exclusively the pension account of the petitioner. Next para. The petitioner is justified in arguing that Section 31 within bracket
G.
Right. Within Section 31 within bracket small g of the Surfacey Act clearly provides that any properties not liable to attachment fall outside the purview of the Surfacey Act. Hence, the argument of availability of alternative remedy is defeated, as the action taken by the bank cannot count as one under Section 13 of the Surfacey Act itself. The bank has relied on Section 13 within bracket 11, which provides that without prejudice to the rights conferred on the secured creditor under or by the section, the secured creditor shall be entitled to proceed against the guarantors or sell the pledged assets without first taking any of the measures specified in clauses small a to small d of subsection 4 in relation to secured assets under the Act. There is no manner of doubt insofar as the guarantor's liabilities being coextensive with the borrower. However, the issue at hand is whether, in view of the specific exclusion in Section 31 of pension accounts from the purview of the Act itself, the deduction from the pension account of the petitioner stroke guarantor can be labeled as a measure taken under section 13 of the Act. Full stop. The definitive answer in view of the provisions of the statute as discussed above is a resounding no. Full stop. Next para. Hence, comma, since the principle of section 60 of the Code of Civil Procedure has been applied by section 31 within bracket small g of the Surfacey Act itself, comma, the defense of the bank that the provisions of section 60 is not applicable cannot also be tenable in the eye of law. Full stop. Thus, comma, the impugned action of the respondent bank in deducting the amounts substantially from the pension account of the petitioner is palpably dehors the law and dehors the provisions of the Surfacey Act itself, comma, thereby making such action amenable to the writ jurisdiction of this code. Full stop. Thus, hence, comma, there is no scope of sustaining the said action of the bank. Full stop. Next para. Accordingly, WPA 7639 of 2024 is allowed on contest, comma, thereby directing the respondent bank to reverse the withdrawals of all the amounts from the pension account of the petitioner bearing account number 027001100111682 lying with the UCO Bank within a week from date. Full stop. The respondent bank is further restrained by an order of injunction from deducting any amount from the said pension account of the petitioner in terms of the perceived rights of the respondent bank with regard to the non-payment of the loan taken by the petitioner's son. Full stop. However, comma, it is made clear that nothing in this order shall preclude or prevent the respondent bank from taking any other due measures as sanctioned by law to recover the amount of loan which has not been repaid by the petitioner's son, the borrower, and to take other steps than that impugned herein, even against the petitioner stroke guarantor, comma, if otherwise sanctioned by law. No rest to cause urgency.
My lord, may I make one submission, my lord? Perhaps my lord has recorded that all amounts have to be reverted, my lord. May I kindly just indicate it's only the 2nd March 2024 amount that
all the deductions.
There's only one deduction, my lord, in respect of recovery. That is the 2nd March 2024 one. That is an amount of 34,000.
There is no other deduction at all.
In fact, yes.
Acha, very well. All the deductions made by the bank, the deduction made by the bank on March 2, 2024 to the tune of rupees 34,938 shall be reverted back.
Great.
Thank you for pointing it out.
Great.
Good argument. Yes. And Mr. Kormokar, your learned junior also argued very well. I'm not trying to be gracious, but they really argued very well. Thank you. Next. Oh. The Baki আছে দেখুন
39.
Yes.
Lord, I have developed a property, Lord, a multi-story building.
Yes.
I applied for electricity connection.
I've got the state, your lordship.
I've-
Distribution company, lordship.
Lord, I have applied for electricity connection for the building. Lord, the electricity company said that I have to install a transformer. Lord, I applied to the Restraint municipality, asking them to allow me to install the transformer on the municipal road. The permission is granted by the municipality. The quotation was issued. I paid the entire amount. They came to install. The local councillor, rather ex-councillor, and 2 or 3 shop owners of the building that I constructed, they didn't allow them to do that. Page 26.
This is a private dispute then.
They have not taken the law in their own hand, forcefully stopped them from installing. I need police help, Lord, so that they could install. Kindly have a look at it, Lord. Page 26.
Have they been served, these persons?
Lord, 3 private respondents are there. 2
Yes.
have received.
Who have received?
1 take a receipt করেছে নামগুলো বলো
Who is the councillor? Which respondent?
Lord, he is not made a party, Lord.
You're
my
making
Lord,
allegations.
The later they said, I didn't say that. They are saying
They mentioned these 3 people.
they mentioned the councillor, they named the councillor and the shopkeepers. I have made the shopkeepers party. Who are
Councillor also has to be made a party. He might have something to say.
If my lord,
Why
grants
this is the an open and shut matter, why didn't you implement
Making the politician a party, my lord, is sometimes difficult, my lord,
is
for
it?
the persons, my lord. My lord may understand it may have some other
Since
repercussions.
when, Mr. Chakraborty?
Not for me.
Making politicians a party.
I'll add him and come back.
This is the most outlandish excuse I've seen for non-implement of a necessary party. Most outlandish.
I'll add him and come back.
I'll record that in my order that this is the most outstanding,
Not record, but
outlandish.
I'll add him and come back.
The allegations of the petitioner is that
Shubhajit
despite
Sarkar. Shubhajit Sarkar.
the allegation of the petitioner is that despite having obtained permission from the respondent number 6, that is the chairman, Rishra municipality, for installation of a transformer to electrify the premises developed by the petitioner, and the WBSEDCL being otherwise agreeable to do so subject to compliance of formalities, comma.
Lordship, I have not yet received any instruction. Just 2 minutes back, I have received
No,
a copy.
his submission. Comma, such connection cannot be given to the petitioner due to resistance by the private respondents and a councillor of the area, comma, who has been named by the WBSEDCL. This is WBSEDCL.
Yes, sir.
By the WBSEDCL in its communication to the petitioner. Full stop. At the outset, comma, even without going into a hearing, even without hearing the learned counsel for the respondents, comma, it transpires that the councillor named by the WBSEDCL, according to the petitioner, has not been impleaded as a party to the present writ petition. Full stop. Hence, the petitioner is directed to implead the said objector stroke councillor as a party respondent. Full stop. Necessary amendment to the cause title of the writ petition shall be carried out by the learned advocate and record for the petitioner during the course of the day. Full stop. Copies of the amended writ petition shall be served on the added respondent, indicating that the matter shall be listed on. Tell me the date.
It's in
2 weeks.
Risra.
2 weeks.
1 week it will be done. It's in Risra. So
Very well.
should not take much time.
Returnable on April 8, 2024. Full stop. Next para. The affidavit of service filed today be kept on record. One has not been.
Not only respondent number 8, it's showing dispatched, but other 2 respondents have received it.
Very well. I've not recorded your submissions because non-joinder, let them implead that person, then we'll.
Lord, may it appear under the same heading, Lord, it's appearing as updated.
Yes, April 8, 2024, under the same heading.
I'm grateful, Lordship.
Yes,
You're appearing?
for the respondent.
If you are appearing, then I cannot hear it in 3 minutes.
Yes.
And you are also there, so let me see if there is any. I already set a name. 2 minutes ago, no matter. I've not called this officially because if I call this, it goes down.
Yes.
Very well.
Grateful, my lord.
Original side matters. Any mentioning? Listed matter item number 1, court application Continental Chemical Corporation and others versus West Bengal Small Industries Development
Yes,
Corporation
Mr.
Limited.
Pincher, let us resume.
I am
Yes.
for the respondent.
Right. You are for respond number? All the response. Very well. Yes.
Shall I start from the beginning or shall I
Please
start from the
indicate,
scheme?
just brush up once, Mr. Pincher. Because
Your Honor, the respondents introduced
Mr. Pincher, please take the microphone a bit closer.
the respondents introduced a scheme. I'll come to the scheme a little later.
Yes.
I applied for the scheme. Please turn to page 117.
It's a subsidy scheme, you said.
Yes, it's a scheme for renewal of lease
Oh,
as
yes.
well as settlement of disputes.
Right.
I was denied the scheme.
Yes.
Page 117.
Yes.
With just a 2-liner after a hearing.
Yes.
A 2-liner, please follow earlier orders.
Page 17, 117.
117.
Decision taken in hearing.
With reference to the subject cited above, this is to inform you that the corporation has decided to ask you to comply with the order of the Managing Director, WBSIDCL, dated 4/5/2015 and 29/5/2015, and to execute and register lease deed immediately.
So this is
I
not
was
the
denied
refusal.
the scheme. I was denied the scheme. I was asked to follow earlier orders.
Acha, acha.
So I came to the court in appeal. Your Honor, the order of the I came to the court in a writ petition.
Yes.
The writ is on page 125. Please turn to page 132, paragraph 21. When the court asked them that what is the reason for denying me the scheme, they said that number one, I had not executed, I had not registered a lease deed in my.
Sir, which I'll disturb you for half a minute.
Yes, sir.
What is the difference between the scheme and the previous order? I mean, by the
Sir,
previous order, you had to execute a deed.
By the previous order, I was to execute a deed at a rate of 30 lakhs per kattha, which they have now reduced to 4 lakhs per kattha.
All right. Very.
In the previous, this thing.
That is the primary difference.
Primary.
Very. Let us come back to page 132.
Okay, page 132.
Yes, I'm there.
When the judge asked them that, why are you denying him the scheme? They said, number one, I'm a defaulter and hence not eligible for this scheme. And number two, I had not registered the lease deed in my favor. So I was not eligible. On page 132,
yes,
the petitioners have not been able to make out any case of discrimination. There is no evidence on record to show that other allottees have been given special treatment or benefits which have been denied to the petitioners. Even if it is assumed that other existing allottees have been given the benefit of a scheme, the petitioner's continuing default with regard to payment of occupational charges makes the alleged discrimination irrelevant. Para 22, last 3 lines. The statement made on behalf of the corporation that the corporation will take steps against persons who are on the same footing as the petitioners is recorded. Based on this, my writ was dismissed. I went into appeal. Prior to appeal, after my filing of appeal, they settled the case of Gravo Prints.
Yes, yes.
The Gravo Prints settlement is on page 138. Means I've given a sheet, a similarity, a chart.
The chart, yes.
Sir, page 138. Gravo Prints' first allotment was in 1984. My first allotment, petition number 1, Continental Chemical, it was in 1986. Gravo Prints' lease expired in 1993. My lease expired in 1992.
Mr. Pincham, what are the relevant differences? I mean, relevant to the context, according to them?
The relevant...
and there are certain differences in dates, obviously there are.
Yes.
What are the relevant in the
The
context?
similarities are that we both became defaulters.
Yes.
I
Argue in their favor for a minute, Mr. Pincham, so that you can controvert that. Argue in their favor. According to them, what could be the important differential factors?
The only difference is that Continental Chemical, the original lease deed was in the name of a proprietor, S.S. Agarwal, who failed. And I took over in 1991. Whereas Gravo Prints has continued through and through. So the initial lease deed.
Gravo did not default.
No, he also defaulted.
But
Gravo means the original lease deed was in the name of the proprietor, the current proprietor of Gravo Prints.
Which continued?
Which continues. Which means which expired in 1992.
Yes,
but he has continued.
He has continued.
He has continued till date.
And you took over in case of...
I took over in 1991.
You took over by a mutual treaty. I mean,
no, I informed them also.
Achha.
I informed them, they accepted my the change.
So according to you, that is not a relevant differential.
No, sir. Because I gave them my... I asked them to register the lease in my name. I submitted all the documents. They agreed to register the lease, but just kept making excuses of not executing. I'll come to that also.
Right.
So other than that, the similarities are, I became a defaulter in 2014 when my rent was increased from 12,000 to 5 lakhs per month.
Yes.
Gravo Prints became a defaulter in 2018 when he also received these kind of bills. Gravo Prints default, item number 8.
So only the change of ownership is the difference between
is the difference. Yes, Your Honor.
The rest are more or less same.
Yes. I became a defaulter in 2014, Gravo in
more or less contemporaneous.
Yes. But Gravo Prints was allowed this scheme. His accounts were settled on the basis of this scheme, and now he has registered his lease on the basis of this scheme, while I have been denied this scheme.
In fact, you are on a better position in item 15. Because amount payable towards arrears as per special scheme, they were to pay 3,14,000.
Yes.
You are not to pay anything. This is not applicable to you.
No, not applicable. Since they denied the scheme to me, then it becomes not applicable to me.
Let us continue. Yes.
So
what happened in the appellate court?
The appellate court, I placed all these documents, Gravo Prince documents showing his all his papers were shown.
Yes.
So based on that, the appellate court writes, by the said order, the writ petition filed by the appellant was dismissed, wherein the writ petitioner sought for benefit of a special scheme announced by the respondent. The appellant's case is that they are entitled for the benefit of the special scheme, which was recorded in the minutes of meeting held between WBSIDCL and the Entrepreneurs Association of Behala Industrial Estate.
It's a picture. Let us come to the last paragraph directly. I mean, the rest is unnecessary. This is the crux.
In light of the above, we dispose of the appeal by directing the appellant to submit a representation to the managing director of the respondent, enclosing copies of the documents by which the benefits of the scheme, of the special scheme, was granted to Messrs. Gravo Prince, as well as a copy of the order. And on receipt of the said representation, the managing director of the respondent shall afford an opportunity of personal hearing to the partner of the appellant and pass a reasoned order on merits and in accordance with law. This direction shall be complied with within 3 weeks from the date on which the partner of the appellant submits the representation.
You are a partnership firm?
Yes, sir.
All right.
I applied to the MD for against this order.
Yes.
Your Honor, thereafter, please turn to page 166.
This is that order.
This is the order of the managing director.
Yes.
Your Honor, the last paragraph.
Right.
In the course of hearing, the appellant files a written representation before the managing director, stating that the benefit under the special scheme as stated above has been allowed to Messrs. Gravo Prince Prod D3, Behala Industrial Park, and the same should be extended to them also. However, it is clear from a bare reading of the said circular/notification dated 18/2/2021 that to get the benefit of the said circular/notification, one has to either have an existing lease agreement or an expired lease agreement with the respondents herein. But record shows that the appellant neither has a lease agreement nor any deed in the form of a lease agreement, either existing or expired, with the respondents herein. More so, it is mentioned that the said circular notification dated 18/2/21 that to avail the benefits of the scheme, unit had to apply within 3 months from the circular notification dated 18/2/21, and the said scheme will be in force till 31/12/21. And to get the opportunity of the said scheme, the allottee will have to apply within 3 months from the date of issue of the said circular/notification. But the appellant herein prayed for availing the scheme benefit on 16/9/21, as such as stated by the appellant himself in the course of the hearing, which is also after the date of the expiration of the scheme, benefit as proposed in the said circular or notification. And then after a few lines, a mere letter of allotment cannot constitute a valid lease in the absence of a lease agreement.
Right.
Your Honor, now I'd like to place the scheme before you. The scheme is on page 107.
Yes, please.
Your Honor, the first was a meeting between the Entrepreneurs Association and WBSIDCL, wherein they introduced the scheme. It was on the 13th of October 2020.
Great.
Honorable Chairman took the chair and welcomed the members present in the meeting and started the proceedings. Managing Director briefed that WBSIDCL has decided to introduce a special scheme and rate for old and existing entrepreneurs of Behala Industrial and Commercial Estate as described below. The second part is the rate to be paid and the scheme of settlement. The circular in this regard was is on page 108. This
Mr. Pincher, I require a clarification on this. This Continental Chemical Corporation, it is a partnership firm of which you are one of the partners.
partners.
What was the character of the previous entity from which you took over?
Proprietorship
Proprietorship of
of
somebody
SS
else, third
somebody
party.
else, a third party.
So you are a new entity, new entrant in there.
Yes.
So you did not have a previous
But
lease or something
I
like that.
took over the company as a going concern. I paid all his liabilities to WBFC, WBSIDC.
No,
So-
was there any CIRP or nothing like that? No corporate resolution process like
No, this is a
private trade, private agreement.
Partnership and proprietorship company. So there
This scheme is for old and existing entrepreneurs.
Yes, sir.
You are not one of them.
I am an old and existing entrepreneur.
Hmm.
In fact, if you go to the next page, page 108, the circular,
Yes.
the board of directors of WBSIDCL in its 359th meeting held in 10/2/21 has decided to launch a special scheme for conversion of lease from short term to long term in respect of existing allottees of Behala Industrial Estate.
This is probably very important. Yes.
This is the only criteria for this scheme, Your Honor.
So allottee, the moment they say allottee,
Yes, Your
letter of the allotment is
Yes, Your Honor. That is what I want to say. That this is for the existing allottees, and the letter of allotment in 2004 in my favor is what is sacrosanct. What is the
page number of the letter of allotment?
It's on page 71. It's on page 71 and on, Your Honor, 1 minute. I'll just page 146 also.
Same.
Yes, same. Accordingly, the scheme is hereby launched with the following terms and conditions. This special scheme will be valid up to 31/12/21. To get the opportunity of this scheme, the allottee shall have to apply within 3 months from the date of issuance of this notification/circular. First, long-term lease will be for 99 years. Secondly, market price declared was 30 lakhs. Rebate announced was 50%.
The rest follows. Once
follows.
you are an allottee, within the contemplation of this,
The rest follows. And the settlement scheme, that is, it comes later on. Bullet point number 5.
This 2004 allotment was given to Continental before you came.
No, after I came. Means I came in 91. Since then, I have been in various.
Oh, you were there since 91.
Yes, Your Honor. And this letter of allotment is based on an order of the chairman who gave us a hearing. And based on that, that letter of allotment was issued to us. If you will see page.
Yes, sir. The scheme is of 2020 and you are there from 1991.
Yes, Your Honor.
That by definition makes you an old and existing entrepreneur.
And please turn to.
Yes.
Okay. 1 minute, Your Honor. MD का order, हाँ, ये वाले कौन से page पे? Your Honor, please turn to page 69.
Yes.
To Continental Chemical Corporation, reconciliation of accounts of shed number is given. Your letter dated is given. Page 70. The first line. The above reconciliation has been done in the presence of Sri Ashok Pincha, partner of Messrs. Continental Chemical Corporation. After this reconciliation was done, an amount of 1,48,000 was made payable by me, which I paid. After this payment, this offer/allotment letter was issued in my favor.
Page 71, you say, is the allotment letter?
Yes, page 71 is the allotment letter. So after I had paid the amount due that they had calculated, this letter was issued to me.
All right.
Now, Your Honor,
so one ground goes according to you. I mean,
yes. Now, the second ground of the MD that I applied late.
yes.
Your Honor, now I'll go back
So
to
this is the impugned order. Page 166 is the impugned order.
166, 167.
Yes, obviously.
I'll go back to the scheme.
Right.
Page 110. After the scheme had been introduced, there were some doubts in our minds, the association mind. So this is the next meeting between the association and the Entrepreneurs Association and WBSIDCL. 110.
Yes.
Your Honor, on page 111, the second paragraph, as directed by the Honorable Chairman and Managing Director, Finance Officer has explained that in the case of outstanding dues, the old rate has been taken into consideration. Only enhancement of rate has been applied as per the initial lease deed or offer letter, which was not reflected in the last issued rent bill. No new rate or illogical abnormal rate has been applied while calculating the outstanding dues. Since we had all received 40 times our rent bills, we were thinking that everybody will be given that kind of outstanding due. So this is why they clarified that those abnormal bills will not be taken into consideration. Only the rate applied as per the initial lease deed or offer letter. So offer letter and allotment letter is one and the same.
Offer letter is the letter of allotment.
Yes, sir. Sir, thereafter, the circular, they issued another circular, which is on page 112.
Yes.
Here again, they write a special scheme for conversion of short-term to long-term in respect of existing allottees of Behala Industrial Park. In this circular, they reduced the one-time payment from 5 lakhs to 4 lakhs. And they enhanced the time, the validity of the scheme by 180 days from the date of the circular. And those who wanted to take the benefit of the one-time payment of 4 lakhs had to apply within 90 days.
Where do I get that?
So first, bullet point 1, 20% rebate will be given against the earlier rate of 5 lakhs fixed for one shot payment. That is 4 lakhs per katta, subject to the condition that the facility will be applicable for 90 days from the date of issuance of this revised circular.
So this is that 3 month they are referring to.
No, the 3 month they are referring to is the first circular.
The first one.
First one. Where I had delayed in applying.
What were the timelines? I mean, just
the timelines.
Should I find it from page 107? The date, last
No,
date.
108, Your Honor.
108.
They issued the on 18/2/21.
Yes, what is the
scheme was
timeline?
valid up to 31/12/21.
Oh, right.
Thereafter, they again, page 112.
So you, Mr. Pincha, you are trying to take advantage, not in a bad sense, I mean, you are taking advantage of the fact, two things. One is that there was a discussion, there was some scope of doubt, old rate, new rate. And secondly, the circular of page 112, which gave further 90 days.
Yes.
Do you mean to say that?
Yes. So in page 112, they from 25/8/22, they extended it to by 90 days for applying for the 4 lakhs. But the entire scheme was extended by 180 days, 6 months. So approximately 24 to 23.
Yes.
So, Your Honor, now please come to page 122. Please keep this 112 also.
Yes.
Page 122. Your Honor, the letter is dated 23/12/22. Your Honor, and last paragraph. We further state that we are desirous to go forward with option A, deferred payment of the special scheme for conversion of short-term lease to long-term lease for existing allottees of Behala Industrial Estate, issued by circular number this dated this. So I reapplied within the second timeline, within the second time that they gave the this option. This scheme was further extended up to 15th of March, which is on page 113. But this is irrelevant since I had already applied again.
Yes.
Now, Your Honor, supplementary. The supplementary affidavit, Your Honor.
Yes.
Page 6, the last page. Your Honor, when they introduced the scheme of 4 lakhs, they introduced it on 25/8/22. So based on that, within 90 days, one had to apply for the 4 lakhs. 90 days is 24/11/22. Your Honor, please read this. This is to Coronet Plastics Private Limited. Page 6 of the
Which is not you. Which is not you.
No. This is another entrepreneur in Behala, another allottee.
They were permitted after that period.
Yes, Your Honor. But reference 1, reference 2. Please read reference 2. Your application number nil, dated 30th/12/22.
Yes, that is why I asked you. I saw that.
30th/12. He applied approximately 1.5 months after the expiry of the 4 lakhs offer. And he has been issued an allotment offer letter, and he has already registered his lease.
Mr. Pincha, there can be an argument that, I mean, 2 wrongs do not make a right, but you may have a valid argument in saying that they themselves treated that to be directory, not mandatory.
Yes.
Because otherwise there cannot be a negative equality. If this person, they did wrong in favor of this person, you cannot claim a negative equality. But this can, in a different way, you may say that that was relaxed.
If they are relaxing for one person, they have to relax for the others also.
If that relaxation, Mr. Pincha, is illegal, something unlawful done for one person, that cannot be a handle for another person to.
Even if you don't take this into consideration, I have already applied again.
Have applied, and not only that, that relaxation itself may indicate also, subject to what your learned friend says, that was not mandatory. I mean, it was a relaxable clause, directory.
Because overall scheme was extended by 180 days.
Yes, yes.
And they are desirous of settling all disputes. Otherwise, why in this scheme would they write all legal cases will have to be withdrawn to get the benefit of the scheme? They want to settle everybody's
Obviously,
disputes.
yes. Yes. You did not have any other legal case?
No, at this time, no. When I applied to them, I had no. Otherwise, there were 6 or 7 cases that I've gone. But at this time, I had no case.
So this is your...
Yes, Your Honor.
Let us hear them. Yes.
যখন পেপারটা দেওয়া হয় তখন উনি রিট ফাইল করেছিলেন, আর তখন থেকেই যখন ক্লেম হয় 3 কোটিটা 5 crore হয়ে গেছে।
The outstanding dues of my learned friend Lordship more than 5 crores nowadays. Now, Lordship, kindly turn to 166, the order which has been passed by the managing director on the basis of the direction of our division and Presidential Justice, Chief Justice.
Yes. Can you please take the microphone a bit closer to you?
Yes.
Yes.
In compliance, I am reading this portion, Lordships. Page 66, Annexure P41.
This has been placed just now by Mr. Pincha. If you want to highlight it.
Not everything has been placed, Lordship. The difference, Lordship, is this.
Yes.
So only with regard to this, those who are the lessee, either existing or expiry, they will give the special benefit. Those who have there is no execution of the lease, they will not give that particular benefit.
Now, where do I get that in the scheme?
Yes, scheme.
Show me from the scheme that this is there.
I am reading this order, Lordship, then Lordship.
Definitely, in your own way.
Yes. Lordship.
The order actually I've seen. You need not, I mean, there are 2 or 3 grounds given here.
Yes.
2 grounds actually.
Yes.
One is that he did not have a lease agreement, which is a prerequisite of this scheme. Second is delay beyond 3 months.
Yes.
And third is actually 1.5, because third says a letter of allotment is not a lease, which takes us back to the first point.
Yes.
So no lease agreement, letter of allotment is not a lease, and delay of more than 3 months. These are the two grounds.
There is a huge dues, Lordship, from him, Lordship, more than from 4 crore from the inception.
Dues were there also for Gravo, which the division bench touched by
Yes,
saying that
Gravo is not the same on the same stand, Lordship, with the present
why not
petition.
Why not?
Gravo is the existing leaseholder, Lordship, that was expired.
So then we fall back again on the lease. So Gravo also had default. Because you are harping on their huge dues, Gravo also had dues. But the distinguishing feature, according to you, is the lease agreement.
Lease agreement, he has not executed time and again. Opportunity was given to him to execute the lease. Even the page one.
Bilateral lease deed executed হয়েছিল. With them, there was no existence of a bilateral lease deed being registered. ইনারা lease claim করছে
Lease
on later.
They are claiming the lease on later. No execution of the lease at all, Lordship, any day.
Page 108.
Page 100.
How do you deal with page 108?
Oh, yes.
108 first line. Conversion of lease to page 108. যে lease deedটা by document যেটা আছে page 108. Page 108 এইটা দেখো।
Yes, Lordship. The scheme.
From যাদের
You are saying, I'm telling you what you'll go on to say. This says special scheme for conversion of lease from short term to long term. And Mr. Pincha says the rest of the sentence in respect of the existing allottees. So whether it's allottees versus lessee or those are independent terms, we have to consider this only.
Yes.
ওনারা চাইছেন যে we also come
If there was no previous lease, there could not be any conversion.
Yes.
That is your argument. That's very obvious.
That is the thing. They are claiming that they are the previous lessee, Lordship. That is why, Lordship, they are asking this benefit, Lordship.
not same.
It is not the same, Lordship, as allottees, Lordship, with the lessee, Lordships. And here, Lordship, in the order sheet, Lordship, particularly, the same thing have been particularly.
Order sheet, those are the two grounds I told you. Lease, no lease for him, and the delay.
Yes.
And what about the delay? What is your argument on delay?
Delay, Lordship, time and again, they have, since from the beginning,
yes,
they were asked to execute the lease. They did not prefer any offer to execute the lease with this thing. They are as if they are using the particular property in a central middle business place of Calcutta, Lordships, in a very low premium, Lordships. And it's a
but that is the scheme after all.
No, not
the
that.
scheme is that for others you are giving that.
Lordship, he's enjoying that property, Lordship, and the authority, Lordship. It is their prerogative, Lordship. They are introducing the scheme, Lordship.
Actually, you have been repeatedly requesting them to do what?
To come
To
under center.
under same center.
To
come under a center of a
one of you argue.
আমরা বলছিলাম
Let him.
Mr. Gupta, come over.
extremely
Yes.
to disturb you.
You have repeated.
Gave them an option.
No, what was the request to them?
The request was that since your tenancy or right to continue is not protected by a registered lease deed, you can have this option provided you comply with all those conditions. It is a choice given to the party because their right is not covered by an instrument of.
But could you do that under the scheme if the scheme does not provide?
This scheme,
that's an independent exercise.
This scheme was, my lord, given. If your lordship may kindly look to page 108.
Yes.
This scheme, my lord, directed that one short term will be given another to those who are covered by an instrument already existing. It might be existing or it
is for
expired.
Conversion of already existing short term to long term or whatever the other.
Yes, even though it has expired. Now the other option which was given to other party is that those who are not having a lease deed, they can also take advantage of this provided they agree to the terms and conditions stipulated by the scheme. This scheme makes them mandatory. For
Mr. Gupta, do you understand the implication of that argument?
I'm coming, my lord. I'm coming to that. This scheme made it mandatory that all areas which are lying, existing, has to be cleared. It is post-payment of all area.
Show me one communication from you giving that offer.
Kindly come to page 108. Yes, I will come to that. 108 is the circular. This is Further, your lordship has been.
That does not say what you are saying now. The other alternative.
I'm kindly take page 108. 108, your lordship will find option. The first one gives them a right long-term lease of 99 years. Option A, option B, these are the options given to the parties. Now come to the terms and conditions which are appended underneath this. If the lease is expired, then arrear amount will be calculated and informed to the unit. Arrear should be cleared till the previous month to get eligible for the scheme. This makes imperative that all arrears must come to an end to have a benefit of this. All interest, all cases have to be withdrawn at that point of time which was pending. Now, my learned friend, my lord, what he did, that when he was given this circular, he came in High Court by filing a writ petition, claimed that this is unjust to him. I found, my lord, from the record I have been informed, there have been in 2004 writ petition appeal, in 2014 writ petition appeal. These all proceedings were taken the moment he was asked to pay the arrears. Now it is a choice given to a party that you pay, and if you like this, you can derive this.
But Mr. Gupta,
my lord,
still, even if this term and condition, the terms and conditions of payment of arrears is to be complied with, still then the first argument remains. Still then he has to have a lease according to your argument.
At that point of
but
time,
the others were given this offer who did not have a lease deed.
At that point,
But as per this, if you insist on this arrear, they have to have a lease in the first place, according to your argument.
The intention was to bring all within the umbrella.
But the moment you say that, that is arbitrary. You are making a distinction according to your whims without following the scheme then. If others were allowed, how were they allowed?
No, the scheme which was, my lord, given.
Either you adhere to the scheme,
yes,
or you, on transparent basis, you give equal opportunity to all others.
Kindly, my lord, who are entitled to the scheme.
Yes.
Now, my lord, it makes imperative that if you want to have a long-term lease deed,
Areas to be cleared.
All areas to be cleared.
If he did not have a lease deed, how could you give him the offer repeated requests?
Now, if he do not have the lease deed, it, my lord, shows that the occupation charge which he was making payment of must be cleared by that period if he intends to have a benefit of this. That means there is no due existing. The purpose was that in case there is no due existing and all arrears are cleared.
But due is not even a ground in your in the order impugned here.
I am coming, my lord, to that.
Only 3 months delay and lease agreement not being there.
2018.
The new ground you are making for the first time.
It's not. It's not embedded in his all writ petitions. He has annexed
the impugned orders gives 2 grounds. One is there was no lease agreement for him. Second is that he made a delay of 3 months, more than 3 months. There is no mention, no whisper whatsoever of this ground of yours. That repeated requests, he did not pay. There was an exception made for some.
My lord, it has been gone into extensively by the writ court. If your lordship, my lord, wants, I should take your lordship to the order passed by the writ court by my lord Justice Misuse Bhattacharya. Dealing with all, it was dismissed.
But that has culminated. Justice Bhattacharya's order. No. That has culminated in a division bench, which took the shape of the impugned order last
Kindly
week.
come to the this is order passed by the division bench. How it has culminated.
Come there.
Now, my lord, your lordship will find, because the division bench, I must, my lord, with great respect to their lordship, I shouldn't say.
That means you are going to abuse the
judicial discipline gives me a bit. But
maintain the discipline, Mr.
My lord.
Don't say anything.
Now, my lord, what has happened?
Yes.
Before the division bench, an argument, a case was thrown away to the division bench that apart from the order which has been passed by the writ court, as if not to go into the propriety or correctness of the writ.
Cannot reopen the division bench finding.
No.
So let us not argue on those. Whatever is there in the division bench directive, that has to be
followed. May kindly come to the order of the single judge, how far it has merged with the order of division bench, and whether it has brushed aside the order passed by single judge, and to what extent their lordship. I am coming to the order itself. Page number APO 135, your lordship will
135?
return to 135.
Yes.
One-
135 division means starts.
135 hai to, huh? Yes, 135. Kindly, my lord, take
Para
up
21 of the single bench may help you. Para
Para
21. You just
21.
please come to para 21, page 132.
132.
It begins from there, continuing default on his part with regard to payment of occupational charges, which you are harping.
Yes, my lord, it starts from page paragraph 13. It starts, I may not trouble your lordship to all those, but I will come to the relevant part itself. It starts from page 125. Now, I'm sorry, 125 is the order passed by the read court. Your lordship may kindly ignore.
Sir Gupta, your arguments are
Page 135.
your arguments are encapsulated in para 20 onwards, 20, 21, 22.
Para 20 of read court, your lordship.
Of the read court, single judge, which you are placing.
Your lordship
Please come
was
to para
trying
20,
to-
132.
My lord, before I go to the read court, as it felt from your lordship that your lordship would look after the appellate court order. I go to the appellate court, then come back to that.
No, not that. Mr. Gupta, I have read the appellate
Yes,
court
yes.
ad nauseum. Please come to para 20 of page 1.
Para 20. The petitioner's reliance on the minute dated 13/10/2022 is misplaced since the alleged benefit of the special scheme for old and existing entrepreneurs were made conditional upon previous dues being cleared. Post payment only the scheme is available. Consequent to, sorry sir, consequent.
Yes. I don't need a commentary on that. Just read the judge.
The writ petitioner do not qualify for the said scheme as the writ petitioner failed to clear the arrears and hence remained a defaulter. Also in the order passed by managing director dated 6/4/15 and 29/5/15. The contention of the corporation did not communicate the amounts of the petitioner is incorrect, as would appear from numerous notices issued by corporation to the petitioner both before and after the minutes dated 13/10/20. Reference in this regard may be made to the notice dated 19/4/18 and 11/2/22. These are demand notice claiming 3 crore and above in 2018, which he has annexed in this writ petition also. The petitioner cannot seek any benefit under new scheme while continuing to defend defaulters. The petitioner have stalled not only payment of arrear, but also execution of lease deed with respondent number 1 while enjoying the benefit of 3 plots. The arrears are due from August 2014. Not a single payment made since August 2014. The moment there has been a demand, there has been litigation. There has never been any order of stay or setting aside the demand.
Next para also helps.
Petitioners have also not been able to make out any case of discrimination. There is no evidence on record to show that other allottees have been given special treatment or benefit which have been denied to the petitioner. Even if it is assumed that other existing allottees have been given the benefit of a scheme, the petitioner continuing default with regard to payment of occupational charge makes the alleged discrimination irrelevant.
So this is the crux of what you are saying.
Crux of the matter. And this
You are
is
starting from page 125.
I'm sorry, this is in consonance with the scheme itself. Post pay, show your intention to have benefit or not. It's not like a statute.
But the difficulty, Mr. Gupta, is this is an additional ground which does not find place in the page 166 order.
Now, my lord, what is noticeable is kindly come to page 135. How the appellate
135, yes.
135.
Yes.
Now, one thing your lordship will find, the order which was assailed by
I understand your point,
has
Mr. Gupta.
not been set aside.
This was never touched.
It remains. It's not merger.
At least the findings remain.
My lord, your lordship, it's for your lordship. By the said writ petition, the intra-court appeal is against us. By the said order, writ petitioner was dismissed, wherein the writ petition sought for special scheme announced by the respondent. The appellant case is that they are entitled to the benefit under the scheme which was recorded in minutes of meeting held in between WBSI DCL, the Entrepreneur Association of Behala Industrial Estate on 13/10/20. The writ petitioner was dismissed by the learned single judge on the ground that the appellant was a defaulter and the appellant has not been able to bring on record any document to show that similarly placed defaulter allotee.
So it was on an entirely different ground that it was sent back.
Now, my lord, what has been done? Just akin to what now is happening. a supplementary affidavit filed and a case of other is being sought to be placed, so that the discrimination alleged in supplementary affidavit against that may be adjudicated. And this he reaps benefit for years since 2014. This what has actually happened.
Thereby perpetuating his occupation also.
Since 2014.
That is your allegation.
This is clarified in the order also. In the appeal, the appellant appeared in person and has brought to the notice of the court at that point of time that Gravo Behala Industrial, the benefit of special scheme has been granted, though he was a defaulter. However, this document was not placed before the writ court, and the explanation given by the appellant is that the lease deed was executed in favor of Bravo on 21/8/23, much after the writ petition which was dismissed on 23. In the light of above, we dispose of the appeal by directing the appellant to submit a representation to MD of respondent enclosing copies of the benefit scheme granted to Gravo. As a copy of this order on receipt, the managing director of the respondent shall afford an opportunity of personal hearing this direction to be complied. Now, my lord, the principle of merger gets applied if a impugned judgment is set aside, gone into, decided, taken care of. This remains even before the division bench. One which he had that discrimination, consider this representation. This, by this consideration of representation, he cannot escape all since 2014, because the other writ petitions also he has filed and all orders are available before your lordship. Since in 2004, in 2009, in 2014, and the last one is this one. Therefore, by filing all these writ petitions, he questions rate, payment, charges, but he never adhered to not even the existing occupational charge were paid since 2014. Far
Since
less
2014, he has not paid anything.
nothing. Now, my lord, not even yesterday I was incorrect. My friend said that he has paid everything. Therefore, I have to take instruction, and they said it is more than 5.5 crore, the outstanding which was not paid. In 2018, when 3 crore 60 was there, writ was filed. There was never any stay nor order set aside. Now, this, when it exists, he cannot say, my lord, that discrimination is alleged, because the discrimination of page 106 also, to which attention was brought, that is page 112, kindly have a look to. It was argued that there was extension of time. This extension will also post payments, these are all. Therefore, having not paid or complied with these two, 108 or 112, and having not withdrawn the pending litigation at that point of time, even under these two, 108 and 102, having not, my lord, acceded and complied, he cannot make any case that he is governed by this. Prima facie, it goes away. Nothing more. And already eviction notice has been issued. He have filed an appeal before the appellate authority.
Eviction notice under 71 Act.
Yes, yes. That is his fixed for hearing. I have been.
That is under the 71 Act.
Yes, 76 Act, my lord. That is fixed on.
76 Act, which is the 76 Act? Government premises.
Because it is public premises, government premises. The hearing before the appellate authority.
Oh, this is state government. You are right.
Yes.
76.
He's fixed on 2nd April 2024.
Yes.
He has filed an appeal against the order of appellate authority.
That is independent of that. I
Yes,
won't
yes.
interdict with
Yes,
that. He is not also asking for that.
This is not.
That will have take its own course.
Therefore-
Subject to this, of course. I mean, if he gets a right here, then
Therefore, all that I will say, even under these two schemes, having not complied with the condition laid down under the scheme,
so payment was a sine qua non, which he did not do, and withdrawal of litigation also you are at.
and it was
And Justice Bhattacharya held about that default, which was
everything
not upset by the division bench, and which still remains. That is your condition. Well,
by going into entire proceeding, because it's a lengthy judgment dealing with all that, how there has been no discrimination at all, because it cannot extend. The option given to a party by 108 or 112 cannot be enlarged by an authority. It must be confined to what has been given.
Well,
I'm grateful.
thank you. Yes, Mr. Panchayat. Reply.
Page 106.
It cannot go on by turns, either you or him.
No, no,
I won't hear you also. Since he has argued,
I'm sorry.
I'm sorry, I'm sorry.
I gave you that option. Either you or me.
I'm sorry, Willard. Only we would like to that he has not complied because my learned friend has taken your lordship to page 146.
He may be erudite, but he cannot be learned.
No, I'm sorry. Page 147 underneath.
Page 147.
146 and 147.
What is that?
147, last paragraph, your lordship will see. This first part has been read to your lordship. The last concluding part is that all the payments are to be deposited at this office within 30 days. This clause was not read.
This is page?
Page 146.
Yes.
It ends at 147, last paragraph. 147.
30 days, yes.
Please note, therefore, it was placed
No,
before
he says that probably he has complied with this.
No, it has never been complied with. Page 147, it has not been complied.
I have a note here that done. I mean,
yes.
Apparently, it was done by him.
Are to be deposited at this office within 30 days from the issue of the letter. This was not done. No 2014 or 2008 or 2012 was also complied. 108 and 112. This was also not complied. Now, therefore, having not complied 108 and 112 circulars, there is no scope of consideration.
Right. Yes.
Your Honor, it's wrong to say that I didn't comply.
Yes.
Paid all of those dues.
Yes, you said on the last occasion, page
yes,
147, at least you did comply.
Yes, I complied with.
Have you annexed anything to prove that?
Let's check it out.
Yes.
Your Honor, I would like to please turn to page 169. It's letter dated 8th December 1998. Enclosed, please find deed of renewal for our shed number 6/1. There are 3 letters like this, as follows. Original copy duly signed and stamped with non-judicial stamp paper of 3,500 with plan. Duplicate copy on demi paper, white copy. This is the first time that I sent them the lease deed for registration. Sir, next page. On 14/1/1999, they returned it with, these are the errors. The next page, 11/2/1999. Your letter number, this renewal of lease deed. Enclosed, please find herewith renewal of our lease agreement for the above mentioned. I returned it back to them after corrections. Next page, Your Honor. 26/2000. This is the letter from the executive director. This is to refer to your letter number nil dated 11/2/1999 and to inform you that the documents furnished for execution and registration of renewal of lease deed agreement have been forwarded to the Secretary, West Bengal Small Industries Development Corporation Limited for further action. We would request you to execute and register the lease deed within the next 10 days after fixing a suitable date on personal contact to the Secretary, WBSIDC Limited. They directed for thing, but immediately after that on 1/8/2000, renewal of lease deed, you are hereby requested to meet the assistant manager on any working day in the office in making prior appointment over telephone. This is in relation to some rectification in the lease documents and payment of difference in security deposit. They again returned it to me. I returned it back on 16/10/2000. The next page, page 174. Page 175. You are hereby requested to take back the documents submitted by you for resubmission of all the documents after revalidation of the non-judicial stamp paper. The non-judicial stamp paper had expired by then. So they sent it back to me. Your Honor, on 23/10/2002, I again submitted the same. The next page, Your Honor, on 4/6/2004, second last paragraph. You are therefore requested to take back registration documents submitted by you as renewal registration is to be made as per the new draft of lease agreement, which will be sent to you within a short time. It will be sent to you in a short time. Your Honor, next page, 16/6/2008. After, this is the fresh letter of allotment that they gave me. Execution and registration of short-term lease agreements against plot number this.
And what about not paying anything during the entire period?
I have paid. I'll come to that also.
Very well. Let us continue with this. Yes.
It's first I'll just finish how I tried to get the lease done and
right.
how they continue thwarting
Absolutely, yes.
at all stages. You will have to execute and register 3 separate lease agreements with this corporation for 15 years under short-term rental basis, subject to the retrospective effect from 1/1/2004. But they say that we have attached a copy of the all lease deeds will be executed and registered as per our draft lease agreement copy enclosed. This copy was never enclosed.
You seek for that at page 180.
And page 180, I asked them to please give me this. They didn't give me.
Yes.
Your Honor, now page 181 is the extracts of the BOD meeting, Board of Directors meeting of WBSIDCL. Your Honor, on page 184, item number C. As regards implementation of new lease deed, long-term and short-term, as well as long and short assignment deeds, Board was pleased to note that the deeds have been finalized. Your Honor, this finalization is done in 2013.
This is a general meeting, not only regarding you.
No, this is the Board of Directors of WBSIDCL.
They are meeting not for
No.
only regarding you, but the general.
Generally,
all
everybody. So the lease deed that they were making in 2004, which was supposed to be sent to me shortly, was actually finalized in 2013. And in 2013, nobody was informed. Thereafter, they asked me to convert to long-term lease by the order of the managing director, page 185, 186. Similar long-term offers were made to other units, Your Honor, page 187 to Gravo Prints. And the demand from him is 1,26,66,667 in 2018. And this was long-term lease at 30 lakhs per katta.
They say Gravo had a lease previously. You did.
His lease expired in 1992.
But there was a previous expired leases are also within the contemplation of the scheme. They said they had a lease at least. Expired lease, but they had expired lease is also it also comes within the purview, either subsisting or expired.
No, Your Honor. What comes under the purview of the scheme is just allottees.
But the language is
allottees. To convert the short-term lease to long-term lease of the allottees of Behala Industrial Estate. I also had a short-term allotment.
So you say, according to the scheme, lease and allotment is interchangeable, basically.
Obviously, Your Honor. The short-term lease will be converted to long-term lease for the allottees of Behala Industrial Estate. You have to read it in totality.
Very good.
And Gravo Prints also received in 2018.
And they have also relied on page 108, the third last clause. Ideas should be cleared.
Yes, I'll come to that also.
Oh, that will cover regarding the payments.
Yes, Your Honor. Gravo Prince received this 30 lakhs offer. He did not execute his lease deed in 2018. Next page, Laha Machinery, 2018, same offer of 30 lakhs. He also did not execute long-term lease. There are multiple units who received these 4 of them I have attached. None of them executed these long-term lease at 30 lakhs per katta. Your Honor, the next few pages are the number of units whose lease had expired. 70% of the lease in Behala Industrial Estate had expired in 91, 92, 93, like that. And everybody was offered that long-term lease of 30 lakhs per katta for 99 years. Nobody renewed. It is only after this scheme has come, where they have reduced the rate to 4 lakhs per katta, that everybody is interested in now renewing the lease.
Yes.
Next point that I'd like to... Outstandings. Your Honor, please turn to page 75. It's the first book.
Yes.
This is my rent bill for the month of August 2014, Your Honor. Page 75, 76, 77. These are my 3 rent bills for the 3 properties. They total to 12,083. Please, outstanding as on 31/7/2014 at the bottom of the bill. Outstanding dues as on
Page 77
page 75.
or 75 itself.
75, 76, 77, all three are the
Similar, yes.
similar bills. Outstanding dues as on 31/7/2014.
Yes, yes.
Principal 0, interest 0. I had no outstandings as on 31/7/2014. Now, Your Honor, the three bills on 75, 76, and 77 total to 12,083.
Yes.
Now, Your Honor, three bills are on page 78, 79, and 80. These bills are also for the period August 2014, the same period.
Why same period, separate bills?
I
For three
received two
plots.
bills. I received two sets of bills. One was for 12,083, which was in terms of my allotment letter, which I've shown you earlier. And this bill is for 5,01,930.
This was for what?
I had applied for an electrical connection at this time. And they enhanced my rent from 12,083, the agreed rent as per the letter of allotment. And the letter of allotment was valid till 2019. In 2014, they increased my rent from 12,083 to 5,01,930. These are the three bills amounting to 5,01,000. And this is the reason that I became a defaulter. Otherwise, earlier I had no dues with them. I used to take the discount that they offer if you pay before the due date. I used to take those.
Well.
So, calling me a defaulter, I didn't become a defaulter on my choice. They forced me to become a defaulter by this kind of a bill. My billing is at that time was less than 5 lakhs. How can I pay 5 lakhs per month as rent to them? I have huge amount of employees. It's a small scale industry. We run our business on our employees, not on machines. We cannot afford very heavy machines. Thank you. 48. Your Honor, now they have, I'll go back to this scheme. Page 108, Your Honor.
Yes.
Other terms and conditions. The rate incorporated in the lease deed will be taken into consideration till its validity. This is for settlement of outstanding dues. If the lease is expired, then arrear amount will be calculated and informed to the unit on a case-to-case basis. We had doubts regarding this case-to-case basis. How are you going to calculate? The third one, arrear should be cleared till the previous month to get eligible for this scheme. All interest and interest on interest will be waived 100%. Rent, GST, M-tax and other taxes to be paid. This is the settlement scheme.
They say you did not pay the arrears.
Sir, one minute, I'm coming to that. And they clarified on page 111, the clarification is, as directed by the Honorable Chairman and Managing Director, Finance Officer has explained that in case of outstanding dues, the old rate has been taken into consideration. Only enhancement of rate as applied as per the initial lease deed or offer letter, which was not reflected in the last issued rent bill. No new rate or illogical abnormal rate has been applied while calculating the dues. No new rate or illogical abnormal rates have been applied, the ones which they applied to me. So basically, if they were to calculate based on the allotment letter, the outstanding dues. And my outstanding is on page 148. I've calculated that also. Outstanding as on 31st January 2024. The total outstanding comes to 15,31,000. Not the crores that they say it comes to.
This is as per the
old
rate of
as per the old rate and as per the scheme, without taking interest and interest on interest, penal interest into consideration. And I am willing to pay this. That is why I went to them in the first place, asking them to settle my dues. They are settling everybody's dues. Now, please go back to Gravo Print's offer letter, Your Honor.
$187.
140, Your Honor. The new, no, sorry, not 140.
187 crore.
No, Your Honor, 142.
142. Yes.
Bullet point number 4.
Hmm.
You will have to deposit 3,14,500 towards outstanding dues in respect of rent, municipal tax, and GST, excluding interest on rent, which stands as on 28/2/23. Your Honor, they are informing everybody the outstanding dues along with the offer letter. And you have to clear these outstanding dues before you go in for registration of lease. So saying that I did not clear the outstanding to become eligible for this scheme is wrong. It is their duty to calculate my outstanding dues. They have done it for everybody. They have calculated everybody's outstanding dues similarly. If you go into the supplementary affidavit, bullet point number 4.
Yes.
You will have to deposit. This is to Coronet Plastics.
Right.
You will have to deposit 1,50,297 towards outstanding dues in respect of rent, municipal tax, and GST, excluding interest on rent. So they are calculating for everybody and telling them you pay up, and everybody is paying up. I have done my own calculation. I've told them that this is my calculation. You check it and give me send me the offer. I'll pay it. But no, they want crores from me. Something which I can never afford, Your Honor. And this demand of crores is based on those bills. Despite having an allotment letter for 15 years, on the 10th year, they make my rent from 12,000 to 5 lakhs. And now they want payment on that rate.
Where is that enhancement? The enhancement to lakhs? Which page?
Page 70.
When they first asked for that enhancement?
78. 75, 76, and 77 is my actual rent bill.
Yes, yes.
And 78, 79, 80 are the enhanced rent bills. And page 89, the one which says there's want in crores. Page 89 is the demand based on these illogical, abnormal rent bills. And the long-term lease premium, they're asking me for 30 years in this demand, Your Honor. If you will read page 89, long-term lease premium for 30 years is 23,40,000 per katta.
No, this is not in crores.
No, no, Your Honor. They are saying 3 crores, 4 crores. This is not in crores.
But this is in lakhs, whereas previously it was in thousands.
In thousands. Yes.
Right.
Your Honor, the scheme is for the allottees, Your Honor. And I have a short-term lease agreement. They have agreed to register my lease, but they did not register it. I am entitled to this scheme, Your Honor.
Your lease agreement is that page? Just remind me that. Your short-term lease.
The letter of allotment.
That allotment, right?
Yes, Your Honor.
Yes, yes. Mr. Pinch, I'll request you and your learned friend, both of you, to file a very short written notes of arguments. Just refer to the pages, the main line of argument and pages.
Page
I have my notes, but just indicate.
Page 146, Your Honor.
Yes.
you will have to execute and register 3 separate lease deeds with this corporation for 15 years, short-term rental basis. This was a short-term lease basis.
Right.
And now they are converting it into, for all the allottees, they are converting the short-term to the long-term. And all these circulars talk about allottees. There is no mention of leases or expired leases or current leases. It's all about allottees, Your Honor.
Very good. I'll close the arguments and I'll request both. When can you file your short written notes of argument, both of you?
Monday, Your Honor.
Monday you will be able to do it? Yes. Mr.
Monday.
I'll keep it on Monday then?
Wednesday. হলে ভালো।
Wednesday?
Your Honor, Tuesday they have a hearing.
That is
Tuesday.
That has no connection with this direction.
Your Honor, just
In the hearing, you can cite the pendency of this.
Your Honor, I may cite the pendency of these litigations, but if my petition is rejected in in another case,
it will not be over in one day.
Within 2 days, they evicted him after the managing director decided against their appeal.
I have the copy.
No, file it on Monday. Mr. Gupta, you have the week.
No matter. I have the copy that where he challenged all 3 crore amount, which was rejected also.
But Mr. Gupta, on another aspect of the matter.
No, these are all part of his
No,
petition
because
also.
this, unless this adjudication is over, can you pass a final order of eviction? I mean, if he wins here, suppose, theoretically he may win here. If he wins here, then the eviction proceeding goes.
Force, because that is under
No,
another
before that,
statute.
no, before another statute. What are you saying, Mr. Gupta? That labels him to be an unauthorized document.
If your lordship,
He does not remain an unauthorized document if I pass this order in his favor.
lordship wants, we can delay
No,
for some
I'll
days.
request you to hold the final award.
That can be done.
I'll put that in my order.
Hearing may be called up.
I'll keep it on Wednesday. I'll put that in my order. You cannot pass a final award there. You can proceed with the.
Kindly do not. We will come on Monday. We will file it.
Even if you file on Monday, I won't be able to pass my.
We will try the authority.
No, I'll put in.
Your Honor, I'll just
Putting
read
this
out
in
the
order will
eviction
not create
notice.
some impediments. We will
The
not
eviction
proceed.
proceeding will go on, Mr. Gupta, but no final order on that will be passed.
Your Honor, I'll
My
just
lord,
read
we
out
are
the
requesting the authority to fix it after every.
I don't wait for a request. The learned counsel, heard learned counsel. No. Hearing is concluded. Full stop. The petitioner appearing in person and learned counsel for the respondents are requested to file their written notes of arguments on April 3, 2024, when the matter shall be placed under the heading to be mentioned for the purpose of filing of written notes of arguments and passing further orders. Full stop. Although the respondents may proceed with the pending eviction proceedings against the petitioner, comma, no final order shall be passed in the said proceeding till disposal of the present writ petition.
Hearing for one hour.
Yes.
দুদিন wait করছে, accept.
Item number 2, Electro Steel Casting Limited versus the State of West Bengal.
I appear for the petitioner.
Why?
I am led by Mr. Mojumdar. He is online. He has.
He is appearing in this matter from WBID from the court.
Oh.
Yes, my lord.
Mr. Siddiqui is not here. How can you argue?
No, my lord. I think Mr. Siddiqui, we can save the trouble for Mr. Siddiqui. Perhaps he has nothing to argue in this matter. Very well, my lord. If he is otherwise inconvenience, man, we'll come back on Monday.
You asked for adjournment on the last occasion also, Ms. Adok, or was it some other matter? I'll check up.
Grateful.
Yes, no, petitioner.
So
no. 50-50, yes.
We will come back on Monday. When we come back on Monday.
Adjournment is sought by the respondents. Let the matter stand adjourned till.
Let the matter retain its position.
affidavit of service be kept with the
Yes,
record,
Mr. Mojumdar. By default, it will retain its position.
So grateful to your lordship.
The affidavit of service be kept.
Affidavit of service filed today be kept on record. No, April 1. 1st April.
But may I take your lordship's kind leave, man?
Yes, Mr. Mojumdar. Thank you.
Item number 3, Siddhartha Sen versus State of West Bengal and others.
For the petitioner, my lord, application made under the Information Act.
Yes.
Requesting for certain documents in relation to the registration given under the Apartment Ownership Act. My society registration applied for on a 18th of July, I find, my lord, another society whose registration has been applied for later has a prior registration number. So, my lord, I asked for only information regarding what are the documents submitted by my.
So what was done? Not given?
Nothing.
Refused or sitting tight?
No, my lord, first authority, they gave a reply. Kindly see page 22. The answer is, he is informed that documents sought for in the instance are kept by the apartment branch of this department, but these are not readily available due to incomplete rearrangement of the setup of that branch.
So you preferred a first appeal?
Yes.
What happened there?
So there is nothing, no response. Then finally to the Information Commission.
You informed this on who is for the first authority? You have served on all, Mr. Shen. Just check up.
Milord, I have received the service today morning, Milords. This is my difficulty, Milord. If your lordships.
You are the first authority then?
Yes.
Yes.
14th of July 2022, you said that they have to wait for some time. Rearrangement of the setup of some branch. Rearrangement must be over by now. Mr. Chakraborty, do this. You take you file a written instruction, not written instruction, file a very brief report, take instruction. I'll put it in my order so that it helps you.
Very well.
Mr. Shen, instead of directing affidavits, so that it
I
can be
think
resolved.
that will be better, my lord.
Right.
This is the affidavit of service.
Affidavit of service filed today be kept on record. Full stop. The primary allegation of the petitioner is that despite the petitioner having applied for certain information under the Right to Information Act, the State Public Information Officer delayed the matter, full stop, in its communication dated July 14, 2022, annexed at page 22 of the writ petition, it was intimated to the petitioner by the said authority that the documents sought for are kept by the apartment branch, AB capital, of the said department, but those were not readily available due to incomplete arrangement of the setup of that branch. Full stop. The petitioner was requested to wait till the same was available for supply. Full stop. Being aggrieved, the petitioner has preferred a first appeal which is pending. Full stop. Be that as it may, since
First appeal, the second appeal.
several months have passed after the petitioner was requested to wait by the SPIO, it is expected that the relevant documents must be available by now. Full stop. The who is the SPIO? Which respondent, Mr. Shen?
Respondent number 2. Just one second.
No, 2 is the appellate authority. State Information Officer, 3.
No, 3 is my. 3 is second appellate authority.
As a by 1.
1.
Yes.
Through the State Public Information Officer.
Keep on. By now. শেষ ওয়ার্ডগুলো শুধু আমার বললেই হবে। হ্যাঁ। তারপর কিছু বলিনি। Accordingly, next para. Accordingly, respondent number 1, that is the State Public Information Officer within bracket SPIO, shall file a brief report affirmed on oath indicating the current status of the documents and how soon the information sought by the petitioner can be furnished. Full stop. A prior copy of the said report shall be furnished to the shall be served on the learned advocate for the petitioner before the filing of the same. Full stop. The matter be listed on, I'll give you 2 weeks time. The matter be listed on April 11, 2024 under the same heading for filing of such report and passing further orders. Mr. Chakraborty, please try to impress upon your client if the documents are available by now.
Can be given and nothing much.
It can be resolved.
Yes, can.
And your friend's client will be relieved. 10th.
There is a confusion regarding
yes. তাহলে 11th না করে 10th. April 10th পদে দেবো।
Under the same heading, my lord?
Yes. Under the same heading remains.
Grateful option.
Item number 4, Gaurav Poddar versus UCO Bank and others.
Yes,
My lord, I appear for the bank.
Yes. What is your full name, please?
Samriddha, my lord.
Samriddha, no, that is not
Samriddha Shen.
Yes. Yes, Mr. Bordhan.
My lord, the challenge is to a review committee order for willful defaulters, my lord, at the instance of a personal guarantor.
2.6.
This is a little better, my lord. My lord, kindly takes
Yes.
the show cause notice, which appears.
Once a person acts as a villain in a movie, he's labeled as a villain. That has happened to me. Now I am a willful defaulter and I am also
Fraud.
No, fraud, willful. I am a fraud, I am a willful defaulter, and I am also in a way LOC,
NPA.
LOC authority.
NPA.
Yes.
My lord, kindly takes, my lord, the show cause notice.
Yes.
At page 29.
Hmm.
My lord, I am Gaurav Poddar, whose name appears at page 32.
I've decided there is a reported judgment, unreported judgment of yours. Gaurav Poddar?
No, there's not. That's Dalmia.
No,
That's
Gaurav
Gaurav
Poddar. Anyway, what happened then?
My lord, kindly sees this notice was initially issued to Limtex TN Industries Limited. I am a guarantor. My name figures at page 32, saying a copy of this has been sent to me.
Yes.
Kindly sees, my lord.
Mr. Bordhan, I am growing stricter. I mean, I have been too liberal. You are taking undue advantage. These are.
No, I'll
so
come.
what? You have received a copy.
I'll come.
Yes.
So, my lord, kindly sees what are the allegations, my lord? Diversion and siphoning of funds.
Right.
And, my lord, then, my lord, kindly takes 2.1.3b, diversion and siphoning of funds.
What is that?
My lord, this is page 29.
Yes. Sorry. Got it.
2.1.3b, RBI circular. Then, my lord, explanation, diversion, siphoning of funds. Continues, my lord. Next page. Then, my lord, see, this act shows deliberate, willful, default nature of the promoters, directors, personal guarantors, corporate guarantors, which caused detrimental effects on the health.
Page 30?
Page 31.
Achha, yes.
Then, my lord, kindly takes the next paragraph. Thus, the above acts of the company, its promoter, directors, personal guarantors, and corporate guarantor are in conformity with the RBI guidelines on willful defaulters under clause 2.1.3b, subclause 2.2.1c, D and E. You are advised to reply within 15 days. Now, the first committee passes an order at page 33. So, I have been able to show this is only qua 2.1.3b and 2.2.1. Page 31, 2.1.3 and 2.2.1. While the personal guarantees would come under 2.6. Even in the show cause notice, it's silent on 2.6.
2.6 need not be mentioned. 2.6 is the precondition.
No, 2.6 is the provision on which the bank or the FI can proceed against on the personal guarantor. So today in the show cause notice is 2.1.3b and 2.2.1c D and E. Now, kindly sees the order. Starts at page 33, Milord. The relevant portion would be at page. The operative portion, page 37.
Yes.
Now, the above instance of irregularities confirmed to clause 2.1.3b, subclause 2.2.1c, D, E of
2.6 is
RBI
also
guidelines.
introduced.
Yes. Now, comes 2.6. So, 2.6 is introduced for the very first time in the order. Please, at page 37. But thereafter, I write to them at page 39. So, show cause not on 2.6, order on 2.6, which goes against me. Now, I write to them at page 39. Twofold grounds, Milord. This is my letter dated 21st of September 2022. It may be noted that the bank has filed an application against me for both Limtex and Limtex TN Industries under 95. So I take up the first point of 95, Milord.
You gave a reply in the first place to the show cause.
No.
Why?
Milord, because the first reply,
mentioned as a guarantor, you could have said that
2.6 does apply.
No. You are mentioned as a guarantor. You are given a notice. You could have said that in your reply. 2.6 is not mentioned.
It was not given, Milord. We did not. I can't improve facts, Milord. There was no reply.
My lord, may I indicate one thing? Perhaps my learned senior friend does not have appropriate instructions. They have given a reply to the show cause notice.
Achha.
That, my lord, I am carrying an informal copy with me. If my lord kindly allows me, I'll
So
file an affidavit in opposition.
They have
dealing with-
taken this point of 2.6 not being there.
They have not, my lord. Their reply, they have not. I'm carrying myself a copy dated November 24, 2021. This is in respect of the notice dated 30th of March, 2021. That is the show cause notice.
24. No, huh?
Mr. Bordhan will have to take instruction. Anyway, what are the other points?
Now, my lord, kindly cease. I have taken 95. Then, my lord, I have taken. It is all necessary to highlight that my present net worth is negative.
This is page
39.
39, yes.
This is before the, my lord, the review committee. So I say that my present net worth is negative, as majority of my assets were in the form of equity shares of the stressed limited group of companies, the only assets available to the convertible fund, such and such. So I say I'm not able to pay. I don't have the means to pay. Now, my lord, the review committee orders comes. Kindly see the review committee order, my lord. It starts at page 41.
No, but at present won't do. At the relevant point of time when demand was made, then whether you...
My lord, I'll say this, my lord. Good, bad, indifferent, I've taken two stances. Have those been even considered? Kindly take the review committee order, my lord. My lord, the review committee order starts at page 41. 42 is the observation of the review committee. My lord, sees representations dated 21/9/2022 received on 28/9/2022 from Mrs. Moushumi Banerjee, Mrs. Nitesh Agarwal and Ram Gopal Chatterjee, stating not to declare them willful defaulters as their independent directors. The committee considered the request of Moushumi Banerjee, Nitesh Agarwal and Ram Gopal Chatterjee to exclude them from declaring as willful defaulters as their independent directors in Limtex Tea and Industries Limited. Representation dated 21/9 received from Shankar Poddar for OTS offer such and such for release of his personal guarantee. Representation 21/9 received from Subhash Kumar Poddar for OTS offer for release of his personal guarantee. Representation dated 21/9 received from Gunjan Poddar. Thereafter 21/9 from Gopal Poddar. Turns over, my lord. Representation dated 21/9/2022 received from Mr. Gaurav Poddar for OTS offer of 8 lakhs for release of his personal guarantee. So, Mullah now comes back to this letter, Mullah, at page 39. What did I say? I say I don't have the means, but still, as an OTS, I can pay you 8 and 95. Since Mullah proceedings on section 95 are on, I claimed immunity. My lords have held against me in another matter, Mullah. I'll try to persuade my lord to hold it somewhat different.
Regarding what?
Section 95. Mullah now sees, Mullah. So the representation is being taken note of. Thereafter, my lord sees the entire order thereafter is silent on the consideration of the representation.
How is the representation relevant even?
Well, I have to show that I don't have the means to pay. Once I say that I don't have the means to pay, my lord, it was incumbent on the review committee to say, no, you have the means.
Representations were for settlement.
No, kindly cease. Kindly cease, my lord. I say...
For OTS offer.
No, threefold, my lord, kindly cease. I say, bank has, my lord, kindly cease, my lord. It may be noted the bank has filed application against me, both limited and such, section 95. Next, at this stage, it is necessary to highlight that my present net worth is negative, as majority of my assets were in the form of equity shares of stressed Limtex group of companies. The only assets convertible to fund are investment in mutual such and such 2,09,000, cash in hand of 2,000 and odd, balance in bank account of 68,000. The total fund is 280. However, in view of a long association with your bank and the fact that we have fully cooperated whenever required by assisting proactively in selling collateral securities for partial liquidation of bank dues, I hereby offer an amount of 8 lakhs payable in 3 months as OTS for release of my personal guarantee.
That is neither here nor there.
So, I'm on threefold scores. OTS is something else. But
your present net worth is negative as majority of my assets. This you can say was required to be considered by the review.
Yes.
At best.
Yes. Number one, and also 95,
95?
But kindly, I'll place, Mullah. The entire, my representation has been taken note of, but not considered. Not considered, Mullah. Kindly seize, the order now. Clause 2.1.3b at page 44. Well, this is pursuant to the clause on diversion of funds 2.1.3b. Then, my lord, 2.6, it merely says 2.6 of RBI Master Circular on willful defaulters bearing such and such, which reads such and such. Then order of review committee, willful defaulters, my lord, holds me guilty at page 46, entry number 5. My lord, where is the consideration?
Your name has been uploaded. Uploaded.
No, my lord, I'm instructed it has not yet been.
How soon can you file your opposition? What do you want to?
I will first
Is it
satisfy
necessary?
my lord on the issue of section 95. I have judgments to show for the effect that in as much as the main company has not yet been admitted into CIRP.
No, how soon can you file your opposition? Because you wanted to cite a document also.
Yes, my lord. That document and
So I'll give you how much time? 7 days? 10 days?
10 days if it's so commenced to my lord.
In the meantime, please don't upload.
Great.
I'll not pass an order of stay of this, but
I
don't
undertake, my lord, we will not.
Kindly records that, my lord.
Yes, yes. Learned counsel for the petitioner has made out a prima facie case for hearing of the writ petition on merits, inasmuch as it is contended, inter alia, that clause 2.6 of the RBI Master Circular for declaration of willful defaulter was not cited in the show cause notice, but formed a part of the adjudicatory process for holding the petitioner to be a willful defaulter in the capacity of guarantor. Push up next para, that apart, certain other issues have been raised. Push up learned counsel for the respondent bank contents inter alia that in its objection given to the show cause notice,
Yes, my lord, that's a reply to the.
in its reply given to the show cause notice, the petitioner did not raise the issue of non-mention of clause 2.6 of the Master Circular. Full stop. That apart, certain other factual aspects are sought to be brought on record by the bank. Full stop. Accordingly, the respondents are directed to file their affidavit in opposition within April 10, 2024. Full stop. Reply, if any, shall be filed within April 17, 2024. The matter shall be listed for hearing on April 18, 2024. Full stop. The respondents are restrained from uploading the name of the petitioner as a willful defaulter till May 15, 2024 or until further order, whichever is earlier.
So grateful.
Thank
Grateful. But the issue regards 95, my lord, would require a revisit in view of another judgment of the Supreme Court.
No, absolutely. 95 I'm open, Mr. Bordhan, because there are
OTB,
certain...
OTB, my lord, has held against me. I'll try
No,
to...
not OTB is not sacrosanct.
No,
OTB is not final, conclusive.
I'll try
There are
to
several
improve, my lord.
judgments on...
Otherwise,
Very
to
well.
hold otherwise, my lord.
Both of you will argue on that.
So grateful, my lord.
Thank you. Mr. Bordhan also come prepared on the legal philosophy behind section 95, not only the judgment.
Surely, my lord.
Both of you, applies to both of you. Yes.
Item number 5, Gaylord Commercial Company Limited.
Yes.
Lordship, I appeal for respondent number 1.
May I please?
Yes, please.
My lord, today I am before your lordship challenging, my lord, freezing of my securities. My lord, by the Calcutta Stock Exchange, on the ground that, my lord, the listing fees have not been paid by me. My lord, I say, my lord, that freezing is unlawful because, my lord, firstly, my lord, I had applied for delisting of my shares.
Calcutta Stock Exchange is represented here.
Mr. Rupa Ghosh is appearing for Calcutta Stock Exchange. He is not present in the court today. Your
Why didn't you say that before she started?
Your Lordship, just 5 minutes are left. Let it.
I'll take it up on Monday.
Your Lordship, one thing, if I may indicate, I appear for
Yes,
respondents 1 and 2 for SEBI. Your Lordship, in this matter, if Your Lordship kindly takes up page 49.
49, yes.
Yes, Your Lordship. This is the status of a complaint which was filed with us. If Your Lordship kindly takes up page 50, I'll just read out the complaint details, Your Lordship. I am a director of Gaylord Commercial.
What do you mean to say? Tell me.
Your Lordship, effectively what I'm indicating is that SEBI, they had filed a complaint with SEBI with regards to the allegations present in the writ hearing. We have already given them a reply which is present at page 49, that as it stands, the information that we have gotten from the stock regulator is that they are a listed company. And as such, no intervention from our end is
You are not a
possible.
necessary party.
Your
My
Lordship,
lord,
I think-
absolutely no.
Your
My
Lordship,
lord,
I feel I'm not a
absolutely.
We'll consider that at the time.
My lord, SEBI's job is also to conduct an independent inquiry. What they have done is collected my complaint, forwarded to them. To
Yes, that
Calcutta
is
Stock
probably a
Exchange.
component of the challenge. At this stage, I won't expunge your name. Let us hear you also.
Already.
We'll come back tomorrow.
But may I file the affidavit of service?
Yes, affidavit of service filed today be kept on record and adjournment is sought on behalf of respondent number 3 and is there any 4? Yes, 3 and 4. First up, let the matter stand adjourned for the day.
Very small illages, may I ask?
Yes,
Milord?
Chakravarti.
Item 50 of the appellate side, may I inspect the file, Milord? We want to take out an application.
Yes, yes.
So, in
Any
presence
officer
of your
is-
lordship's officer, may I inspect
Are
the
the
file?
charges reasonable? No, the officers are there.
I think
I'll take a feedback sometime from a cross section of you.
Lord,
Whether
once
there
your
are any
lordship
charges
is
at
on
all.
that side, Milord, my lord should not, Milord, recollect all those.
All the more so I should be involved in that. When I was in that side, then probably everybody doing also says so. But this side I have to be more cautious.
Okay,
Item 50. Item 50.